Right, so we are starting in a few minutes. Right, we are starting in 5, 4, 3, 2, 1, we are live.
Surrounding the Corporate and Neighboring Rights Bill and key considerations in trademark cancellation and opposition. Through these discussions, we aim to enhance our legal strategies and fortify the mechanisms that protect and promote creativity and innovation in an ever-changing world. I extend my heartfelt appreciation to our distinguished speakers. When you look at the list of the speakers we have great minds in this area, in this field, those we have here in the room and those online. We do not take it for granted that you do, gracefully agree and accept to take part in this, in shaping this great discussion. You have graciously made time to share your expertise with us, and we do not take it for granted. For that, we do appreciate. Your commitment to fostering knowledge and guiding professionals' intellectual property is, invaluable, and we are truly privileged and lucky to have you today. The audience is lucky to have great minds like you in the room sharing your expertise and experience. As we embark on this training today, I encourage each and every one of you to engage, ask questions, share your perspective, and let this be an opportunity not only to learn, but to collaborate and strengthen our collective efforts in safeguarding innovation and creativity. I do thank all of you for sparing time to attend this, and I wish you great deliberation and a good day ahead, both for today and tomorrow. Thank you.
Thank you very much, Mr. Vice President. We'll start with our first presenter for today, Mr. Kalunji Tony, the Acting Manager Appeals Litigation at the URA. His topic is on taxation of intellectual property. Mr. Tony Kalunji, take it away.
Thank you, Tracy, for the introductory remarks. Good morning to everyone. So I'm going to request that my slides be okay. So the outline, we are going to look at its taxation in the domestic sphere and then the international sphere, and then we'll conclude. But before we go into that, I'm going to give a brief introduction. Now, we are going to look at the basics, taxation. Now, it is simple as to what is tax, but for this topic, we'll limit our discussion to the strict definition of tax, being that it's a compulsory levy that is non-quid pro quo. So elements such as stamp duty, registration fees, penalties, because in their very nature, they are paid when you expect something in return, let's say registration or renewal of a patent, or they are issued as out after a situation has happened, they will not be covered by this presentation. We'll only focus on income tax and value-added tax. And then the other aspect we'll look at will be when it comes to cross-border taxation and enforcement of intellectual property rights. In tax, we have what we call the revenue rule, or those who did conflict of laws, the rule in Dicey and Morris. So basically, no state can enforce its laws in another state. That's the general principle. It cuts across tax and other spheres of laws. However, if you look at, for instance, intellectual property, to go against this, that's why there are series of agreements that are entered into, such as TRIPS, to enable rights be enforced in other countries. And for tax purposes, we will have what we call double taxation agreements, and we'll also have what probably now we have conventions on mutual assistance and taxation or sharing of information. So let's go to IP also. Now, when you're defining intellectual property from the taxation perspective, there is no definition of intellectual property in the tax regime, both in the domestic and international arena. They just refer to it, but what they do is that they define the income that arises out of it. So basically, if the topic is to be thoroughly discussed of taxation of intellectual property, it will necessitate looking at each and every country that exists, and you look at their specific regimes, and then you come with a proper taxation. There is no one size fits all. So for the domestic taxation of intellectual property, I will limit it to Uganda. And basically in Uganda, if you look at our Income Tax Act specifically, when they were drafting it, they didn't specifically cut out any special taxation regime for intellectual property. Currently, for instance, we have a special taxation regime of the extractives industry, maybe because it's lucrative, but none exists for intellectual property. You have to trace it through taxation of other incomes. And for that, we have three categories of income that are taxed under the Income Tax Act. We will have business income, employment income, and property income. Now, the general rule is that IP will fall in property income. How? Because that is where the definition of royalty is. And they'll say that anyone who has who receives income in form of other things, including royalty, is liable to tax. Now, when you go to the definition of royalty, that's when you find that royalty essentially has two elements. If you receive any payment for use of intellectual property or for transfer or disposal of intellectual property, then you're supposed to pay royalty. However, that definition, if you look at it, it drives your mind deeper. Because whereas all other definitions, most of them in the Income Tax Act, are inclusive, for instance, they will say a company includes, but when it comes to royalty, it appears to be an exhaustive list that lists specific items therein. And if you were to analyze it, that might bring you into other aspects of taxation. To drive this point home, I'm going to request that if we can project the specific provision of the definition of royalty in the Income Tax Act. Yes, if you can slide down up. Yes, and also slide up and we see. So when the Income Tax Act is defining royalty, they state that royalty means, and then they list. But if you go to it to summarize it without being a mouthful, they just get all aspects of intellectual property, and then you can stop there, and then they list them. For instance, the first bracket is the use of, so there is using of intellectual property. In one, they will list patent, design, trademark, copyright, and then they go to the right to use, movie, picture, and so much. And then they go to the use of, they keep listing the specific intellectual properties that they pick from different laws that govern intellectual property. But if you could slide to the next page, the following page, we will find the next page. Yes, there. You will find that the definition of royalty is broader. You can stop there. The definition of royalty is broader, and the definition of intellectual property, as per the income tax, becomes broader because it captures other aspects of business income or items that border on business income. Specifically, V, when they say that the use of or the right to use any tangible, movable property. Now, ideally, there are other aspects of properties that are tangible and movable, but when they are used, they are not limited to intellectual property. So you will have those undertakings there. Now, that will cut across this taxation of business income. Then if you look at Roman numeral V, the imparting of, undertaking to impart any scientific, technical, industrial, or commercial knowledge or information, technically, that will be provision of services. It means that an expert or someone who is carrying out a trade, if ideally, let's say they are at the university and they provide that knowledge, it is ideally intellectual property. Now, in the sense of intellectual property, it covers know-how and know-how. So there are those aspects of intellectual property that cut across, that are hybrid, that when you look at them, on one hand, they will have components of intellectual property, but they can have provision of services, and they can have aspects of even employment. For instance, if you focus on V, assuming the person imparting those scientific or technical knowledge or skills is in aspects of employment. Now, in tax, that specific paragraph will change the entire transaction. You can structure it thinking it's royalty, but if that person is under control of someone who has engaged them, and they're in a concept of employment, it might then twist to become employment income. Then if they are independent and they are not ideally giving anyone the right to the information, and they come to just teach and go, you may argue that it spills over to business income. So the definition of royalty goes deeper, but for Uganda's case, these provisions have not been litigated upon, so we are yet to see people who come across those transactions. But if they are analyzed, we are likely to see intellectual property not ideally being taxed only under property income, but it can have aspects of employment and even business income. I'm requesting we go back to the slides. Yes, so in Uganda, the domestic aspect, when we are taxing intellectual property, the general rule will limit it to property income. However, Uganda taxes intellectual property in two aspects. It uses what we call the residence rule and the source rule. Residents will tax any Ugandan if they get income from Uganda or elsewhere. outside Uganda, we tax that intellectual property. Then there are aspects where we can tax intellectual property where under the arm of source, whereby income is sourced in Uganda. So if we go to, let's say, section 78K that is quoted there, it will state that royalty is sourced in Uganda. One, if the person providing the service, the consideration arising from is a Ugandan. Then two, if the expense received is provided by someone else to an entity in Uganda. And then if you go to 82, they will tax that specific income. And normally the taxation regimes, if you go into the procedures of how this amount is collected, it will be withheld and so much so. So technically under the income tax, if you're looking for intellectual property and you go to royalty, you have how we tax it. Now, if we go to value-added tax, ideally value-added tax does not focus on specific items, but focuses on services and goods. So they will only list, ideally every service, including that one that involves intellectual property, should be taxed unless it is exempt. So what they only exempt regarding royalties is if you supply royalties in respect of agricultural technologies. So if you're involved in research and development in agriculture, you will not pay value-added tax, so it is exempt. In Uganda, we have had a few cases trying to analyze this. So we had put them there. For instance, we have a case of Apollo Hotel, that is Sheraton, where you find that a taxpayer operating a hotel here, but has a system that manages the services of a 5-star or 4-star, and that's the Sheraton IP Central Reservation System, where it was taken to be an imported service because the provider or owner of that service was located outside Uganda and the person receiving it was in Uganda. But that case had a dispute whereby the taxpayer, the Sheraton Apollo Hotel, was of the view that for them they were not importing services, but rather they had imported just a software. Then we'll have cases of allied beverages, whereby, this is Coca-Cola, whereby Coca-Cola gives someone a contract in Uganda to do research and development on how to increase sales in Africa. That person does the research and development. They propose that to increase sales, you need to advertise. And in advertising, they even make adverts. Now, when those adverts are made, they are played in a radio station of Capital FM in Uganda. So URA comes and taxes saying that you have imported services because Coca-Cola Group is in the USA, and it's the one that has given you that particular service to advertise in Uganda. So you realize there's a decision of the Tax Appeals Tribunal agreeing with that approach, but when the matter went to the High Court took a different view and said, no, actually the services were exported because the adverts were intended to be Africa, beyond Uganda. Then you will have the common aspect of Africa broadcasting. This is NBS. Those of you who watch Telemundo, ideally, someone who owns a television would want to show some series or dramas or movies, but the contract they have with people who own that intellectual property is that when they are sending those series or dramas to show, the NBS will import CDs, compact discs. So at the point of customs, URA will only see that compact CDs have been imported. But what is contained on those CDs are the movies that are going to be displayed. So you will find URA saying that, no, what you have imported are services, but you'll find the taxpayer saying that I've imported a good. So the test is a view. There is intellectual property that is in forms. For instance, if someone imports a book, ideally, is it actually the book or what is in there that you tax? So for that, Africa Broadcasting is where it's still ongoing. They have appealed, but ideally it's when the approaches of the tax appeals tribunal and the High Court are that they imported services and the discs were a means of importation. Then you will also get other aspects of something being incidental, and it normally comes up with intellectual property rights. Then also for VAT, there is an international regime. As you know that educational materials, it's not there, but materials that are used when it comes to education are not supposed to pay import duty, ideally, because of the international regime of customs. But now you will find people importing every book and they argue that it is educational. Someone imported books that were plain, that those that we used to write, and they argued that it's also an education material because you use it to write. Another one will import books that are specifically novels, and they argue that there is an education subject called literature where people read novels. So that has been used to make, even if it's a Bible, people argue that for religious purposes, it falls under that exemption. So basically, for the domestic aspects of taxation of intellectual property, you have to look at income tax, focus on royalties. For VAT, there is only an exemption when it comes to if the royalties are for agricultural technologies. Now, let's go to the international taxation of IP. Ideally, intellectual property, as the word itself says, is the converse or the reverse of real property. Because when the world was starting, it was built on brick and mortar. But when it came to intellectual property, it's that those ideas that were put in place, and it was property that you could not ideally touch, and therefore it developed issues. It has, every intellectual property I know of has a cross-border element, because if you look at how it is applied, where it is made, you will find that it's more than one country. So for international tax, we mainly have two models. There is the OECD model and the UN model. These are models that are used to draft double taxation conventions or agreements. Although there are others like the US model, there is the EU, there is ETAF, but it all stems from the OECD and the UN. Now, countries foresaw this, and they normally come in form of agreements to agree who should tax intellectual property in the event the transaction is between the two countries, to avoid double taxation. Because if you have, let's say, intellectual property that is owned by someone in Kenya but used by someone in Uganda, it is possible that the government of Kenya will tax the owner of that intellectual property because they have received the royalties. But it's also possible that the government of Uganda will tax the owner of the intellectual property in Kenya on the same front, that the money that is used to pay the royalties is sourced in Uganda. So to avoid double taxation, countries enter into double taxation conventions to agree who should tax and when. Now, there are a lot of similarities between the OECD and UN model, but when it comes to intellectual property, that is where the difference is. The OECD approach is different from the UN approach. The OECD takes the view that in case of cross-border transactions, it is only the country of residence where the owner of intellectual property is located that should tax. In the scenario that I gave of an owner of intellectual property in Kenya selling it to someone in Uganda, whereas Uganda can claim to tax that amount because the royalties come from Uganda, and whereas also Kenya will want to tax because the owner is resident in Kenya, under the OECD model, it is Kenya that will tax because the owner of that intellectual property is located there. But when it comes to the UN model, they take a different view. They allow also the country of source to tax. However, they limit that amount to what we call a percentage, a threshold. You don't tax beyond, let's say, for instance, a 10%. That will be one difference. The other difference will be the definitions. The OECD model definition is limited to what constitutes royalties if you're to tax them. It is also it lists all the intellectual properties, but the UN model goes far to list other aspects that have come up. For instance, that example I gave in Africa Broadcasting of films, tapes that are used for television broadcasting, under the UN model, payments there under are royalties. Then they have gone ahead to include other aspects of scientific equipment, of, let's say, leases or items that are involved for industries are also taxed as royalties. Now, technically, those are the differences, but they have implications. Since most of the intellectual property is owned, or most of the companies that own the intellectual property that is viable are located in developed countries, the OECD model favors them. So you will find that it's only those developed countries, since they tax on residence, that can tax and get the money. However, the UN model realizes that when intellectual property is located in developed countries and people come to exploit it in developing countries, even the developing countries should get something. And for that, that's why they have, their list is broader. That's why their list allows source countries to tax a portion of that income. Now, ideally, international tax, when it comes to intellectual property, becomes interesting and is a contentious area because of the differences in views, and this is how they come up. Whereas on the international sphere, they define royalties, they do not define intellectual property things they list therein. What does this mean? International tax, if an item is not defined in a treaty, you have a right to resort to domestic law. Now that appears simple, but when you go to domestic law, there is a question of which domestic law must you resort to. Will you resort to the domestic law of the resident state or the domestic law of the source state? Then also, if you're to resort to domestic law, do you look at the definition in the domestic tax law, for instance, in Uganda under the Income Tax Act, or you look at the definition in the domestic intellectual property law, for instance, in Uganda, such as the Copyright and Neighboring Rights or Trademarks Act or Industrial Property? So there's that aspect, and normally some countries have taken different approaches on what to look at. Then the other aspect will be that that definition of royalties, and this comes up when countries try to solve this problem, to avoid countries from using their domestic laws or confusingly using their domestic tax laws or their domestic intellectual property laws. The OECD and UN approach share a concept. They make that list exhaustive. In other words, what is listed under Article 12 of the UN and OECD model is exhaustive. If they have not listed an item there to be royalty or intellectual property, you can't come and claim it's a royalty. And this was in there's a case where it came up in India of Formula One. Basically, there was a Formula One Grand Prix hosted in India. and the Indian government tried to tax that income on two grounds. One, permanent establishment, which is not applicable here, but the other arm was royalty, because they had given the entity in India to make sure it pays for the royalty at $1 and pays the other profits of $40 million. But the Indian court said that whereas it appeared to be royalty in the essence, but artworks licenses were not listed under the equivalent of Article 12 and therefore could not be taxed. So basically the list is exhaustive therein. So basically, how are they taxed? I had discussed this. The UN approach gives only rights, exclusive rights to the state of residence. If the owner of intellectual property resides in your country, then you can tax. Then also the OECD, on the other hand, will create a parallel taxing. But now here is also how international tax becomes a bit complex. Whereas it's generally accepted that the owner of intellectual property determines the taxation under the OECD model, the term ownership, when it comes to royalty, has been subject to contention. Whereas under intellectual property, if you want to know who owns intellectual property, you can require a license. For instance, proof that you own copyright or a trademark, you can have a license or registration. But when it comes to international tax, to determine ownership, they don't base on the license only. The reason they did that is it was realized that entities would set up companies that basically do nothing but owning intellectual property. The common example they use is that approach of Amazon and also Google, whereby you find that there is, let's say, even let me use Apple. There is Apple Inc. in Ireland, and it's a company, and its own role is to own all intellectual property of Apple. It doesn't do anything at all. But the group has other companies that do the production, that do the transporting, that do the research. And when it comes to the most valuable item in Apple, it is intellectual property. So you find that a company that does nothing owns most of the assets in the group. So what countries did, they tried to for international tax purposes, to redefine what it means to own. So for you to own intellectual property, it's not enough international regime for you to come with your license or registration document. No, they will interview you and look at the acronym of DEMPE. They will look at in a group who has developed the intellectual property, who is exploiting it, who is maintaining the intellectual property, who is producing it, and who is exploiting it. And who controls the risk at the end of the day, who performs the functions for you to be able to determine ownership. So because of that, you find that the country of residence shifts in that regard if you go fully. The UN approach is basically, it maintains that approach of ownership when it comes to transfer pricing, but for it will allow a source state to tax subject to a limitation clause. Now, this topic, as I had said from the start, is a bit long, but I listed some areas that merit further discussion and consideration. For instance, you can't talk about taxation of IP without looking at what we call BEPS. Now, the current international tax regime is built in trying to catch up with multinationals that carry out what we call base erosion and profit shifting. In the example I looked at of Apple, you find that entities can set up structures in a way that they pay minimum or no tax at all, whereby they set up entities to be able to incur most of the revenue in those countries that are not taxed, and entities where they are in high regimes of taxation, they don't get to pay. So they carry out base erosion and profit shifting. So the BEPS project issued action points 8 to 10, and they concern when it comes to transfer pricing, what you should look at when you're valuing intellectual property. There's also action point 5 that is not there, but it focuses on what we call patent boxes. They are entities that just exist to own patents, but when they are not exploiting it. And whereas under intellectual property laws, you can lose right to some intellectual properties if you don't exploit them within a given time. In international tax, it also has an equivalent effect whereby they won't give you a benefit of ownership if you don't use it. Then we'll have hybrid mismatches. What looks as royalty can be interest or can be dividends. For instance, whereas we finance companies under debt and equity, it would be simple that if you take money under debt, when you're paying it back, you'll pay interest. Or if it's equity, when you're paying back equity and you declare profits, you pay dividends. However, intellectual property has been used to conflate or gold plate among these. How? You find a transaction where someone is giving someone a right to use intellectual property, having elements of both interest and dividends. For instance, if you've given someone to use a right to use your intellectual property, if at all in addition to that, you require them to give you a right to participate in the company, because the right of participation only comes up if it's equity. That means ideally, that what you call royalty, if it's paid back to you after profits are declared, can be taken to be dividends because your intellectual property gave you a right to participate in a company and make decisions, which is equivalent to equity. Then also, if in paying you back, they have to repay you an addition, it can be looked at as interest, whereby it's as if you give someone a loan, you just give someone to use a license, but where are they paying you at interest or at a specific rate? Then also, there is also hybrid mismatches between services. There are some intellectual properties like know-how or show-how, or let's say experience, even software, whereby it can be looked at as a service, and it determines whether you tax it as business income or you tax it under royalty. It might have an effect in international tax because what is taxed as business can only be taxed international tax if you prove that someone has presence in your country, either physically through a permanent establishment or by having an agent. But if it's royalty, on the other hand, they need not be there because it's only residents that will be taxed under the OECD or under the UN. You can also look at that. Then I had talked about determination of IP ownership. They now no longer look at registration requirements or regimes or licenses. They determine who has developed the intellectual property, who has enhanced it, who maintains it, who protects it, and who exploits it. Then, in fact, in admission, there's what we call hard to value intangibles. It's their very nature. They are only called hard to value intangibles in transfer pricing. You realize they are intangible. What runs through intellectual property is an aspect of uniqueness. For instance, if you look at copyright, ideally, whereas there is no specific regime of uniqueness, but I can't just reproduce someone's paper and I also copyright it. It will be bordering on plagiarism. If you come to trademark, if your mark is not distinctive in a way, it may not fall in either of the classes. Then if you come to, let's say, patents, you realize that unless you're introducing something new or improving a design. So there is an aspect of uniqueness. Now, in international taxation or transfer pricing, the methods that are currently available to arrive at a price of arm's length necessitate you to look at comparables. So it is hard to determine a value of intellectual property if there is nothing you can compare it to, because it's a patent, it's the only one, it's a trademark. Then also, the current trend is taxation of the digital economy. Currently, there is a challenge that states are facing whereby people have stopped doing business in the ideal brick and mortar. And all they do now is to transact online. We are currently, let's say, at Fairway, but you find there is a business of, let's say, Airbnb. Someone is making money without owning the hotel. You have Uber, you don't own the car. You have other aspects, but you realize that all those aspects of the digital economy, how people are able to exploit revenue is through intellectual property. So you find that the bulk of the digital economy is comprised of intellectual property, and states are having a challenge of taxing it because, as we had said from the start, the revenue rule or the rule of Dicey, ideally no state is allowed to impose its own laws in another state. So if Uber or Airbnb they are located outside Uganda, it will be hard for Uganda to tax them, even if you know that the platform exists there. And then also, even in the countries where they are located, like the US, it will be hard to tax them because these entities are not existing. They are conflated, and you find they are owned by a company that is either a shelf or shell company in a specific territory, or you can't even realize or locate them. So the challenges that are faced therein on taxation of the digital economy, all of them come up because of when you look at taxation of the intellectual property. But ideally, the challenge is that the world focused so much on taxing brick and mortar, and it really forgot about intellectual property. And multinationals have capitalized on this, and the result is that when it comes to taxing, even I think the entire international regime should come up with measures to tax. Even here, if you look at it domestically in Uganda, and you look at where most of our revenue is coming from, it's not in intellectual property. Yet if it comes to ownership, you find that most of the top large taxpayers in Uganda have aspects of intellectual property that they either claim as deductions or that are used to reward themselves through royalties, interest, dividends, service fees, management fees, research and development. So much so that you can find a company established and it's operating for 5 years where most of its expenses are research. Let's say COVID came up, you find that whereas a lot of money was made from the health sector, but when it comes to, if you want to tax them, they can viably inform you that they didn't make a lot since most of the money went into research and development. So essentially, that's the taxation of the intellectual property in Uganda. Thank you, President.
Thank you very much, Tony, for that informative and insightful presentation. I'll now open up the floor to any questions in the room or online before we move on to the next session.
Thank you very much, Tony, for a very insightful presentation. I found it fascinating, more so because it's an intriguing area, but also because even from your own conclusion, there's still more questions than answers how to tackle this area. And I don't know if um, this area has been explained in your presentation regarding intangibles of a specific nature, which is trade secrets. So I'm looking at a situation where you have Uhuru and his restaurants and a flood of patrons going to his restaurants because they love his pilau rice. And he has a trade secret behind the recipe. Or maybe if you're looking at the KFCs scattered all over the country, which have the franchise arrangement with, is it Yuku Foods? Are you going to tax that on the basis of a business, the service that is rendered? Is there any way in which you look at the intangible value of the trade secrets that come out of the IP in that business? How do you deal with that? Because on the one part, if you're taxing the business, you may be depriving URA of even much more revenue that it could have earned. But then if you say, okay, let's go for the value in the recipes, what's the standard that you use? From what I see is that there are really different standards that are applied in taxing IP. If it's someone who has his big performance in Lugogo, you go for maybe the get collections after the profit that comes out of having paid all the different service providers, the bouncers and the different service providers. But how is it with the other intangibles in the country? Thank you.
Thank you very much, Tony, for the presentation. I have just two questions, follow-up questions. One is with the limited registration of copyright and the nature in which people continue to utilize their copyright without formal registration, and with what you've explained as the challenge in determining ownership, what measures or what standards are in place for you to be able to tax the intellectual property in the copyright, as opposed to what doctors mentioned about get collections and maybe the music of the person being played on radio. I'm talking about the intangible aspect of the copyright and how you determine, with the challenges of ownership, how do you execute the taxation of the intangible aspect of the copyright? Then the last one is a general question. What is the viability of taxing intellectual property with the low tax base, but then also with the challenge with innovation we have as a country, and at the level we're ranked very low in the standards of innovation. On the innovation radar, we've ranked very low. What is the viability of taxing intellectual property, given the nature of the need to develop R&D and foster innovation and technology transfer? So do we really need to tax intellectual property at this stage of our development?
Thank you. Dr. Anthony, you raise. Okay, so Dr. Anthony, you raise an interesting question of how to tax intangibles. Now, generally, the intangible intellectual property is not taxed because it would be hard to do so. It's not taxed. What is taxed briefly are two elements: the use and transfer. So what is normally taxed is actually, to make it clear, what is taxed is the consideration. So they only tax the consideration to use intellectual property, or if at all there is a transfer. Because ideally, in its very nature, it will be hard for you to come up with a regime to tax. It will be hard, although it's possible, and I think probably liaising with entities that register intellectual property, we could ideally say that we liaise, let's say, with URSB, everyone who has copyright or marks or patents registered therein, we get those registers, we run through them, and then we begin to tax. Now that might need amending or proposing a law to that effect, but currently, as the law stands, what is only taxed is the consideration if you give someone a right to use that intellectual property. That one we can tax because we follow the money. There is money that has moved from A to B, and there would claim. Then also, if you dispose of it, we'll also tax it. So if you go to use, we can easily go to royalties. We can say you have used this, we'll tax. Then if you go to disposal, we can go to other aspects of capital gains, tax, and we look at them if there is a gain. Yes, so that is how it is currently with the current regime. But I think in future developments, they intend to tax it. Because currently, for instance, under the European Union, and even internationally, there is a regime. Internationally, there is what they call the CFC rules, Controlled Foreign Company Rules, whereby it was realized that most of the multinationals were keeping the bulk of their money without being taxed. And normally, intellectual property or royalties grouped with two other items. So it is dividends, interest, and royalties. What entities would do is that they would structure their transactions to stop consideration, to stop the appearance of consideration for use or transfer. How? In simple terms of a loan, an entity would give a loan to another entity and never recover the interest. Or another entity would allow people to come and buy shares in it, but it would never declare dividends. However, in the process of not declaring dividends, they are sending someone management fees who has an office in London and does nothing. They are paying for someone training. They are putting them on the roll and giving them expenses as employees. That's for when it comes to interest. When it comes to also dividends, you're not knowing that was dividends. But when someone who has also given you a loan, you're not paying back the interest, but you've structured your transaction in a way that you would only give them preference when it comes to decisions making. So also when it comes to intellectual property, people were holding onto that aspect of you use someone's mark, but you don't pay back in royalty. But you find, now I'll give an example I'm aware of. Let's say Coca-Cola. So Renzori, there's a company called Coca-Cola. It owns the Renzori brand, and in that group there's Allied Beverages. But you find that the owner of the wells where we dig the water from is Allied Beverages, whose shareholding is similar to that of Coca-Cola or Century. But then this one owns the wells. There's another company whose role is to dig the water. And then there's this other company whose role is to manufacture the water. Then there's a company that owns this mark called Renzori. But you find there is ideally no revenue moving from the company that manufactures the water to the company that owns the mark. However, what you see in their books of account are management fees. So there you can reorganize the transaction and you say, no, if this transaction was between two different independent parties that are not related, you can't give someone and marker not charge royalty. This item of management fees, we are going to reclassify it to be royalties. Or not, we are going to compare yourself with other brands and we regard that. So sometimes mere owning of intellectual property, even if there is no change of consideration, is subject to tax. And the EU has pushed it further. Basically, you have CFC rules whereby if you, a company that has revenue beyond, let's say, 500 million euros, and you're just there, they can require you to just periodically pay a percentage of that revenue. However, in Uganda, we are yet to reach there. And currently, we don't tax the intangibles, we are only taxing the consideration in case there is for the use and then the transfer. Then there was two other questions asked on what standards are in place to tax the intellectual property aspects. The standards, we are still basing on the current laws that we have, and ideally, since we are in a self-assessing system, what normally happens practically is that we allow taxpayers to file their returns, and then we look at them, and then we analyze. So specifically when it comes to intellectual property, they will ask you hard questions and try to see that the way you've structured your transaction makes business sense. So if we see that there are items of royalties, we'll ask you, but Renzori, we have gone to URSB and seen that you don't own this mark. How come for you you're manufacturing water with this mark and you're not, there is no item of any royalty anywhere? So therefore we try to add back or adjust, or if you claim a lot of expenses for intellectual property, as most entities do, we'll try to say that, okay, research is expensive, but you've been researching for this long. What is the problem? And I think previously there was a regime to try to, it passed, but there are entities that were declaring a lot of losses. So you find an entity is declaring a lot of losses, but if you go to their expenses, most of them are comprised of research and development. So they are what would limit the period within which you carry forward that loss. Yeah, so that one is a bit complex, but we use the current laws. Then about the viability of taxing intellectual property, I think world over, and the reason why people have not engaged so much in taxing intellectual property is that if you look at tax beyond other aspects of or benefits of intellectual property, you realize that you might benefit more in not taxing intellectual property. And in asking the question, you put it right, because intellectual property is what helps us develop. For instance, there are regional blocks. Now, like the EU is interesting. In the European Union, they have a directive whereby member states of the European Union are prohibited from taxing intellectual property aspects of use or transfer between entities that are located in the member states. Of course, this can be justified from the way they structured the treaty on the establishment of the EU and functioning of the EU, where they allow freedom of movement when it comes to goods, services, capital, and people. So for you to freely allow movement of services, you may need a state is prohibited to tax aspects of intellectual property if they regard, for instance, people imparting knowledge or scientific knowledge. Regarding movement of goods, the same. If they are movables or intangibles, you shouldn't tax them. So also coming to Uganda, I believe if a country wants to encourage people to develop, it may not impose a strict taxation regime. And that's why you see in the VAT Act, there is at least a clear exemption if someone's research is in the agricultural regime, because you need to develop that. So the viability, on one hand, I don't think it is viable. However, there is the other side of the coin. If you look at it realistically, you find that the entities that own the intellectual property are located on one side of the world. These are mainly in developed countries. So for you as an entity, as a country that is developing, how will you benefit if you do not tax Apple? How will you benefit if you don't tax this mark of Renzori? Because what happens is that these entities come, they establish, they literally make money off you, and you as a state, you don't make anything. So I'm thinking developing countries, it is viable for them to continue to tax intellectual property so long as they have not yet they have not yet established developments of their own. Otherwise, if we are still using goods and services whose IP is owned in developed countries, you're better off trying to tax, because the money they make is a lot. And if you look at the intellectual property value of these entities, you find that it's enough to it's more than the GDPs of most of African countries. So I think developing countries should tax, but those countries that are developed, in my view, shouldn't tax. Those countries that are in regional groups that intend to increase freedom of movement of goods, services, people, capital, you may not need tax. Yes. That's the response.
Thank you very much, Tony. I see that there's a hand up online. Please, let's take one more question from Brian Kajubi, and then we'll move on to the next session.
Thank you, Tracy. Kindly confirm that you can hear me.
Yes, we can.
Tony, thanks a lot for this insightful presentation. I think Dr. Kakoza and Professor Vachivenga in academia, we should reconsider realigning the IP outlines to capture taxation of IP. In law school, I was never exposed to it. I'm finding it very, very, very rich. Tony, I have a question. I don't know whether it would be fair to have it answered, but probably you may offer some guidance. Whereas you've discussed taxation of IP, there is another component of enforcement, which I'm aware you've not discussed, but when it comes to enforcement, there is a role our tax master or regulator, that is URA, plays. Either they do it in passive or they just ignore, but probably you may offer guidance. Unlike those registered IPs like trademarks, where it's obvious, let me stick to trademarks. You have a person who is a manufacturer, is based either in Uganda or even outside, and his IP or their IP are being threatened by over counterfeits, infringement, and any other. Let me stick to counterfeit. So the customs team, they will receive so many counterfeit products, and they will tax them. But these counterfeits are distorting not only the value of my IP, but also any other rights that may be associated for as long as it's business. From the past, ULS and so many IP practitioners have tried to engage URA to come up with a mechanism of probably having a list of recordings of people's certificates, that if Brian is importing, let me say, Renzori, but we're aware that the Renzori is owned by someone else, do you guys at customs or at URA ever ask for proof of title regarding some of these IP products, or the proof of title is pure for as long as I have the necessary international trade documents, the rest URA is not concerned. So we've been having a challenge in enforcement of IP rights, especially in regards to trademarks. At the source, let me call it the source, URA. You will tax fake products or counterfeit. Then here in the market, they are flooded. They are affecting people's IP rights and people's brands. What mechanisms, if any, is URA proposing? The last time they told us that that is purely a prerogative of URSB. URSB is not a taxing master or a revenue collecting entity. So is there a way you can guide business people or even IP practitioners on this call and the venue on how URA can help to combat that issue of counterfeits affecting people's IP value? Thank you.
Thank you, Brian, for the question. Ideally, I should have discussed this, but I had narrowed down my presentation on the definition of tax not to include custom duties, stamp duty, and so much. But still, to answer your question, yes, it's true. Counterfeits come in, URA collects import duty, it allows them to enter. But the role of URA customs, in addition to collecting duties, it includes limiting or granting access to goods and people who enter Uganda or customs control. However, here are the challenges that come up. For instance, that scenario that you've given, it's common, but there is a difference between having exclusive distributorship rights and having a sub-license or having a right to use intellectual property. Normally, the aspect, if someone comes and has a distributorship agreement, if you look at it specifically, it is different from having intellectual property. But either way, the point is still made when it comes to IP. Now, what happens is like this. The current regime is the East African Community Customs Management Act. That's the act that URA Customs bases on to handle importations. Now, in there, the definition of an owner of goods is so broad that it is not limited to someone who owns, who has a title to the IP. For instance, the definition under customs suggests that anyone who is in possession of the goods, even for instance, the driver of that truck that has the goods, or the clearing agent, for that purpose, they are the owner of those specific goods for that purpose. So if someone comes and they tick one of the boxes of being an owner, it will be hard to deny. However, also, if you look at it from this aspect, there is, I think it might need a cross-border element. It might need a cross-border element, and it depends on the country, how it structures its regime. For instance, I'll give an example. Most countries structure their regimes whereby they separate customs from immigration. For instance, in the US, it is ICE. It is immigration and customs control. However, and they have their IRS, the body in charge of revenue. Now, as we take the UK approach of HMRC, whereby you find that at least customs is related. Now, in Uganda, customs is with URA, but immigration is a bit different. There are immigration laws that can try to more capture people entering in with goods that are not fit for purpose, but also URA has a law, but the law has limits. The best that URA can do is that a counterfeit is defined as a good that is uncustomed. So if we get counterfeits by their very nature, we can get them and charge the person with a criminal offense of being in possession of uncustomed goods. However, if you go into aspects of intellectual property, that's where the definition of counterfeits becomes limiting. For instance, and I'll put it to you, will it be a counterfeit if it's only on the mark, or it has to go towards the good itself? So because of that, what we normally do, and when it comes to some goods, some people are required to get specific licenses from other entities before URA allows the goods to enter. For instance, if you deal in food supplements or medicines, would require you to get a document from National Drug Authority to confirm that the medicine that you have is fit for purpose. If you're bringing in, let's say, beverages or things that can be consumed, we can require you to get what we call, there's a certificate that UBOS, Uganda Bureau of Standards, gives. So if they give you that certificate, then it's okay. But what most entities do, they come at the point of importation and they have those documents. There's a certificate of origin coming in from another region, another country. Says goods are from there. Because ideally, no country should allow goods to exit its country if those goods are in breach of, let's say, intellectual property. But if they have left another country and there's a certificate of origin, and they come here and it's medicine, and you realize that NDA has confirmed that it's medicine, or Uganda Bureau of Statistics has confirmed that they are fit for purpose, it is hard for URA, unless it is URA receives a complaint, because what most taxpayers do is that if they notice on their own that someone has managed to breach these gaps, they can at least lodge a complaint with us, and in that process, normally, if there is evidence that it's a counterfeit, we can hold the owner of the goods to have uncustomed goods. But there are other aspects of intellectual property infringement, as you might know, that are a bit more complex, and URA does not have the powers to determine such a dispute. For instance, you might need, the powers are normally reserved for courts of law, for you to determine that someone is passing off or that they have infringed on a trademark. I'm thinking URSB or courts of law are best suited compared to Tony Kalunji to sit at the border and be like, this Renzori is a bit similar to Rebori. I may not have that mandate. So it's about a collaborative effort, and maybe in future we can propose to see that. I know they established a one-stop center at the border where all these entities sit together from either Kenya or Uganda or Tanzania or Kenya. We sit together, but still it has to involve a play, because normally, and when we receive those requests of URA, please stop these goods from exiting or being released, normally what URA requests for is a court order. Because in the past, there is experience that when we tried to involve ourselves into disputes and try to stop goods from entering on ideas that they are counterfeits, people successfully argued that we didn't follow due process, that the powers to determine whether or not it's a counterfeit are not ideally given to URA, unless we get supporting documents or proof. There are scenarios where we totally know. For instance, there are taxpayers who who, because of their goodwill, are more pronounced than others, that we can clearly tell that this is not, whereas it's Abibas, there is a proper Adidas. And then for that, we are able to stop the aspects of that. But it's broader. For instance, I also know taxpayers, and this is an approach that other countries have gotten, like India. Normally, German can complain that most of its medicine exists in India. And there is that approach. Taxpayers have come here and they have obtained licenses from Uganda Investment Authority. They have set up industries here. They are even registered with URSB and so much. But you realize that what they are manufacturing is ideally something that borders on infringement of intellectual property. But as a country, you may need to either develop or support this. And that's why if you go into the more complex regimes, normally when they are imposing standards, normally they give a sunset clause or they allow developing countries not to be strictly punished. But it's a conflated response, but in simple terms, URA does not have the four corners of the mandate. We can only find an offense, but if there is corroborated effort and there is a court order where it has been decided that this is an infringement, then ideally URA should be able to enforce. So I would advise from a practical practitioner's perspective, if your client gives you instructions that the property has been, let's say, infringed, you're better off getting a court order and serving it on URA to comply with than you seeking it to, requiring it to delve into the dispute and try to navigate, because even the other person will try to claim that it's not intellectual property. There are those who come and even import. I noticed the dispute of Coca-Cola. No, it was Colgate, where someone had a distributorship agreement to bring it either in East Africa or Uganda, but someone went abroad, went on a plane, got it from another distributor of another region, and they had their documentation and brought it. And then they came and argued that, are you saying I can't go to Singapore and buy Colgate and bring it in Uganda? Because people come at the airport. And they are saying, are you sure there is a limit on the volume? So it's a discussion that is evolving, but a court order can help protect your client in that regard. Thanks you, Brian. I hope I've tried to answer. Okay.
Thank you very much, Tony. I'm sure we've all learned something from him. You've really been comprehensive in responding to those questions, and we thank you for that. We'll now move on to the next session, which is a panel discussion on tax implications in intellectual property value addition. It really follows from Tony's presentation, and we'll just contextualize what he has covered. This is important because as Uganda continues to position itself as a hub for innovation and creativity, the interplay between intellectual property and tax law is increasingly critical. So our discussion aims to tackle tax implications associated with value addition, focusing on how the tax regime addresses the commercialization, valuation, and cross-border aspects of exploitation of intellectual property assets. This session will draw on the expertise of market leaders, and I believe the insights shared here will be invaluable for navigating the evolving landscape of intellectual property. So allow me to introduce our distinguished panelists. First, we have Professor David Justin Bachibinga. Professor Bachibinga is an advocate of the High Court of Uganda and a professor of commercial law at Makerere University since 1998. He is a fellow of the Uganda National Academy of Sciences, African Academy of Sciences, and the World Academy of Sciences, respectively, and a former visiting professor of law at the Uganda Christian University. He has taught law of contract, equity and trusts, revenue law and taxation, and intellectual property law at Makerere University, and is the author of numerous books and scholarly articles, including Law of Contract in Uganda, Equity and Trusts, Revenue Law in Uganda, Intellectual Property Law in East Africa, among others. Professor Bachivinga's deep understanding of both the academic and practical aspects of tax and IP law will greatly enrich our discussion. Next, I am pleased to invite Mr. Edward Balawa, a partner at Max Advocates and a seasoned corporate and tax lawyer with over 14 years' experience. Edward specializes in tax advisory and controversy services with a focus on both direct and indirect taxation, international taxation, and transfer pricing. Edward offers a wide range of tax solutions to a diverse clientele, including multinational enterprises, micro, small, and medium enterprises, government entities, and individual taxpayers. His expertise encompasses direct and indirect tax services, including business and transactional tax advisory, international tax and transfer pricing, dispute resolution, and litigation. Edward holds an LLM in international tax from King's College London, an advanced diploma in international taxation from the Chartered Institute of Taxation, a chartered governance qualifying program from the Chartered Governance Institute in the UK and Ireland, a postgraduate diploma in tax and revenue administration from the East African School of Taxation. His extensive experience in advising multinationals and government entities will enable him to perfectly address these complex tax issues surrounding IP value addition in Uganda. So we are going to cover a few themes, and each panelist will be sharing their perspectives before we can open the floor to questions and comments from the audience. We will also call on Tony Kalunji to supplement on some of the questions that we have here. So to start us off, Professor, could you start us off by explaining how Uganda's tax laws recognize and address value addition in the context of intellectual property assets?
Thank you, Madam Chair, and thank you for the flowery introduction. Now, perhaps we can start from the basics, meaning one may ask, what is value addition in the context of IP? Value addition normally manifests itself, and I'm going to give examples of the different IPs or intellectual property, but it manifests itself from, first of all, there's the creator of the IP. Of course, when it comes to patents, this is known as the inventor. Then when it comes to, for instance, copyright, it may be somebody who has written a piece of work. And then when that happens, in order for you to realize value, or what sometimes they call commercialization. In Makerere, we have a unit which looks at inventions and then reaches out to people to try and commercialize, these inventions. Now, in terms of, for instance, the patent the invention can be modified. And when it is modified, whoever has modified it, if he satisfies the requirements under the Intellectual Property Act, that person may be able also to obtain a patent for it after they've modified it. Alternatively, the Intellectual Property Act, I think these are sections 67 to 69, recognize the fact that a patent can be utilized, let's say an invention can be utilized in the form of a utility model. You know, you can modify the invention in such a way that you utilize it. I regard that also as a form of value addition, ensuring that what has been invented can be, let's say, modified in such a way that it can be used. Of course, the rights of utility, those who are entitled to utility models are different from the patent holder. So that is one aspect of a value addition, if you like. Then when it comes to, for instance, copyright, many of you know there are people who they either write books or articles, and the value addition, you know, can come in when these works, either artistic or scholarly, are either converted into either music or plays. That means you have people who are able to convert them into what are called derivative rights, or the Copyright and Neighboring Rights Act talks of neighboring rights. If you look at sections 20 to 21, 26 to 27, you'll find that it is possible to convert artistic or scholarly works into maybe musical works or videos, plays. And then when that happens, there is another group of people who acquire rights. You've heard of the rights of, for instance, the performer, the one who performs either the musical work or the play. And then you have the rights of a director. That one also acquires rights. And then the rights of a producer. Those will also acquire rights. And of course, when they are paid in respect of those rights, under the law, as Mr. Kalunja has put it, Section 2, which defines royalty, in a way they are receiving royalties which are subject to tax. It has been explained that royalty is regarded as a form of property under Section 20 of the Intellectual Property Act. So you can see the value addition affects not only the originator of the IP, but it will move on to other people who have tried to modify either the work or the invention, and then they acquire rights for which they are paid, and such payment under Section 2 is regarded as a royalty, which is subject to, of course, tax. Of course, taxation, you know, can also, the value addition, you know, can move on to what we call, I don't know whether I'm moving into the other area, I can move into what is called, you know, licensing. And this occurs where the inventor, or maybe the originator of the work, doesn't have the capacity to exploit that work, and therefore they opt either to license their either patent or their copyrighted work to another person, or they transfer it to another person, or even assign it to another person. That again is giving it some sort of value addition, in the sense that one doesn't have the capacity to exploit what they have produced. Again, in Makerere, we have, I think this is the Directorate of Research and Graduate Training has a unit which tries to commercialize the inventions. And that can be done again through the form of licensing, outright transfer and, of course, assignment. I don't know whether I have handled it adequately. It is important, of course, for taxation purposes, that there should be value addition in regard to intellectual property, in the sense that if you simply invent something and then you keep it in your home, you are not able to exploit it. Of course, there will be no value addition. And you cannot talk of, for instance, royalties as envisaged in Section 2 of the in the Income Tax Act, which, as Mr. Kalonji has put it, the definition of royalty is broad and exclusive. It actually itemizes payments for these activities related to intellectual property. So it is important that value addition is initiated to be able to exploit the IP. Maybe let me stop here for the time being.
Thank you, Professor. You've given us a detailed background on the different forms of intellectual property and value addition in those contexts and how they are taxed. So we'll move on to Mr. Balaba. From a practical standpoint, how does Uganda's tax regime address income derived from the active commercialization and exploitation of IP, whether through licensing, assignments, franchising, or further development?
Thank you, and thank you for having us. So we typically have to deal with the question of, and it's good you outrightly raise it as income. We have to deal with the question of whether or not income has arisen, because only then would you get worried about income tax or corporation tax. So the commercialization is such that you must have generated some kind of payment. And the presentation has ably discussed the bit about royalties and how that happens. But you will have typically two sets of transactions relating to IP that then lead to commercialization. So it's either the IP itself, in which case you have transactions involving the IP assets, which Professor has just ably discussed, in terms of have you had to license, have you had to assign, was it an outright sale, is it a band of rights that have moved, say franchise, is it that there are services that have been related to a transfer of, you have an actual IP asset moving. And that's the easier one to deal with, because then effectively, it's about taxing the income arising from the IP. Now, the other set of transactions, which becomes a lot more controversial, is transactions that are about the use of IP, but in connection to provision of goods or services. The debate now world over is whether or not everything has just not become digitalized. Literally anything, whether it's transportation, whether it's sale of anything, it's driven by IP. And the question is, what is the value of that IP? So you might be getting payment for goods, but then what's the contribution of IP to those goods? It might be an iPhone, yes, but of the amount you're paying for the iPhone, what contribution goes to all, so many of these other different IP assets that could be involved, the design, the name, it gets complicated if you have different parties owning all those different things. Then the question becomes, who is entitled to how much of that price? So the first set of transactions has been ably discussed, so you potentially have royalties. Royalties will arise, and if they arise, then they're either property income, typically, and then you have a way to tax it. So whether you're an individual, you pay your tax on individual rates. If you're a company, you pay your taxes as well. I think the other thing to add is if you're using the IP in your business, our tax regime has also been generous enough to allow you what we call an amortization. So if you have IP that you're using to produce business, then just the same way you have other assets getting a depreciation allowance, you are allowed an amortization for your IP. So let's assume it's a copyrighted software that you have, and its useful life is, say, 1 year or 2 years, depending on the license. So the law will allow you what we call a tax deduction, for that value. It's spread across the useful life of that IP. Now, in practice, the controversy has been, there's a lot of IP for which you can't define ascertainable useful life, in which case then you will not get the benefit of the amortization cost. But to the extent that you can, you actually get that benefit. So that's one set of transactions, and they are pretty straightforward. The complex ones are the ones where you have IP, and the transaction is such that the main face of the transaction are actually goods and services. But the driver, the value driver in that transaction is actually an underlying IP. It's either embedded in, imagine goods you're buying, but part of the goods you're buying that have a trademark. So essentially, part of what you're paying for those goods is the value of that trademark, in a way. In some cases, you will find that price isolated. So we have so many importers here that import largely trademarked goods, and they'll have to be paying a royalty as well on top of the price. Now, that's very easy to distinguish, because then the royalty component is this. But in other cases, it's not. So you have an aggregate fee or an aggregate price, either for the goods or for the service, and then you can't exactly tell which compensation relates to the IP, which compensation relates to the goods. Now, because that's where the problem has been, the entire world now has been grappling with how then do you tax that contribution, that IP contribution to either a supply of goods or a provision of service. We have online marketplaces now. So you have online advertising services. So essentially what for you you're getting is that you're advertising, that's a service, but this service is essentially powered by IT. Or you have an online marketplace, you have an accommodation platform, Airbnb, or you have a car hauling service, Uber or something, or you have, so many of these, even just a search engine for that matter. So what the laws have done is to take a step forward now and introduce taxes on those things as well. So I'll not belabor the taxes that have already been explained, but I'll only add, that other dimension, that you now have taxes that are intended to cover that second segment of transactions. So in 2023, a tax was introduced called a digital service tax. Now that digital service tax is supposed to cover whatever has been defined as a digital service, and many of these, cloud computing, online advertising, online marketplaces and platforms, search engines, data services. So what you're getting is a service, but because it's powered by the IT, there is something being paid for it. And this payment can take different names. So someone can say it's a commission, someone can say it's a service fee, but essentially it's a payment because you provided your platform in order to be able to provide the service. So we have a tax now called a digital service tax. And that tax applies to, as you would imagine, the biggest providers here are non-residents. So they are not resident here. So you have all these, anything and everything that you typically can think about, Amazon, Google, all these people that are providing whatever service. So the tax has been introduced, it's at a 5%. So the expectation is that those companies who are using their IP, in that sense, those platforms, in order to facilitate those services, either of goods or services, could even be across goods or services, should be able to now pay a tax called a digital service tax, and that tax is 5%. They should be able to account for the tax themselves. Of course, it's easier said than done. A lot of complications in terms of how do you get them to pay, and how do you get them to comply. But we have a law in our books now, effective July 2023, that they should be able to file returns, they should be able to account for taxes. Because what they are providing has been essentially defined as a digital service. So that is one development to clearly watch, and it's again back to the fact that it's a transaction where you're trying to exploit IP, but it's not a transaction directly related to IP. It's because the IP is just being used to power the provision of goods or services. Okay. Thank you.
Thank you for that comprehensive response in respect to income tax. Are there any other taxes beyond income tax that businesses should be aware of when commercializing their IP assets?
Thank you. So what has been done on the income tax side has also been done on the value-added tax side. So what we see is that when you have on the VAT side, they are not called digital services. They are called electronic services. But most of them are similar. You still have the same platforms. You still have the same, whether it's Netflix or Google or, whatever those platforms are, for as long as they are non-resident. So what VAT has done is to classify those people as having their place of supplying in Uganda, even when they're doing that remotely. So you have this service being provided to you remotely. You don't have the owner or the player, the owner of that platform or that IP here, whatever app it is, or you don't have them here. But what they have said is that to the extent that you're dealing with a business to customer arrangement, a B2C arrangement, then the rules have indicated that you will be deemed to have supplied the services in Uganda for VAT purposes. The full implication for that is that you must account for VAT in Uganda. So again, these have been elusive. So until that law, it was, there was no obligation. They are not here, they are out of reach. So again, you see government desperately trying to get into that space and taxing those, they're called electronic services for VAT. So again, those people are expected to file VAT returns on a quarterly basis, which is on a 3 months basis. They're expected to account for VAT. So I don't know if you've tried to log into some of those platforms lately. They are keen on asking from which country and details like those, because they know that there could be a value-added tax that they could account for. A number of them have complied. So the options are they either register themselves or they register a VAT representative to help them account for the taxes. But it's similar to, not exactly the same, because here you're accounting for 18% VAT, but the services are more or less similar. They are IP powered, they are services, and they're getting payment for it, because either way, they're either charging you a commission or a service fee or some kind of payment. Because of that, they have enabled you to do it. So because of the platform, they charge you something for it. So there is VAT to think about. And then the other one is customs. Again, and this is very important, because the way we know it, there's usually a mix, and I'm still talking about the transaction where you have a mix of both IP and either goods or services. So what for VAT purposes, because the question becomes, for VAT, IP is a service, but what if that IP is directly related to a good? The rule in VAT is that whatever is more dominant will give the character to the transaction. So if the service is only incidental to the goods, then they will be considered as goods. If it's the goods that are incidental to the service, then they'll be. So IP finds itself in this all the time, because a lot of the people that have to get intellectual property are either bringing it in relation to, some goods or some services that they are having to sell. So that's how it's solved. But for customs, similar rules exist. And this has been litigated. So there is a butter shoe company case, I think, that has been decided by the High Court as well. So what happens is, if you import goods, but you also pay royalties, okay? And there are two conditions. If the royalties you pay are related to the goods, so in this case, you have butter shoe company, they import shoes. The shoes have an embedded trademark butter, but then you have to pay royalty to butter brands, even as you pay the price for the shoes to someone else who is manufacturing the shoes. So the conditions are two. One, if you pay a royalty, and that royalty is related to the goods. Two, if the payment of the royalty is a condition for you to be sold the goods, then those royalties will be considered as part of the customs value. So again, a lot of the net importers have this problem all the time, that whatever you paid as royalties is now considered as part of your imported price of those goods. So if you didn't declare it as part of your imported goods, then there is going to be an uplift of your customs values. So for example, if you declared $100, and then it turns out you also paid a royalty of $20, then on the side of customs, what they want to see, if those two conditions are met, what they want to see as the customs value for the goods is not 100, it's 120. Because the royalty is directly related to the goods, and the payment of the royalty is a condition for you to have been sold the goods. So again, that's another thing to be careful about, because it's a very common problem during what are called post-clearance audits by URA. Every time they find a royalty, they are keen to know, is it related to the same goods? So a lot of our people that deal in trademarked, goods and all find that as a routine tax issue that they have to deal with. Thank you.
Thank you very much, Edward, for highlighting the taxes that are attached to value addition. We'll move on to another important theme, which is valuation of intellectual property assets for tax purposes. So sticking with you, Edward, what are the main challenges faced in valuing intellectual property for tax purposes within Uganda, and how can this be addressed in practice?
The challenges are many, and it's because of the nature of intellectual property. One, it's unique. We've already been told that. So then where are you going to find, if URA is disputing my price, then it's very hard for them to find a comparable, to say it ought to have been this. So it's very, very challenging to arrive at actual values. Of course, the easiest thing is if someone who is dealing in that intellectual property, possibly sells it to independent persons. Because the assumption is the price at which they are selling it is, a price determined by market forces of demand and supply, because they are dealing. But the bulk of IP is possibly, either internally used or owned as an asset, and then maybe not necessarily in the business of having to sell it. So it becomes very hard, and it's not a Uganda problem, it's a global problem, to value intellectual property. It can be very unique, so it's hard to find comparables. to try and ascertain the value. And then there's a way it tends to camouflage, because then at its initial stages, you may not know the value of that IP. It can literally explode depending on different times. So you will find people, for example, selling an IP that is in an intermediate stage, what Professor was just discussing earlier on in terms of value addition. And then it goes on to be improved, or even without anything else, it just goes on, to explode in terms of value. So there are problems that have been addressed as uncertain values, extremely uncertain values for IP, depending on its stage. And then you obviously have the hard to value intellectual property. Hard to value because you can't find it, and someone owns it alone. You can't find it, with anyone else. So it remains a problem. Of course, the owner may put a price to it, but it's also difficult, because the normal way to try and generate prices is you try and look at what did it cost you to bring into being. But then that for IP becomes a problem, because you might have spent too much and maybe the value is not that much. It either becomes obsolete as soon as you have it. So it can't be the cost. It might also be a small cost, which ultimately then becomes a game changer, in terms of value, or in terms of what value it carries. So it's a very big problem that there are even international guidelines now on hard to value intangibles and how to try and arrive at a value. But there is no certain answer. So for example, what has been proposed is that you can try to use financial valuation techniques. So again, the guys in finance and the accountants have a way to value things. They can use some discounted, kind of cash flow methods, or they can discount expected future outcomes. But so that is what people are left with. So you go to a valuer, and then the valuer comes up with. Now the challenge with that is that it heavily relies on so many assumptions. Now you're not so sure, the Revenue Authority is not going to say, but these are assumptions. So I think the straight answer is that it's very difficult, and it remains a challenge, though there is effort to try and find a price, because you want to try and find a price. The easier thing, the rule of thumb in trying to find a price is you just look for independent persons and you find out what are those independent persons pricing that thing at. The challenge with IP is that you're unlikely to find the same thing. Okay? So you have it and it's yours, it's unique. So you can't find independent persons dealing in exactly the same thing that you're dealing in. Yeah, so it's hard to value, and remains a challenge. Thank you.
Thank you, Edward. I'll just rope in Tony here. Do you have any additional perspectives on valuation of intellectual property assets from the taxman's perspective?
Yes, thanks for that. A lot of it, and I agree with Edward, with the starting point is comparables between transactions. On one hand, the entity we are looking at and the independent entities, and then the entities in the group. We see that it tries to match up. And then we also indeed use accounting or valuation methods. There are Berry ratios of this world where you look at someone's profit, and since normally they put everything in expense, we are like, no, if we get your profit margin and expenses and divide them, we can come up with what is called a Berry ratio and try to use it across. But what we tax administrators do, most of the IP is with multinational entities, and they are required to file transfer pricing documentations every year, or to have some existing. So when these are filed, tax entities have entered into conventions to share information. There's automatic exchange of information, and so much so. Now, in the process of automatic sharing of information, If there is any variance between what you have declared in one state with another, we can be able to catch up and know. Then there are what we call databases. When we get, in quotes, one taxpayer, or a taxpayer is or files proper information or is audited in one entity, there are what we call transfer pricing databases, whereby if you subscribe, although they are expensive, and while doing an audit, you're able to go there and try to search and come up with a value of the specific items you're looking at. So there are service providers who have taken it among themselves to study these specific sectors and come up with specific. Now the values are not specific because IP is unique, but they come up with margins to be like, oh, if you want to value a trademark regarding water, at least if it is in this country, it should have a range of this and this. So we get those ranges. If it's beer, this, or if it is a sector in banking, you're looking at software, or if it's fleet management. So there are systems that we subscribe to, though they are expensive, though they are not conclusive, and we try to use those as in determining the ranges to use. But still, I agree, it is hard to tax, and we're working on that.
Thank you, Tony. You've brought up the aspect of transfer pricing, which takes us to the next theme on cross-border considerations. I'll go back to you, Edward. How does transfer pricing affect the taxation of IP transactions involving multinational corporations operating in Uganda?
Thank you. So essentially, transfer pricing is you have countries. So you have any transaction. It could be goods, could be services, could be loans, could be intangibles that we are talking about here, and then you have several countries involved. And for some reason, you then have the challenge of which country should have which amount of returns from that particular transaction. So that's what you have. You literally have countries trying to say, this is what you ought to report here, or this is what you ought to report here. And it can be very contentious. So you have countries trying to do adjustments. So you indicate that my revenue from this country is this much, and then they say, no, your revenue should be this. Now, why should that be a problem? It's a problem because the transaction happened between people who are related. And because you're related, that means you either share the same shareholder, or you're both commonly owned, or one of you has a substantial shareholding in the other. There is a natural tendency or the temptation. You can afford to manipulate pricing, because ultimately you are the same people. So that's usually the danger, and because of that, you then have revenue authorities being very worried about whether or not you're reporting the right prices or the right amounts. So that's what transfer pricing is essentially about. Now, for IP assets, the problems for this transfer pricing, we've already hinted about problems with valuation and all. It's hard. But what used to happen, or what happens essentially, is that you have this in big multinational groups. A group can have its own captive bank, it can have its own captive insurance company, it can have its own single company that runs all the IP, it can have one company that does management services. So a group can have, for business reasons really, different companies doing different things. But some of course then look to tax reasons. So just assume a scenario where in the group, the holder or owner of the IP is one person. That person is possibly resident somewhere in Ireland or Luxembourg or Netherlands, either paying no taxes or paying, very small taxes. And then we've already said here that IP is a huge driver of, profits or value. And everyone knows that. So you then have this company that is doing substantially nothing, but in terms of how you're dividing your profits, you're saying the bulk of these profits should be reported there, because that's where the IP is coming from. I mean, you're talking about an Apple, phone or whatever it is, and it's not hard to convince anybody that you should apportion a substantial price of this amount to the IP as the driver of that price. Because there are many other people making similar phones, possibly similar functions, but not with the same price. Now, what that used to do is that if you're only going to look at the fact that I'm owning, and therefore if I'm owning, I should essentially drive, or I should get all the returns that relate to IP. I mean, it's a mismatch. It was a problem, a huge problem for everybody. And a lot of the international, the multinational, the e-commerce companies and all, I mean, followed exactly the same model. All of them without exception. All of them, whether it's Starbucks or whatever, in whichever sector, all of them same model. They have a company that is holding IP in a very tax-friendly country. And then, of course, they are portioning, whatever value relates to IP in that country. So what the world has done now at an international level, and many countries are doing this now, is that they're saying you should not get a return on IP purely because you own it. The question is, what have you contributed to it? Because yes, we agree it's of value, but then everyone who has contributed to it should share in the return. So other than have one owner somewhere taking the entire return, it should actually be apportioned to all the different contributors. So that's how they come up with that interesting acronym called DEMPI. So DEMPI means whoever developed, so development, enhancement, maintenance, protection, and then exploitation. So whoever participated, whoever has a DEMPI function to the IP is entitled to a return. Okay? And there have been very interesting cases, I think Coca-Cola cases in the US, where even companies, Coca-Cola companies that were only having to sell, as in sellers, distributors, I mean, were actually seen as people who are enhancing. Because you see, they are having to, they are exclusive in this market, they are the ones driving your IP in this market, so they should have a contribution. They have a contribution, so therefore they should have a return. So that's the debate now, and that's what is happening. So other than just being an owner, you must have DEMPI function, contribution. You must have, we all know that you're only entitled to a return if you incur a risk. You must have a DEMPI risk. So what risk are you carrying, in regards to that IP? If you carry a risk-free, even if you're the one who has financed it, you only get a risk-free return. A risk-free return is usually small because you've not incurred any risk. And risk is what explains why you should enjoy a substantial portion. So you must have contributed to a DEMPI function or incurred a DEMPI risk or some kind of DEMPI asset that you've had to contribute to the IP. To the extent that you have not, or to the extent that you have, that's how much of the IP returns that should go to that specific country. So that's how it's being dealt with now. And increasingly, of course, then multinationals have to think again. So other than have one company that has, one employee somewhere in Ireland without anything else, but all it does is hold all the IP that you have across the world, and then in return it gets all the returns attributable to the IP being reported there and not elsewhere. I think that's a thing of the past now. So those are the latest trends that we are seeing. Of course, the other one in respect of IP is also what is IP? You know, so the global consensus now is that they have discarded, or they are discarding, both legal and accounting meanings. Because you see, IP is, I mean, intangible. It's not things that are protected or registered. There are a lot of other things that attract or drive a lot of value, but you will not find them anywhere registered or anywhere protected by anyone. So those are the recent developments you are seeing. So you have IP meaning now being broadened to say, for as long as it is something that independent persons would pay for, and it is not a physical asset, and it's not a financial asset, then it's an intangible. Essentially, it's IP. So it doesn't have to be registered. So we are out of our traditional, what is the legal meaning? The accountants, of course, have been more liberal, because then for them, they take the economic substance of things. So the accounting meaning is, much broader than what you would have a legal meaning. But the international tax consensus now is that you shouldn't have a legal meaning or an accounting meaning. So it's on a case-by-case basis. If we find out that you have this trade secret, or, for which, it's of very high value in your business, or you have this intangible, not registered anywhere, not seen with anyone else, it's unique to you, then it is IP. And therefore, all the other full tax implications will fall on. Thank you.
Thank you very much, Edward. Now that we've looked at the taxation bit, we've looked at valuation, cross-border considerations, we'd like to now look at practical considerations. So, Professor Bachivinga, what practical advice would you give to Ugandan entities looking to protect and monetize their IP while ensuring tax compliance, particularly when resources are limited?
Thank you, Madam Chair. I think practically here in Uganda, perhaps one needs to focus on what are called SMEs, small and medium enterprises. What normally comes out has related actually to musicians and entertainers. And I think it is important to get these musicians and entertainers to maybe register either their artistic work to enable them to earn royalties. And from a revenue collection angle, such people, of course, can be tracked. I think many of you have heard of the Taxpayer Registration Expansion Program, TREP, where the URSB, the URA, and of course local authorities are involved. So because of that connection between those entities, if a musician or entertainer, has registered their work with the URSB, this information, of course, can be shared with the URA, and there's then a process of assessing, any tax which may be payable. The main problem, of course, has been that many of the musicians they are ripped off, that they are exploited. You've heard of cases of people's music being played on radios, and they of course, they are not paid. But of course, if you have this backing up of the registration, you will be able, of course, to enforce payment from the various media and other radios. And then apart from that, URA will be able to identify whether there is any income or payments which will be liable to tax. Well, I mean, we've already said that such payments are covered under Section 2 of the Income Tax Act. You know, the definition of royalty would cover all these. The reason why the local authorities are normally involved is that they give out licenses. So that is again another way of providing information on activities, which I'm sure URA would be interested in. Then I think in passing, of course, there was a mention of even the use of these trademarks. Some of the trademarks are linked to the goodwill under the Trademarks Act. I think it is sections 31 to 33. This is again another area which can be monitored and ensure that those who are involved, either they register their interests, and after registration, one can again monitor, how these trademarks are exploited. I think let me stop there for the time being. Yes.
Thank you very much, Professor. I think we'll move on to the next theme. With the rapid pace at which technology is advancing, I think it would be important for us to look at taxation of value addition in that aspect. So, Mr. Balaba, I know you've hinted on this already in your previous discussion, but are there any specific emerging trends or future developments relating to taxation of IP that legal practitioners should be aware of?
Sorry. So sorry, I was saying there is the trend of having to tax or to increase taxation in this area, even when globally the trend is to actually not tax. Because again, we are talking about innovation. You're talking about research and development. I mean, you're talking about having to, this is the very bedrock of your development as a country. You want people to invest, so the sensible thing would be that you actually have tax enabling this kind of space. But from what we've said, you can clearly see that the trends are such that, there is an interest to tax. There is increased appetite to tax, whether it's services related to IP, which are being called either digital services or, in fact, even in the definition of royalties, any related assistance to IP is also a royalty. Payment for any related service assistance. So that is clear. It's a very, you have all these wide definitions trying to capture anything and everything. I'll mention one thing, for example, that is a very a disturbing trend. So you recently had our Income Tax Act amended some few years ago to provide that what amounts to unimmovable for purposes of international tax under the international tax regime includes any intangibles that are a business asset. So again, for IP practitioners, I mean, uncommon to, the legal understanding that possibly your immovable property is only land or buildings, you have a specific definition now indicating that what is immovable property includes any intangibles that you have to use in a business. Now, the tax implication for this usually is that every time you have something classified, because this is just characterizing income from intangibles as income from immovable property. Every time you have something classified as an immovable property, under the general rules, Uganda tends to have a higher taxing rates, because immovable means that it's here. I mean, it's immovable, it's here. In terms of a fixation, I mean, you have a stronger right to tax it. So a lot of the international tax rules trying to tax clearly say that for as long as something is immovable, then the country where that immovable property is should tax. Now here you have a relatively new definition saying intangibles, that you're using in a business are actually immovable property. So it does not matter anymore, I mean, regardless of where you're selling them from or not, for as long as they are a business asset being used in Uganda, then they are immovable property in Uganda by way of classification. Now, just compare that appetite to tax with what is happening globally. I mean, in terms of IP. So you have countries, and we can't say this is because they are the developed world and they are generating the IP. Because it is true also that, I mean, we take pride in the fact that a lot of the youth now are coming up with all kinds of innovations and apps. And it's something that I mean, the government would be interested in, to develop, to encourage. So what better way to encourage than to have incentives? In all the countries in the EU, I mean, literally any country in the developed world, they have a special incentivized regime for IP. It's either not taxed, or it is taxed at low rates, or you have all kinds of allowances and deductions if it goes obsolete, whatever your investment is, whether it's been successful or not successful. I mean, you've attempted, you've had to invest. So you have either incentives based on income. So if you make income, you're not taxed. Of course, that assumes that it must be successful. Because if it's not successful, then you don't get to the income stage. Then you even have countries that just give you incentives for expenditures, expenditure-based. What have you spent in trying to develop an IP? And then they allow you, for tax purposes, to take that back, either as a tax credit or as some kind of deduction, and this happens. The UK has a very popular regime called a patent box, where the rate moves from your 25%, you end up paying about 10% for all patents that have been classified. And so are all the other countries, some of them with as low as less than 5%, And that is the world, because then you're trying to promote innovation, you're trying to promote research and development. It's the driver of your economy. Literally everything in your economy is entirely being, you want to encourage it. So you would want businesses to invest, to innovate, and that is all IP. But yes, the trends here are that we are taxing it.
Thank you, Edward. We'll have one last question, and I'll rope in Tony for this one as well. So what are the specific tax challenges or opportunities for Ugandan business in emerging areas, such as digital assets? You hinted on them in your presentation. And how might advances in technology, such as artificial intelligence and blockchain, impact the tax treatment and valuation of IP assets in Uganda?
Yes, thank you. Well, I think I'll take it that I'll take it that what is a challenge for a taxpayer most of the time is an opportunity for the tax collector. And what is the challenge for the tax collector is ideally an opportunity for a taxpayer. So the points will be addressed. So ideally, IP is a safe place if someone wants to mitigate tax in their business. Because the intention, if you invest a lot in research, is not to tax. But if you also invest in those new areas, chances are that revenue bodies have not yet caught up to be able to understand the nature of those businesses or the IP itself, that by the time probably they catch up, you would have been able to handle. Probably, and that's the reason why the Silicon Valley made a lot of money with that structure Edward talked about, because the entire international taxing community had designed its rules to tax on two principles of residence and source. But because of technology, they came up where you can conflate between the two. They came up whereby I can come in your country, not have presence there, but I sell there a service. I will not have a hotel, I will not own Fairway, I will not own any car, but I will have Airbnb, I will have Uber respectively, and I will collect money from it. I will be Google, I will not have an office, but you'll use my search engine, and the adverts will run, or it will be Facebook. So that one, in a way, by the time people caught up or understood that actually what comprises of, let's say, Apple Inc. are a series of 10 companies located in different areas, and most of it is IP, where in Ireland it wouldn't be taxed, or the others that would be located in Netherlands would be getting tax credits, they had made a lot of money and they could not go back to it. So the challenge or opportunity is that it's an area, depending on how we look at it, taxpayers, if you have the resources, you're better off investing in IP, because thereon you can try, they are not trying to bottleneck you as the real sector where they see. But also for the revenue bodies, they need to catch up because it's a challenge for them. There is an intention to overhaul the entire taxation regime to capture this aspect. And how IP is helping in valuation of assets or taxing is that it's a two-way street. For instance, the same intellectual property that taxpayers use to advance their businesses is also used by tax collecting bodies to collect tax. For instance, I went to China 2 years ago. It is shocking that with their population that is almost among the highest in the world, if not the highest by then, you would go to Guangzhou and you reach their large taxpayers' office and there are only 7 people. And you ask where are the people with these billions of people you have, and they tell you no, everything is. You reach there when a taxpayer goes and you have a complaint, there are robots. You either type or speak to it, it will respond to you. They have AIs that have developed to be able to track, whereby from the moment you enter the building, a message will pop up that welcome. So there are advances in IP that have been geared towards revenue bodies. For instance, especially akin to that, we used to have a challenge of taxing the telecommunications sector. But now people are selling software that shows that there's a lot of money in the telecommunications sector, and this is how to collect it. So IP can be a tool that revenue bodies use to tax and even value. I talked about the databases. It is no longer the idea then, when someone got a transfer pricing matter, was that you will review the transaction, review the rule, you consider an independent party. But now, after every audit, all you have to do is go in a database and you click a sliding scale. You're auditing the financial sector. It's located here. You're looking at management fees. What will you expect? So IP has also helped us. Then it also helps in sharing information. Previously, there was that tendency of you're dealing with a taxpayer outside Uganda. You'd probably need to write a letter. You take it to the embassy. It goes. But right now with technology, after signing of the automatic exchange of information regime across over, every month that goes by, you just log in and you can get access of a transfer of shares, let's say between the Royal Dutch Shell. So there is a lot of information that is being shared because of IP. So IP has also helped in tax collection and valuing assets. So we no longer need to hustle. Think of it as a calculator, whereas previously you would add 1 + 1 to know the value of intellectual property. With the search engine, it's equivalent to a calculator. You just log in the proper searches and they will tell you, they'll bring the entire map that the value of this in Europe is, in the European Union is this, in the US it's this. So these are tools that have really helped us to tax and value. It's more of like a calculator. We did not do the hard analysis of looking at it and you analyze, no. You just load the documents and they will properly audit for you. Actually, the future we are looking at, there are people who had advanced a lot to study accounting. It's possible that we might reach whereby the or future tax collector might need not know the accounting or the law that much, because if you feed it into a system, they can easily tell you that this is how to tax it. You may not even need to file a return where we are going. As long as we have all your transactions, the return will come and you just need to edit and go. So even the international tax payers who are not here, when it comes to digital service tax or any other components, you find that it's easy for us, and voluntarily they come up and they declare and they say they want to pay the proper tax. Because the international tax regime, there is a connection whereby you're only wasting time if you don't comply, because the competent authorities are on one page, they are viewing your data, they can see it all.
Thank you, Tony. At this point, I'd like to open up the floor to the audience. Please feel free to share any questions or comments that you might have, both online and in the room. A microphone will be brought to you shortly.
Thank you very much, the panelists. Mine, just two questions for Dr. Bachibinga. One is, when you talked about technology transfer office at Makerere, it sounded like a tiny office in a corner somewhere. Yet, when I looked at the statistics, the University of Pretoria is making about 150 million rand in technology transfer. Why haven't the universities in Uganda adopted the formalization of technology transfer offices for value addition? Universities like Chambogo, Stema, I tried my best to find information about their technology transfer offices. There's nothing there. Yet, universities are the hub of research and development, and commercialization of the same should be an obvious outcome. Two, that was on technology transfer. And what can we do to make sure this becomes the norm, formalized, and we have it in all universities? Number two is, how do I convince, or how do we convince artists, like you're saying, musicians, to register their art? I'll use musicians as an example of the creators. How do we convince an artist somewhere who has made his one hit song and he knows that by performing at a concert and playing it on radio, he'll make the money. How do we convince this individual, given the voluntary nature of copyright? How do you convince this individual to actually register so that the taxman can finally make the assessment and evaluation and tax? How do we get to that point? How do I convince the artist or the creator to register their art? Thank you, Doctor.
Thank you. My name is Kalibala Nyanja Philip. Mine is mainly a comment, but if there is any question therein in what I'm going to present, then maybe someone might be kind enough to address. But I came in when Mr. Kalunji, Acting Manager Council Kalunji, was making, probably responding to comments from his presentation, which I also picked up to see that there were some things that required maybe making comments about. For instance, for starters, I think URA should get a department for IP in itself. I don't know whether this is being thought about because you've discussed the complications of this subject of IP. It's quite complex, and almost the people who are trained in IP almost pride in the statement that it's also technical, as if it's exclusively known by only people who are trained. You have to be trained in IP to know the character of the subject and how the subject works. So it is critical that URA probably might create an exclusive department for intellectual property, probably liaising with URSB. Yes, liaising with URSB and other world bodies. One of the challenges that you will find while you're enforcing and looking at this IP is that the different IPs have different characters. When you look at patents, you are honestly not going to approach it in the same way that you're looking at copyright. Neither are you going to approach it in the same way that you're looking at trademarks. So the approach of taxation might be very different. You cannot look at IP uniformly that now we are making a regime for intellectual property. Okay? So that is also something to be considered. Because from your presentation, so one of the things that we are picking up, and also now from a practitioner's point of view, that to make a difference between the product and the intangible and the IP still remains a huge complication, and that is acceptable. You know, the most valued companies, they tell us it's Apple, and they convince us that the picture or the logo Apple is the one that carries the value. Not even the hard copy. If there are no intellectual property and no patents, it's not the MacBook that you have, but that itself. And for me, from an IP perspective, that is what I would look at in terms of transfer. Who is getting the license to manufacture these products? And that to me is the IP. But I can realize that, of course, practically, especially in terms of taxation, and I think also Council Bala has said that to look at a word and you say, this is the word that has value, and therefore this is what I'm going after, as opposed to the product itself, which is water, it still remains a huge complication. Okay, that is where maybe also the issue is that how do you tell me that Renzori is worth 3 billion, this word as it is, as you've presented it, as opposed to the water that you're manufacturing? Yet for me, when someone has a license for Renzori, then that means that that is where the money is going. So that is just my comment, my observation. If there are any responses to that, maybe kindly you might. Thank you so much.
Thank you for your questions. I'll let the panelists answer now. Professor Bachivinga.
Thank you, Madam Chair, and the one who raised these two questions. The first one is about the Technology Transfer Office in Makerere, and whether this can be maybe rolled out, to other universities. Well, okay, I'm no longer in university administration, but I think at one time I was director, probably 22 years ago. However, in the research and graduate training unit, I think they had set up a research and innovation office, and they had appointed somebody. The challenge which I learned was that that unit was not properly funded. Okay, it wasn't being given the attention it deserves. So I think it is important maybe to remind the person in charge there, I think a gentleman called Dr. Wamala, to put more effort in developing this office or equipping the office. What was key was to always, first of all, identify the innovations and then reach out to people outside with a view to commercializing these inventions. From what I learned, the person who used to be in that office, I think he has now retired, seemed not to have been very active. So this is something which I think can be followed up. I agree with you that this should actually be rolled out through all the universities, because the main criticism sometimes of universities is that, yes, they say they are doing research, people are awarded graduate degrees and so on, but people question whether this is relevant, to society. So that element, I agree, can be developed. And I'm going to remind Dr. I think Edward Wamala about this. The second question is about convincing artists, to register. I believe you are aware there is a Uganda Performing Rights Society. Whenever these issues of musicians being exploited by radios come up, those people normally have meetings. I've not been able to follow up how far they go. But I think through that Uganda Performing Rights Society, one can convince the musicians and other entertainers, not just musicians, but even these people who are in, most people used to know about the actors. I'm trying to remember Mr. Katende's outfit. Ebony's, yes. Yeah, I think those people can be encouraged, actually, to register and pursue their rights. I remember at one time, Mr. Katende used to follow up these matters. I used to hear of some pirating groups near the tax park being arrested, for selling those tapes and so on and so forth. So one can encourage this Performing Rights Society to be more active in asserting themselves, and also encouraging its members to register with the URSB. I think the Copyright and Neighboring Rights Rights Act provides for registration, although it is not compulsory, but it tries to encourage people to register their artistic and musical works, so that these can be identified and, of course, followed up in terms of people who are trying to exploit those pieces of work. There's a gentleman who has been in that, the Performing Rights Society actually is about 40 years old. And there's a gentleman who has been there for some time called Moses Matovu. Perhaps those people can be advised. to follow up. Thank you.
Thank you, Professor. I'll let Tony handle the next question.
Yes, about you are creating a department for IP. It's a valid concern. Although in the meantime, what we can do, I don't know. I think it depends on being proactive and where the money is. I think if someone came up with a policy that what we expect to get from intellectual property, if we tax it, is this much, it is possible that such measures can be taken, because for you to set up a department, the justifications you need include financial aspects of what will come through. But in the meantime, to prevent and protect the owners of IP, there are already arrangements. I'm aware there are understandings, MOUs between various government parastatals. I don't know whether it can be imaged up compared to people who import goods, to say that if the things you're bringing in Uganda maybe have aspects of IP, could it be that just like NDA provides permission to people to bring in drugs, or maybe UBOS qualifies some goods to be fit for purpose, could it be that URSB should give someone a clean bill that you're not infringing? How fast can that be done not to stop trade? Will it get the blessings from above? So those aspects I think can be considered, so that if someone, we put it out there that if we import goods that have aspects of IP, I don't know, maybe under the TRIPS come with either approval from you on the certificate of origin, maybe we add there a box or liaise with you to verify. It's something I think that can be done. It has been done in other entities. It shouldn't be hard. It's just signing an MOU. It will be implemented. However, in the meantime, also, it's about, it's more of about, normally IP involves, it's more of a private, it's more of capitalism and commercial. The state normally only comes in to either grant you the specific protection, but the interplay is normally left to the free market. So I don't know. It could be mostly a push that has to be done by the private practitioners or entities. But to set up a department to tax IP might need someone to justify why not want to tax coffee, why not want to tax, why IP. But it's a valid concern. Although internally what we do, especially customs, they send people for trainings in Japan. There are MOUs they signed with Japan, with universities in Japan. People in customs go and study, and they come back, and they are supposed to have knowledge in enforcements regarding all sorts of goods, IP being among them. In the international tax is not a unit, is not a department in URA, but it is a section under the Department of Domestic Taxes. Their numbers used to be so few, but now they are increasing them. And under the international tax, there's a subsection of transfer pricing where they deal with intellectual property aspects. Other than that, it's a valid proposal. Although comparatively worldwide, few revenue bodies tax in that aspect, because the idea is that the tax law is different from intellectual property. True. True, it's more of enforcement of that. So other than that, yeah, we look forward to that.
Thank you very much. As we wind up the panel discussion, I'll just allow the panelists to give us a few parting shots in 30 seconds, starting with Mr. Balaba.
Thank you. I think as a parting shot, it's just something for, there is reason for, IP is very valuable. The expected revenues can be quite high in terms of tax. Because imagine you can take, I mean, an IP asset can really explode in value and you make a lot of money. But I think for me, the appeal is for government to think about, I mean, in terms of non-residents, yes, you're guarding your tax base because then you want them to pay tax here. But in terms of your own residents, I mean, we have a lot of young people, a lot of youth having to come up with all these things. I think that there needs to be consideration for some kind of incentivized, tax regime, to target them. I mean, let them have some, I mean, whichever way you want to do it, either reduced rates or play around with the tax base for them so that it's more favorable. I mean, in which case then it becomes an incentive for that sector to move. Because all we are looking at is, it's a sector that drives so many other sectors. So you would want, focus on it and attention, in which case then you have a lot of people at will having to do all these things, not being worried about, okay, now that I have my IP, let me make sure, how do I register it in a different country? How do I make it appear like, I'm actually based elsewhere, as because Uganda will tax me more, because that's what is happening. Thank you.
Thank you very much. Professor Bachivinga, any brief parting shots?
Thank you, Madam Chair. I think most of the matters have been, raised. Perhaps I can emphasize 3 aspects, some of which we've just discussed. The need to commercialize IP through the research institutions. I think, then secondly, which is related, is the need to sensitize researchers to register their work. Those who do research and they have tangible inventions, they should proceed to register their work and then ensure that their work is commercialized so that they can earn income. And of course, indirectly, the URA will be able to collect tax from them based on, as we've been saying, Income Tax Act, Section 2. We've also mentioned the need to involve MSMEs, okay, medium, small. Yes, those small enterprises, the ones which are obvious are the ones involved in the music and entertainment industries. These should be encouraged, to register again their work, and so that they are able to exploit their work, and of course in the process also generate revenue to the URA. Thank you very much.
Thank you, Professor. Tony, any?
Yes, thank you. I think most of it has been said, but using an example of the European Union, I think it's the regional bloc that benefits a lot from IP. Although incidentally, they don't tax their intellectual property. What they do, as a bloc, they accepted and allowed that if there is any transfer or movement or use of intellectual property within the European Union member states, there will be no tax, except if the beneficial owner is outside IP. So I think for the case of Uganda, given that we are trying to encourage people to register, we are trying to tell them to exploit IP, we might benefit if we add that either at the East African community level, regionally, to allow free movement of this IP within the bloc, so that at least there is no tax, and when there is no tax, we get more if we tax the profit aspects. For instance, if it's a royalty under property income, instead of you withholding 10 or 15% or 6%, why not, even if you go under the specific, if it's an individual and you go under the sliding scale of 10 to 40%, if you tax it mainly under business, you're likely to benefit more.
Thank you very much, Tony. At this point, as we close, I'd like to thank our panelists for sharing their thoughtful contributions, their expert information and experience in this area. Thank you very much. We'll now move on to the next session, and I'll invite the next moderator, Estella Atejeka, who is taking us through unlocking the potential of geographical indications in contributing to Uganda's development. Thank you.
Good afternoon, everyone. Can I be heard? Oh, perfect. Thank you, John. So, welcome to the second session of the Intellectual Property Symposium 2025. We are going to talk everything geographical indications. My name is Ategeka Estella Felicity, and our topic, as Tracy has mentioned, is unlocking the potential of geographical indications in contributing to Uganda's development. Just to help us get feelers of the topic, what things come to mind when someone mentions a country like Switzerland or Ghana, Kenya, the Democratic Republic of Congo, Greece? Let's talk about France for a minute. Bordeaux, Champagne, Alsace. So what comes to mind when we talk about Uganda? Geographical indications is the IP for Omuntu Wawansi. It is the IP that markets countries. It is the IP that that is a vehicle for changing the lives of an entire demographic. So my assignment is simple: to ensure that we have an engaging and educative interaction while making sure that we try to keep time. I'll start with the introduction of our esteemed panelists, followed by a presentation by one of the panelists, then the panel discussion, and lastly, a plenary session. Yeah, thereafter, I will close and allow you to go and enjoy your lunch. I think that is a good plan, so we'll get right into it. Unfortunately, I am unable to look into the room, so I'm not sure if the panelists are seated yet. Okay,
Yes,
they
yes, we
are.
are here.
Nice to see you, gentlemen.
Good to see you.
Yeah, so we are blessed to have two panelists who are together a cup of wisdom and knowledge to drink from on this topic. So our first panelist is Mr. Joseph Imbihayeimana. I hope I've said it right. Joseph is an IP scholar currently pursuing a PhD in the field. He has worked in the field for close to 15 years in research, academia, science, technology, and innovation. He's also a member of the National Working Group on Geographical Indications. Joseph, it's lovely to have you here. Our second panelist is Mr. Edwin Tabaro, an IP lawyer with 17 years experience in commercial law. He's the managing partner of KTA Advocates, the ULS representative to the URSP Working Group on Geographical Indications, and a member of the Task Force on IP Division of the African Continental Free Trade Area Secretariat. Gentlemen, we are more than ready to hear from you. So without further ado, I invite Mr. Imbihayeimana to take the floor.
Thank you so much, Stella. Good afternoon, ladies and gentlemen. We have a very brief presentation we want to share with you about geographical indication, and then thereafter it will be preceded by the panel discussion as guided by Stella. Shall we have the slides up? And I'll try to be as brief as possible because we are time bad and we are getting close to lunch. It's all about giving you a background, and then more can come through the discussions. But maybe as the slides come, I need to probably mention that my name is Joseph Imbihayeimana once again. I work for the National Cultural Research Organization, and I'm the one responsible for the intellectual property office that is there. So we're going to share a little more of the potential of the geographical indication, especially for Uganda. Okay, thank you. And as way of introduction, maybe I may need to first put these 3 or 4 things straight. One, when we talk about GIs, we are talking about, one, the GI system, or the geographical indication system. In this case, what we are talking about is a regime or a scheme that guides the administration of this particular form of intellectual property, which is geographical indication in any territory or in any country. And here in Uganda, we went for a sui generis system, a system that is dedicated and that is looking at geographical indication as an independent form of intellectual property. Some other countries have come up with systems that have integrated geographical indications into the existing laws. You well know that a country like the United States, their trademark law is the one that has GI integrated in it. So for us, we came up with an independent system, and that is the one that guides us in the administration of the GI in this country. And when we talk about this system, we are talking about a number of things. There must be legal frameworks. And in Uganda, we are happy to mention that we have a law in place of 2013, which is called the Geographical Indication Act, now CAP 223, but formerly 2013. And then we have the regulations in place to operationalize that act, and these regulations came into force in 2018. Within the system still, you need structures. Without structures, you're not able to move. So we have the National IP Office that administers GIs like any other forms of intellectual property, and that is the Uganda Registration Services Bureau. So this law is administered by the Uganda Registration Services Bureau. But also very importantly, within the existing National IP Office, we have even specific units that are responsible for GI and also specific personnel. We also have the National Working Group that is responsible for guiding how the geographical indication system would be implemented. Now, moving on from that, then you talk about the GI protection. So this system confers now the GI protection. Now, what does the GI protection go to? It goes to the product. And this product must have unique or exhibit unique attributes or unique characteristics that you can relate to where these products are produced or come from. Okay? So in this case, what you're talking about when you talk about a GI, you're talking about now a product. But that product then, to be fully recognized, it must be coming from a particular area. So that means that the product must come with a name of a particular place or a territory. So that means that the protection is to both the product and the place where this product comes from. So that was general to give more of an introduction to the GIs. But what is important to note is that these unique characteristics that we are talking about that are to a product any product that you believe has unique characteristics, and these characteristics are attributed to where this product comes from, must, now this is where now the key thing is, you must relate the unique characteristics to the environmental factors that are in the place where it is coming from, and in this case, it could be the soils, it could be the altitude, it could be the climate, it could be the human factors, say things like local expertise or even traditions on how that product is produced to become the product that has or exhibits the uniqueness that it exhibits. Now, we have been talking about intellectual property as creation of human mind, right? But then this is now moving off from creation of human mind. You've noticed that? Now, how does then a geographical indication that is not a creation of human mind, but just a product that is exhibiting unique, characteristics and attributed to a place where they are coming from become intellectual property? You recall that intellectual property confers both legal rights and economic rights, where you're able to exclude others from using what you have created, but also being able to benefit from it. Now, you realize that products that exhibit uniqueness, when they reach the market, they tend to be marketed, and various players want to use that to be able to market this product faster or even get better prices of that particular product. Now, along the way, you find that there are people or players who come in and they want to misappropriate or misuse that, whereby one will say, knowing that people will like passion fruits from a particular place, and I know my passion fruits came from another place, but when I'm trading them, I say they came from that place that people would prefer. So that means that you're causing, it affects the consumers, but as well it affects the producers. So this form of IP comes in now to protect both the producers and the consumers for that valuable uniqueness that is in that particular product. Now, important to note is this uniqueness must be related to the environment or to the various knowledge or expertise that is in that particular area where the product is coming from. Without that, you may not justify for this particular IP. Now, with that background, it clearly tells you that even within your minds, you can start thinking about the various products we have on the market that are unique. Like when you go to the market, you want to buy something which, like if you say you want to buy passion fruits and you've gone to Kalerwe, which passion fruits would you go for of all passion fruits coming from this country? One will tell you maybe they will prefer passion fruits from, say, Masaka. And they may not have clear reasons why they are going for these passion fruits from Masaka, but to them they believe that these passion fruits are of quality. Now, what we need now to look at to see that that passion fruit falls under the GI system is making sure that we identify now the uniquenesses, all those quality characteristics that one has in mind, and then have them profiled and then see how to relate them with the environment of the Masaka and know what is it that is in Masaka that influences these characteristics. And then you're able to have the producers in that particular place protected, but also have the consumers that prefer the passion fruits from that particular area also protected. Now, this is not a new thing. You've had in Uganda, we've had a law that stems from 2013, but this system has been there in the world for some time and gained momentum in 1958 when the World Intellectual Property Organization negotiated with the member states and came up with the Lisbon Convention, which now provided for the protection at international level of the products that exhibit the unique characteristics that are attributed to where they come from. Now, why was that coming in? It was coming in because there were many efforts that different producers and consumers were trying to use to see that there are products that exhibit uniqueness stand out against others that do not exhibit the similar characteristics. And for a very long time, you had people talk about things like the indication of source. You've had things like, this is a product of Uganda, proudly Ugandan. So that is indication of source, that this is coming from Uganda. But then you have products where you've seen where there was appellation of origin, whereby you have a particular area, the producers are organized, they have set their own rules, they're saying this is how we should produce our product. And in Uganda, we have quite a number of communities that have done that. Interacting with coffee, we have had a group called Bukonzo Organic, and then we have also Bufumbo Organic in Mbale. Bufumbo Organic, it's a sub-county called Bufumbo. Bukonzo is a county called Bukonzo. So these people came together and organized themselves. They set standards. They said, we need now to market our coffee as Bukonzo coffee, but it must meet particular standards. So now that's how the appellation of origin now comes in. So now when you combine these two, now that's what now gives us the geographical indication. Let's move now faster. Next. Oh, sorry, I'm the one supposed to control, sorry. Yes, so what is the nature of the GI that we are talking about, and who are the right holders of this form of intellectual property, and who is eligible to be part of this? One, we are talking about a product that must be distinct and exhibiting uniqueness. Without that, you may have struggles to justify that a product is a GI. And these characteristics must link to the territory where they are coming from. Okay? And then, secondly, and very important, is to see that the product meets certain requirements that are agreed and adhered to by the producers or custodians of that product in that particular area. And of course, setting production standards and rules, which many people call codes of conduct, to see that the quality that you're talking about that is pushing consumers to come for that product are maintained. The other key thing is this IP form or this IP right, unlike other forms of IP that are owned individually or by companies, this is a collective IP. It's collectively owned, and it's owned by all the producers or the custodians of that particular product in that particular area. Okay? And this can be in form of an association, it can be in form of an administrative unit like a sub-county, a district, a kingdom, or any other organized entity. And in some cases, government has also, or government institutions have also, been positioned as the owners on behalf of the communities of this particular product. And very important in this is there must be equitable sharing of proceeds among the participating groups or producers or custodians of this particular product. So the proceeds should go to the producers and the producers within that particular community. And then, of course, very important to note is every producer or every person that is within that particular community is eligible to be part of this GI system. But the very key thing is you must be able to meet the standards that are set by that particular group to maintain the quality that you've laid as the unique characteristic of your product. So, why should we think that GI is important for Uganda? And to me, I keep saying that actually this is the most ripe IP form for Uganda and even Africa, because it talks to what is already happening in the market. Every person here who has gone to the market, they will tell you if they are going to buy sweet potatoes, they have specific sweet potatoes they would want to buy. If they are buying potatoes, the Solanum, they have specific, the Bumonde, they have specific Bumonde they would want to go for. If they are going for pineapples and the pineapples are lined with different labels from different places, they are pineapples that you would want to go for. So, meaning that actually our market has already been structured to implement the GI system, but the producers and we, the players that are supposed to handle our different roles at different levels, have not hoped the consumers actually to not be exploited. Now, the other reason why I believe that this is the most ripe IP form is Uganda, again, is already structured in agroecological zones. So every place, every part of this country is under what we call an agroecological zone. Now, these agroecological zones are determined based on soils, climate, altitude, and natural resources, or even commodities that that particular zone participates in. Okay? So clearly, those are the same characteristics that one would use to justify a GI, meaning that products that are produced in these different agroecological zones are likely to be potential GIs. And we're going to break that down further. Then secondly, Uganda is very rich in traditions and cultural practices. Going back to your different cultural settings, you will know that there are some things that are done in a particular culture that are not done in other cultures. And there is probably particular food, particular cultures eat that are not found in other cultures. Even when other groups try to do the same probably food, they will not do it the way that cultural group or that particular community does it, because probably they have the expertise, indigenous knowledge that has passed over and over, and then eventually it becomes like a technical skill or a technical expertise to see that that food or that product comes out with uniqueness the way it should be. Now, all that clearly tells us that the different products that are falling under the different agroecological zones, the different products that are falling under different cultural groups, the different unique identifiers of different communities, all can easily fall into this GI system and can be protected, and then those communities start benefiting from this particular system. But all that said, even when all that is in place, this has not been tapped. We are talking about the market is already, the consumers are saying, for us, we know what we want in these particular products. The producers are also trying to continue producing. Custodians are trying to sustain what they have. But then there is a missing link. So that is what we are talking about today and why we need to fully have it tapped. And it is one of the IP forms that I believe would influence transformation of agriculture, knowing that this is an agricultural-based economy and the different agroecological zones have different products that are unique, but also it is one way of preserving our culture, given that different cultural setups have different products that can easily be identified to them. And more importantly, it hopes now to link the producers with the consumers or the market. So this is what I've been talking about. The country is zoned into 10 agroecological zones. And from now, say an institution I work for, NARO, we've already structured administratively our institutes to manage the different agroecological zones. And indeed, you will notice that the different agroecological zones focus on various products that are in one way or the other unique to that particular zone and are not to other zones. And this already, again, presents another opportunity that even when we work with the administrative units that are set, cultural setups that are in place, we are able to identify the potential GIs and be able to see how to have them protected easily. And now, these are the agroecological zones that I'm talking about. So, taking quick examples, like Lake Victoria Crescent, this is a zone that stretches from the River Nile to Katonga, and then to Kafu. So this is what we call the Lake Victoria Crescent Agricultural Agroecological Zone. Now, when you look at this zone, there are specific products that are unique to this particular zone. You have vanilla that is being produced in Mukono, and many people consider this vanilla to be unique. People coming from different places wanting to pick this vanilla and probably even blend it with other vanillas coming from other places. We have spices coming from Kalangala. Even when you get the spices from Kalangala, the same varieties, and you take them to my place in Ibanda, they will not come out as the same. Meaning that the environment that is in Karangara is the one that is influencing the uniqueness and the characteristic that the quality characteristics that are in these spices. Talk about passion fruits, what we've talked about. Everyone, even those that probably do not know much about passion fruits like myself, I know that Masaka passion fruits are very good. But I may not have now gone into the details to know what is it that is making this particular product this good, but the market has already structured itself. Then you have pineapples from Kayunga, from Luero. These are products that even when you get a pineapple variety from that particular place and you take it to Kayunga, to Kamuli or other places, you will not get the same quality of product. Albert Crescent is the one that takes the Albert belt, and you have a number of things there. We used to hear that good waraji, for those who know waraji, comes from Kibari and Kagadi, because it is made from those particular brewing bananas that are in that particular place. People try to domesticate these brewing bananas in different places, but things were not adding up and bringing out the best waraji that should. Cross to southwestern Uganda, Kigezi, where you have sorghum, that even the sorghum that is there, even if you got it and took it to Bushenyi, you will not get the same porridge that a person in Kigezi is getting. They have potatoes from Kigezi. We have apples in there. Go to northeastern drylands. This is a belt of Karamoja. We have what we call Gamma Arabic. To us here, it is a west. Go to Sudan. It is the second export of the country and foreign exchange earner in the country. For us, we don't take it as serious. But Gamma Arabic in the stretch of Karamoja is also considered very good, and many other products. Talk about Western Savannah, where you have the Ankore cow, where you have all the derivative products in there. And then, of course, the honey from Bushenyi and many, many other products. Now, when you cross now to the culture, relating now GIs and the cultural setups we have, you have these different cultures and the various potential GIs that one can easily talk about. You have Uganda here, where we talk about the back cloth. There is even a particular community that must handle the back cloth, preserve the back cloth, harvest the back cloth. So there is already a structured way of how we can easily exploit this as a GI. We have Luombo that is here. People have their own techniques of how to prepare it. A person from a different probably setting may not easily do it the same way. We have Enturire from Kigezi. You've heard about over the weekend. I heard there was Bachiga Nation, and Enturire was the most selling product in Kampala. So that is already a GI. You cannot easily find it even anywhere apart from when the Bachiga have gathered, and many other products. So why should we embrace GI as a country? One, this is one way of supporting collective management. This is a collectively owned IP and is collectively managed by the producers or custodians. It is one way of ensuring that we maintain the product quality, because remember, these producers would want to see their product maintain their quality so that they are able to access the better prices and what we would call the premium prices, which would eventually enhance their welfare. But then this would also enable them access niche markets. Today we have potatoes. When they get here, they mix them, and whoever is coming, they tell them this is Kigezo Kisoro potato, but when they are not. But if we have this well organized, we would know that this potato, when it comes, it will fetch a different price, which is the premium, which is in the end going to help the producers gain better welfare and all that. We have success stories. In Uganda, so far, we have had one GI on the register, and that is the Rwenzori coffee, Mountain of the Moon coffee. But there are many other success stories out there. In Ethiopia, you well know about their coffee, probably not the best compared to ours, but they are the most known for coffee in Africa. Yet actually our coffee, even when it is sometimes blended, it has become the second in terms of quality on the world market. Then you talk about their njira, or what many call teff, that is as their staple or best dish. Then talk about Cambodia with the paper and rice, talk about India with the Jering tea, talk about France with the most famous champagne, and then Switzerland, that is everyone who crosses and reaches Switzerland, when they come back here, they ask them chocolates, because they believe best chocolates are from Switzerland. But then word has it that maybe they even don't have cocoa trees. But they are now known to be the best. And now that may not talk to their environment, but now talks to their local expertise that we talked about. And indeed, even when we try to bring it closer to, say, vehicles, in Uganda here, you hear words on the streets that the hard vehicles that cannot overturn, that cannot do this, come from Germany. So now, that could be now their niche, and they can even start promoting their products, which are not even natural products, as GIs. Now, see how people who are trying to squeeze themselves close to GIs are trying to exploit it, and for us, who have these all diverse potential products, we're just looking at them. So what do we need to do as different players? This calls for concerted effort. As lawyers, you have a role to play, hoping these communities come up with standards, hoping them to appreciate the whole aspect of IP, hoping them to know that actually what they have is golden. Then being able to identify these products. As again, stakeholders, we need to identify and profile all these products. Identifying them is not enough. Then we get into their characterization to identify the uniquenesses that are exhibited in these products and start relating them to the places where they come from. And then, of course, hoping members to get organized, hoping members to put in place their systems and things like that. And then, of course, URSB continuously taking lead in the administration and registration of these IP rights. So these are some of the things that we that we must address or handle. One, GI remains a new or not known concept, especially here in Uganda, even with the potential that it has. So we need to do more awareness to see that our people get to appreciate this and make use of this. Then, of course, when you're putting all this in place and people have already structured it right and the market is already ready to pay premium, you do not probably run out from the middlemen that would want to exploit the system. So there is need now to see that there is a strengthened link between the producers and consumers, so that there is that close interaction and you eliminate more of the middlemen. And then and fair competition, of course, will continue, whereby you go to the market and say, I want potatoes from Kabale, and the seller will tell you, these are also from Kabale. And then you end up paying even for a bigger price when you're not supposed to do that. And then the misleading names that are also there. I don't want to mention names. I see some products that are close to our tables here that are mentioning places, and probably consumers like me could easily think that the mountain that has snow, snow is tapped and put in a bottle, and that's what we are taking. But well, the trademark came before the GI system, so we may not have much to redeem. But that's the little background I wanted to give, and thank you so much.
Thank you very much, Joseph, for that very resourceful presentation. I'm sure at the very least, every one of us can now identify a potential GI. And to prove my point, those online, kindly drop the name of a potential GI that you are most excited to hear about in the chat. And those in the building, I'll give you an opportunity to tell us the GI that has excited you, potential GI that has excited you the most at the point when we are asking questions. This one wasn't mentioned, but Jambula, I think it is a fruit I've only seen in Uganda incidentally, and I think it's quite unique. So, in the interest of time, we are going to go straight into the panel discussion. I kindly request the technical person to enable me see my panelists kindly. Yes, thank you. So we'll go straight into the panel discussion, and I will start with Mr. Tabaro. From Joseph's presentation, it is clear that Uganda is well endowed and blessed with various potential GIs, but we only have one registered GI. Drawing from your experience with the GI registration process, briefly describe what it takes to get a product of the potential GI list onto the GI register.
Okay, thank you. Thank you very much, Estella. Thank you very much, ULS. First of all, I would like to acknowledge the role of ULS in proposing IP as an area of practice. URSB as well. More than a decade on this job, I've seen a lot of transformation in this area. When we're starting practicing IP, we found around just about 4 or 5 practitioners in town. It was discouraging, but there was a lot of hope. Professor Kakoza was one of them, together with his partner, Paula Simwe, and they encouraged us, and I'm happy to see that we have come this far. There's still a little uptake by IP lawyers here, but I think that's more of a policy issue and the industry itself, innovation. But just to let you know that in all economies that have made progress, what we call a knowledge economy is what drives them. It is thought, it is ideas. I mean, we go back to the times of JP Morgan, the people who discovered light, cars. These are things that have changed societies and communities, and this is our area. And there is no way a country would make a lot of progress without IP, or intellectual property, or knowledge for that matter. Of course, many years ago, before when we were starting, it was really copyright, trademark, and patents. We started on, just to share a little bit of what we've done, or what I've done, we started on registration of Ankole cow products as a GI. At that time, there was no law, but we're happy to learn that it was in the offing, thanks to Mercy and the former Registrar General, Twebaze, who is now at Aripo. And I think with the efforts of people like Professor Kakoza, we came up with the law. But then again, there were also regulations which were passed in 2018. And those are the ones that provide for the systematic registration of these GIs. Along the way, indeed, we discovered there were quite a number of GIs, and from Joseph's presentation, there are definitely many things we can register and access the markets in Europe. However, very briefly, and just to point out, Estella, the guiding principle is that there must be particular attributes. So the regulations, 2018 geographical indication regulations, give requirements. I mean, the name, the place, address, whether you're registering as an agent or the owner of the geographical indication, And then the main issue is the specific attributes, because it is only a geographical indication to the extent that it has peculiar characteristics or attributes that emanate from a particular area. As Joseph has pointed out, if it's an agricultural product, it is definitely a peculiarity from that area. The one we have so far registered is the Rwenzori coffee, mountain coffee. That is a special Arabica coffee grown on the mountains. If you remember your geography or even biology very well, incidentally in IP, it's one of those areas where chemistry, biology come to life. If you look at the memes that we have in social networks, people will ask you, what does ionization of hydrogen help us now that we are studying or working, whatever we're doing? But that's very, very peculiar and something you'd come across. So Rwenzori coffee is as it is because it's grown in the volcanic area of the Rwenzori area. There's nothing like that you'd ever see elsewhere. I came across as well, working on a similar project in Burundi, a specialty coffee called Kanyanza. In the Kanyanza area, also grown in a volcanic area, and we also know about the Rwandan coffee. These have special prices. So if you went to a supermarket or one of the stores in the US or the UK, the most common is from Rwanda that entered a partnership with Bourbon Coffee. It has a specific price because of its origin. We have not been able to ascertain the success of Rwenzori coffee because it was just registered about 2 years ago. And we're yet to see what benefit it's going to have. But I can assure you, I've seen that of Rwanda and Burundi as well. What are the challenges? There are basically two, and personally I've come across those. I think I'll also share what Professor Kakoza is doing. So we're doing a project which is supported by WIPO on registration of 2 of these products. Mine would be the Ankole cow products. And the question would be, like he said, IP is just basically a writing persona. Yeah, never do you hear of groups of people owning, except for certified trademarks. But would you own an Ankole cow product? If you were to register the AGI, who owns it? Would you own the Rwenzori coffee? I know for sure that Rwenzori coffee was registered by a cooperative that is supported by, at that time, UCDA. So anybody can be a member of that that cooperative. However, in our case, you have the people from Ankole. So just to explain the peculiarity of this breed, just about 3 or 4 things. It can move long distances without food or water. Not without, but with moderate food and water, which is very difficult for an exotic breed. It doesn't need a lot of acaricides to heal it whenever it has disease. So it's low cost. Thirdly, the product itself has low fat. And these are scientifically proven. What is the problem now? It's first of all the R&D, research and development. I'm aware that yes, Naro has a project as well, but alongside it, we have NAGRIC, which has huge ranches and is doing research and development on it. But for you to get those particular attributes and put them into the regulation to convince WIPO or URSB that these actually exist, they don't have that research. When you go to them, they will tell you that they have budget constraints. They're going to read the budget, I think. Is it today or tomorrow? Today. But you will clearly see, and I've worked with NAGRIC for years, nobody ever gives them that budget. So you cannot even have R&D anywhere. I mean, good IP in any country if you don't have good research or R&D. Like they mentioned even Dr. Bachibinga, the program they have at Makerere University, these people. So we look for this. We just simply want to tell people this is the peculiar aspects we have. Secondly, The ownership, I mean, like we said, it's a right in personam. But however, if you look at the recent, in the last 20 years or 2 decades, WIPO has given guidance on sui generis systems on how to register some of these GIs or products or marks that could be owned by communities. So would you, for example, how would you, for example, register the back cloth? That's something Professor is working on. Would you, because it's produced by the Nkonge clan of Buganda, it's not owned by an individual. This is community knowledge. So those are some of the challenges. But I think going around them, you can use the corporate personality. For example, from my reading, I'm not sure whether, Professor, you've handled this as well. If you look at the constitution, the cultural leader of Buganda, who's the Kabaka of Buganda, is a corporate personality. So you have the individual on one side, but when you look at the constitution, it gives the corporate personality to the Kabaka of Buganda. A clan doesn't have corporate personality. Also, on our side, when we're recommending for the registration of, say, Ankole cow products, if you look at the Nagric Act, which was passed a long time ago, it's almost absolute, but however, it provides for breeding societies. So you can have the Ankole breeding societies. Because from the research we've come across and the interaction with scientists is that the moment that cow moves out of the Ankole area, one, because it's not really Ankole, but you're talking about the cattle corridor, because you'll find it as far as Nakaseke, Busongora area, which is Kasese, that's outer Ankole area. But because of the short grass, 2 rain seasons, the ecological conditions give it those attributes. So the moment it gets out, the first thing it changes is the horn, from white to brown. Naturally, the feeding pattern changes. You won't get the taste. But if we had a system that regulated its breeding within that particular area, like Nagric does it, Honor would have done it with huge ranches, you'd have a peculiar product coming out of there, well regulated with certification, just like they do in other agricultural products, where you have certification that for you to be certified as an Ankole cow producer, you must rear it within this ecological condition, under these conditions, and for that particular purpose. Thirdly, I don't know whether I've overshot my time, is what we call genetic erosion. These, for example, Ankole cow under the CBD is an endangered species. So if in the next 20 or 30 years we have not taken particular effort to conserve, it will disappear. You've probably seen it in South Africa, you've seen it in Kenya. I think the president gives it out, and we discovered what we call embryo trade. So people just get the embryo, transport it in the plane or across the borders, and reproduce it everywhere. So the scientists will talk about a genetic erosion in the sense that if you do not have a balance between reproduction and the breeding, then you're definitely going to disappear. But we do have laws and regulations. Everything is in place. But again, the budget shortfalls. NEMA is the one that manages the access to some of these genetics. And if we also had benefit sharing agreements, that's another aspect. Perhaps we could discuss later. We would control some of these things. There are also other potential geographic indications like the matoke. From my reading, I'm meant to understand about 100 years ago, there were about 149 species. They have fallen to about 75. Where the others, they are slowly eroding. However, if we protect it, protection would include conservation or commercialization. You'd have some of these products for ourselves, for generations to come, and probably they would be controlled for the benefit of the country. As the topic suggests, they would be good for the country's economic development, because most of them, almost about 60% of GIs are agricultural products. And like you said, agriculture is the backbone of the country. And I think this is where we come in as lawyers. The law is there, we're working with communities. We just need to keep pushing government, influencing policy for better budget allocations, work with universities, R&D. We've come a long way, and I'm certain these are things that are definitely going to work out. Yes, back to you, Stella.
Thank you very much. Thank you very much for that very elaborate answer. I think we got more than I was even expecting. So thank you. Just a brief add-on as you were speaking. What happens with this genetic erosion? We might find ourselves in a situation where, you know, in the process of conservation, we end up making minor changes to the genetics of whatever product it is. Yeah. How would that would that preclude, if there is evidence that, you know, there was a certain species and then in trying to conserve it, the genetic material had to be altered a bit, would that preclude it from GI registration? Just briefly.
Okay, thank you very much. Again, it all depends on the R&D. I know that is a very contentious subject about genetic modification, but I'll give you an example from the experience. Ankole cow can be conserved in two ways. There's the ex situ and in situ. The in situ is within the laboratory. So if you went, for example, to Nagrik, you will find a lot of semen and a lot of some of the genetics conserved in hydrogen, what they call them, the hydrogen storage. So if you want to reproduce, you simply go there, get it, and take it to your farm. Now that's an innovation. It's what I see them doing. However, if other innovations came up, and I believe they would be there if government researched and gave these people money, or even narrow. We're limiting it to Ankole cow, but I'm aware, for example, there's NAFLI, the National Fisheries Research Institute, somewhere in Jinja. You're aware of the commercial success of what they call fish maw. Fish maw is that white substance from the head of the tilapia fish. It's a kilogram goes for about 1 million shillings. Yeah, Chinese are the biggest buyers. A few people from as far as Russia and Indonesia, basically Asia. So it costs more than the fish itself. As we speak now, it's there's a danger of erosion simply because there isn't protection. NAFLI is a bit constrained as well, but I believe if they were given money, they would find ways of conserving this. And there are so many others. The cotton itself, you are aware, also has issues with genetic erosion, and we lack R&D to develop it further. But however, there are also some success stories like coffee. Coffee, I think, to my knowledge, is one of the best crops that we've had in Uganda, which has been supported by research and development funds. First, the 90s under Kawanda, and now we have Nakori. You are aware that the country made about $1.5 million US, $1.5 billion US in revenue on just one crop, ending this financial year. So, and that's simply because every other time the scientists are creating new varieties. From what you spoke about, the genetic modification, if you went to the websites, you would know that every other year, 3-4 years, they out new varieties to beat pests, diseases, and at times to respond to consumer behavior. It's one of the reasons why we'd get $1.5 billion. I don't think there's any such success within East Africa from my reading, and that's a result of R&D. So I don't think there's any problem, as long as, because scientists are taught, some of them have experience, like Joseph, where he works. That's the reason why NARO exists, so that people create for purposes of innovation and for purposes of conservation, and I believe in turn it would contribute to the country's economic development.
Thank you very much. Joseph, to you now. This GI registration process, from what Edwin has told us and from your slides, moving a product from the potential list to the registered list involves very many stakeholders. So, and Edwin has touched on the issue of, for example, ownership and attributes. Like, there's so many things that need to come together for the process to be successful. But then also these very many things are spread out among very many organizations. You have NARO, you have MAIF, you have the farmers themselves, you have URSB, you have the lawyers. Who should make the first call? How do we harmonize all these stakeholders to ensure that we have potential GIs continually being turned into fully registered GIs? Like, there is a continuous chain of, there's always a potential GI in the pipeline. If one has, you know, issues that are too complicated for the current system, another one is being picked up. So how do we achieve the harmony between all these entities and individuals to ensure that, you know, we have GIs registered more often?
Yeah, thank you so much, Estella. Quickly, one is to appreciate the Uganda Registration Services Bureau for the good work they have done so far in making sure that they coordinate stakeholders together and also create awareness. Today, we have a national working group on GIs, which is constituted by the various stakeholders that have a contribution to make along the whole GI chain, from the producer to the market where you have trade and export coming in. So that is a very good step, and we must appreciate that. Secondly, we must also appreciate that 2020 and maybe 5 years ago, were not having any GI that we would refer to. Today we have at least a GI that is on the register, so we have a success story. Can we pick it from there and learn from how that group managed to get to where they are? Maybe they haven't benefited the way they should, maybe they haven't perfected the system, but can we learn from them and also be moving as they also perfect their system? Because it is learning as we move. But most importantly, what we need to do now are 4 major things. One, awareness. People do not know about this whole thing we are talking about. Can we make people appreciate it? Can we make producers know that they are holding something that is of potential, that would have earned them more? Can we hope even other government entities that have a role to play along the way, export promotion, UNBS, all those entities that have a role to play along the chain get to appreciate their role and also get to know that this is what we have. Then the second thing that is very important is the organization of the custodians and the producers. If we are talking about backcloth, can we get into the cultural setup of Buganda and identify all those key stakeholders that have a role to play on the backcloth, bring them together, appreciate what they own, and then see how they can push it forward. So the organization, if it is an agricultural product, MAIF needs to take a lead role in organizing the farmers. I didn't mention awareness is a responsibility of almost everyone, led by the Uganda Registration Services Bureau, you, the Uganda Law Society, and all other people that have already, appreciated this. And then the next very important thing is doing the characterization. We are already talking about the potential, many products. We can list them. I thought people in the chat would even list Angara and Nanganang. I know for those of you who've crossed West Nile, you cannot bypass Pakwachi without picking some Nanganang and Angara. When you go to other places, it is not there. When you even get that Nanganang and you try to domesticate it wherever, it cannot give you the same product. So now we need to characterize the uniqueness that is in this particular product, and then get to know what is it that is in the area where it is that make it unique the way it is unique, and then we are able to use that as a justification that our product exhibits uniqueness and is a GI. And then the very last but very important thing is the promotion. Mountain of the Moon coffee isn't yet where it should be, because probably there is limitation in promotion. If we see more promotion done, people getting to appreciate that this coffee is real, true coffee from this particular area, then the niche markets would be accessed, the better export markets would be accessed, and also better prices would be fetched. Thank you.
Thank you very much. We shall talk a little more about market soon. So thank you for bringing it up. Edwin, a quick one. I'll limit you to 1 minute tops on this one. For the indigenous crafts and skills, the ones that were classified as cultural in the presentation, what IP protection would you advise a community to go for? Because we have the GIs, but then we also have the traditional knowledge and traditional cultural expressions. I think it's even a less developed area of protection, but what do you think would be better? Or is it a situation where they can work together?
Okay, thank you very much, Estella. Again, from my interaction and experience, it should appear the commercial success of a GI is connected to the traditional expressions and culture of where that particular product originates from. If you look, let's take for example coffee. People are buying coffee, what would they call in coffee with a story. One, it must originate from a particular area, if it's to be a GI, what they're calling single origin. So what they do, or the people in the market who are buying it, they put polygons in particular farms, or even at the buying centers. They need to know that, okay, like he mentioned, they have to be sure that it's a Mukonzo, a Mogisu, or someone who's speaking it. They buy into stories of how this coffee has built traditions, friendship. There's a common story of how people build friendship by splitting the coffee bean and putting a little blood on it to exchange, and they cement friendship or brotherhood. In Buganda, they call it omukago. That alone gives marketability to the crop. Secondly, it's also regal. I think every kingdom in Uganda, though particularly Buganda, when the king at his coronation is being crowned, he does eat some coffee as a symbol of authority, right? There are many traditions. When you come to the Ankole cow, they use it as a, we'll give a very good example, which we all know, when the president is cementing a relationship with people or with the presidents, like he gave Cyril Ramaphosa the cow. And they usually give you one that can reproduce. It's usually a very good one, that can reproduce. He gave the same, and he built a ranch out of it, the ones we see in South Africa. He gave the same to the late President Nkurunziza. If you went there, and he usually, he passed on, but if you looked up in the internet, his wife takes people around that ranch. So is President Kagame. If you went to his ranch in a place called Musenze, I think he reproduced a number, and when the first son of the president went there as well, he gave him some of them. And I think Uhuru as well. We've seen people from their tradition during weddings, they exchange what? Cows. So these definitely go together. It's difficult to have commercial success without the traditions that follow the crop. Other examples, rather beyond Africa, would include, for those of you who have come across luxury, there's what they call Kashmir rug. The Kashmir rug comes from is it Bangladesh or Pakistan, the Kashmir area. It's hand woven, and those ladies have been doing it for over 1,000 years. It's a tradition, and because of that, that Kashmir rug has a huge price tagged to it. There's also the Sahor rug in Iraq. Making rugs hand woven is very common among those populations, but these have gained this attribution because of longevity in doing it. And for some of those nations, things like artisanry follow one generation after another. So someone will know that a certain clan does this very well. So it would also follow, for example, if you're from Nkonge clan, I don't know whether they have lost that tradition. There's a presumption that when it comes to the back cloth, it's something that naturally comes to you. So TCEs, again, traditional knowledge goes with geographical indications. It's not yet well developed, but we're thankful that in the past years, especially international instruments have been passed to provide for protection. I know that some countries have enacted traditional knowledge laws, Kenya particularly, Zimbabwe, South Africa. In Uganda, I think it's still in the offing. They have not yet come up with something like that, but that's where knowledge is. And maybe just to mention that if traditional knowledge were well developed, protected, I think would have a thriving innovation industry. Because remember, you're born with that, or you adopt that skill and knowledge from your community. Develop it, and perhaps even study and talent can be built alongside it. It's largely untapped, but we can learn from other countries that are doing it. Asia, of course, even here, you know that particular Asian families are gold dealers, other goldsmiths, others are involved in a particular trade, and it comes from many, many generations. So, yes, to answer your question, I think if we developed the law, it would provide a great deal in providing a good value to our geographical indications.
Okay, thank you very much. I will quickly move on to Joseph. So the topic today is unlocking the potential of GIs to contribute to Uganda's development. I tried to look up a definition, a suitable definition of development. I came across an article by Awan Ewut from Kema, who says that there is not a single universally accepted definition of development, but there's agreement that it is some kind of process of change that occurs over time, and they go on to explain that, you know, it should be structural change that involves diversification, economic expansion, broad participation, and one that encapsulates the possibility to reduce poverty in a structural way. Do you have a different definition of development? But most importantly, what are the markers of development that you'd like to see for a country such as Uganda, whose economic backbone we've already said is agriculture?
Thank you so much. Again, I want to keep it around the GIs. One, we agree that Uganda is over 70% agriculture. I also agree that we have diversity of these very many products that are unique and that would even be products that, that can help us, expand our export base. Now, the first line is to say, if we have a GI product, can we take it through all the processes and procedures to make it a potential GI product to become a GI product? Now, from there, can we now promote it to be able to access better markets, or those markets that we call niche markets? Which niche markets will give us better prices? Which better prices will impact on the welfare of the producers or custodians? Now, with the welfare of custodians getting better, there is community development or growth in way of, community changing its face from one level to another, because money is within the community. And then from there, we attain the conservation and sustainability, and all those become now ingredients of development. Thank you, Esther.
Thank you very much. I like that your answer was concise. And so now let's get into the markets, because clearly we need to get into the market to get the potential GIs onto the register and get them into the markets for them to translate into development. Yeah. Edwin, so what are the appropriate next steps? We have Rwenzori Mountains of the Moon coffee registered, but we all agree 2 years down the line, maybe the farmers are not yet, earning those premium prices, or not as much of them as as the hope of registering the GI promises. So clearly, registration does not automatically translate into marketability. And so what are the appropriate next steps for tapping into the potential of GIs?
Okay, thank you very much, Stella. I think that's a simple answer. I've seen this argument before, just like you'd have patents on the patent register, which are not commercialized. You just need to commercialize. Commercialize would include marketing. Marketing needs budgets. I doubt that Rwenzori coffee farmers would set up exhibitions or fly to Dubai, UK, wherever to market their products. What we have recommended, and we have discussed it in the working group for GIs, is that once this is registered, and I think it's the constitutional duty of the government to market its agricultural products. For coffee, we used to have the UCDA. I'm certain, of course it was dissolved, but I'm certain the ministry should be able to provide for marketing of the coffee, as much as it would market all other crops. I'll give you one example of a very successful GI. Not sure whether it's registered as yet in Europe, but the rooibos tea from South Africa. From my research, it's bringing in revenues of close to $35 billion. How is it done? If you go to even our supermarkets here, you'll find it. This is tea from South Africa. But we have very good tea as well. Why isn't it alternately in those markets? It all comes down to marketing and budgets. I think niche marketing is very, very, very specialized, with a lot of capital that needs to go into it. And remember that it's not just marketing the product, it's marketing the product with the traditional knowledge and TCEs that go with it. We've seen it in Rwanda and Burundi. I think their governments also have an equivalent of what we had here, UCDA, and they've gone very aggressively to do this. So we just need to provide budgets for marketing. Just like we need budgets for R&D, we also need budgets for marketing of these peculiar products.
Okay, thank you very much. Just to build on that, I'm still with you, Edwin. So you earlier told us about Rwanda and how they'd managed to market their coffee in collaboration with Bourbon. Is it necessary to have international partners if we are to enter the niche market, or is it something, if we had the budget, would be able to do it on our own as a country?
I think for coffee, we're already doing it as a country. I know that the biggest market for Uganda's coffee is in Europe. We have very, very good buyers in Germany, in Italy, not surprisingly not UK, Turkey as well, and then for US it's Portland. We sell it to, of course, the way coffee is traded, it's traded to what they call roasters, and then they produce the final product, which is also a problem because we lose 70% of the value. Yeah, we lose 70% of the value because we sell raw bean. But then alternately, that's a good advantage, and it's the reason why GIs can be used. Value is not limited to processing or manufacturing. What we are saying is that you can actually add value to your agricultural products by registering them as GIs, and then you market them as such. Just like we have learned that fish maw is 1 million shillings per kilogram because of the demand. With niche marketing, you could even get more. So is coffee, or the other examples like rooibos tea. We also have honey from Cameroon. There are about 3,600 GIs registered or recognized in Europe. The value is close to 75 billion US euros within the European Union, but not limited to African. And I think Africa has just about 6 or 7. So if we have only one GI registered here in Uganda, that means we're not even getting about 0.1% of that, of the value of GIs. But however, if we registered, we marketed our coffee, our cotton, our tea, our fish, our ankole cow, and pineapple, and shea butter. Just imagine if we had 8 of them fully registered with good R&D, good budgets for marketing, I think it would have a better return and not just limited to manufacturing. Just that simple, intangible, like we say, it's an intangible asset. You add value by creating good IP in the agricultural products, or even the handicrafts like the back cloth. Yeah, so that's
okay.
my
Thank you. Thank you very much. Joseph, I have 2 questions for you. One, having marketed the products with all the considerations therein, how does this translate into money in the pocket of the farmer? And then the second question is something Edwin has touched on. We have seen agro-industrialization as a strategy as part of Uganda's strategy for development. We've seen it it's part of NARO's strategic plan. It is part of the NDP 4. So after you have told us how the money could translate, how the GIs could translate into money in the farmer's pocket, please tell us about agro-industrialization and how it will correlate with geographical indications.
Yeah, thank you so much once again. One, there is no better way of talking about GIs without marrying it with value addition. So if you're talking about, just a product that is produced in Kigezi and it is marketed the way it is being marketed today, not the best will come out of it. So value addition, whether value addition from its raw form and you have better packaging, better way of presenting this product to getting the derived products out of it. Now, how does this then translate into money? It's when the product is well, organized, the producers are well organized, they well know where the product is going, and then they are able to charge an additional price over what ordinary products of similar nature would fetch on the market. And that premium price, of course, goes to the producers. And that is how the producers are getting the money into their pockets. But very important to note is, it's not to say that once you have this, then you must get premium price. No. It is incumbent on the producer to make sure that they convince a farmer, a consumer, to be able to pay more to that particular product, even when there is a cheaper product on the side. Like we said earlier, let's give an example of not a very straight GI, but we are saying that there are specific cards from a particular country, and people are saying that they can't overturn, they break instantly. So one is able to feel comfortable to pay more for this particular car, even when there is a less cheaper car on the other side. So it starts at that point, whereby a consumer gets convinced that I'm buying that added value in that product, or that quality in that product. And then that is the money that goes into the farmers, or the producers, or the custodians' pockets. But just to underscore again what Edwin just mentioned, government must take its front seat in making sure that this thing works. At marketing, and I'm happy to note that Export Promotion Board was not mainstreamed under rationalization. It's actually strengthened to become Export Promotion and Free Zones Authority. So now that is an authority, it should take a center stage in helping these different good products that we have to access these better markets, so that we are able to get the money that we are not getting currently into the country, into the pockets of the farmers. At the same time, different entities that are supposed to be at the organization level should be able to organize these producers and custodians so that they're able to exploit this particular potential that we have. Thank you, Stella.
Thank you, Joseph. Back to you, Edwin. From your experience and your work with the African Continental Free Trade Area, what advantage will GIs have for us under this system? Also, would our domestic registration be enough, or will we have to undertake further registrations in order to benefit from the free trade area?
Okay, thank you very much. Just two things out of the continental efforts. One, as you know, under the African Union, we're trying to create one market in Africa, remove tariffs, and be able to move freely between the countries. So there are initiatives to create a continental IP system. That is registration of IP rights, not limited to GIs, trademarks, patents as well, at continental level. It's quite new, but as we might have seen from the Cafe Java's case, territorial integrity for IP rights is very contentious, but also comes with certain advantages, because it creates, or what we did, and the draft annexes actually were passed about 2 months ago, which you can read, or we can share them. They create continental IP rights, for example, a GI that is protected throughout Africa. I know there exists OWAPI on one side and the one for West Africa. That's something that has got harmonized, but as you know, any continental efforts are built upon the strengths of the regional efforts. I don't think there's much conflict, but that's where we're moving to as a continental bloc. Those are the efforts. The advantage, one particular peculiar thing I would want to let the lawyers know is that it creates cross-border rights. So two countries, two communities across borders can create one continental GI. And I think that's a question that has been posed for GIs. For example, you have Shea Butter Sudan, Shea Butter Uganda. And as much as there are two jurisdictions, the plant is not different. Plants don't know borders, it just grows across. So can you register a GI as Uganda, and then the Sudanese also register their own? How then do you market in the international market? So the FCTA gives you that opportunity to register across borders. Or even the fish, tilapia, is within Lake Victoria, which is between three countries, Kenya. But when it's moving across, it doesn't know borders. So this gives you the opportunity. The same as Ankole cow. The very same attributes the Ankole cow has in Ankole area, it has also in northern Tanzania, Rwanda, Burundi, and the Eastern Congo. So to avoid much conflict, again, like we said, the continental efforts are to create one market and market your goods as one big market. So it's all about creating value for all of us. And I believe it's something that we can embrace. I know there will be complications in the future for those who are looking at building this area. That's an area to look at. It's still in the offing. The IP division is just creating the things afresh, but with a lot of support and consultation from the member states. I think our task force involves over 50 people from different countries, consultants and the like. But also on the other hand, just like you have champagne, which is marketed all over the world, they protect it globally. Same way you would want, say, your coffee, not just registered here in Uganda. Incidentally, if you have IP rights that are generated or originated from your country and are being marketed outside your country, there's a need for you to have them registered in those markets. So this gives you an opportunity to go global.
Okay. Thank you very much for that guidance. We are almost at the end of this. Joseph, apart from boosting agriculture, in what other ways do you think GI registration can impact a community that successfully registers a GI? What other industries can?
Yeah, thank you so much. Let's just take a quick example of the Ethiopian coffee. You're well aware about the protracted case that happened probably about a decade ago between Starbucks and Ethiopia over their coffee, whereby they would pick the coffee from this country and then go and market it as their own coffee and get all the money that they were getting out of the market. And then the discussions, of course, happened to the extent that eventually they agreed to share benefits, whereby the farmers now become more like outgrowers of Starbucks, and then they're able to agree on the prices, they're able to agree on the non-monetary benefits. And that means that away from the money that is going to directly to the pockets of the farmers and the producers, you're able to benefit from other social services. You're able to gain in terms of infrastructure, you're able to gain in terms of jobs. And all that again comes as a benefit of having utilized this particular system. So I'm looking at a scenario where we are saying that the potatoes, say, from Kigezi are good for chips, okay? And then away from them solves being a GI, then now you have elevated the discussion even to the industrial level, whereby now there is already a market that is going to the off-taker of these potatoes. You agree on the prices, you even agree on benefits that are beyond monetary, that are going to benefit the communities, including establishing the industries in the place, including setting up of other forms of infrastructure and the like. So in the end, the community gets itself lifted from the poor community it has been to a better community. There are many cases that may not necessarily fall directly as GI, but that could follow the same route. You will know about the case of Hoodia, from the genetic resources discussion and access to genetic resources and benefit sharing, how the communities of the Sanis are now benefiting from the producers of Hoodia away from just monetary benefits. So the custodians, the producers of these particular products, the communities where these products are coming from would directly benefit through those various non-monetary benefits. I thank you.
Okay, thank you very much, Joseph. This one goes to the both of you. Just very quickly, what are the pros and cons of GI ownership in the hands of producers on one hand, or in the hands of the state or an administering public body on the other? Or are there pros and cons, in your opinion? Which one has greater pros? Which one has greater cons, without going too much in the details for purposes of saving time?
To start with, of course, this is again a hard question for especially one that is not doing the production, or the one that is going to benefit as a government. But as an independent person standing on the side, I would say that the best way would be the producers or the custodians of that particular product forming their own group and own and manage their GI. Of course, that means that they must have strong leadership to make sure that they enforce it amongst themselves up to the dot to meet the standards, but also to ensure that whoever that is, part of the GI system is able to do things as per the code of practice. But of course, that comes with also some little challenges. One, in the event of breach by one of the members, probably one of the only solutions you have is to eject that particular member. But probably if it was in the hands of government, government could have a better hand of enforcement. But that also does not mean that the producers cannot work with the government to see that some of the infringement is enforced. That is one. Then two, when it is entirely owned by the producers or custodians, they're able to, you're carrying it there, it is your own. So investment would not be a challenge, and effective management would not be of a challenge. When it is on the government side, you risk having no one being responsible, and then it can easily probably be misappropriated along the way, or farmers feel excluded and they are not, or producers and feel maybe they are not part of the whole system and the whole system now collapses.
Okay, thank you.
Edwin?
Just to save time, I'll just respond to one thing. Of course, it's new. Like we said, it's new. We don't have much experience with it, but definitely the pros are good. Like we said, it's group marketing, niche marketing, get better value. You don't have to go for processing. You're talking about adding value through an intangible asset, and it involves a number of stakeholders. The downside of it is that because it involves many stakeholders, again, there's potential conflict, misunderstanding, like we've spoken about, who owns it, the corporate personality, and then returns. For example, if you registered the backcloth successfully, and let us say Mercedes-Benz, as it is doing now, is using the backcloth. I'm not sure whether it's from Uganda or the one from Honduras, because the other communities that have it, and they are making returns, perhaps under a benefit sharing agreement. I don't know whether we know it very well, but under the law, the CBD, the Nagoya Protocol, you would have to access some of these resources through a benefit sharing agreement and give them the money, just like the Hoodia plant was done. This was a plant in South Africa that was what do you call that? The Khoisan. The Khoisan used to eat because it would kill their appetite and they would move for long distances in the desert. One research organization in UK took it up, developed a weight loss making medicine out of it, and there was a battle. With time, they did a benefit sharing agreement. So the question is, who'd take that money? Where would it go? How would it be distributed? The communities, the beneficiaries. There are quite a number of issues, but again, since it's something for the future, our job is to set it up, thanks to USB. The practitioners who are registering these things, and we encourage those to do it, and we shall handle the problems as they come. For now, yes, for now we're learning, and we just need to set this up. Just like copyright, at one time we didn't know we'd have copyright disputes, and it's interesting handling them in court.
Okay, thank you very much. I will now quickly move into the plenary session. There are already 2 questions in the chat that I have seen. For those who are in the room, you'll put up your hand and someone will bring the microphone to you. But remember, only state your favorite potential GI, your name, and your question. So I think I will start by reading out the questions in the chat, and then we can get to the questions in the room. So Esther Kavinga is asking about how the proceeds of commercialization are distributed or managed. I think that has already been touched upon, but she asked something interesting towards the end. If there is infringement of some sort, who is entitled to file a suit from that community? So you have a registered GI. I think the assumption here is that it's owned by a community. Who is entitled to file a suit for infringement? Just to add to that, make it a little more comprehensive, you might have a situation where a particular producer has a trademark and there's some infringement on their product using their trademark is an entry point, but ultimately it's an infringement on the geographical indication, just to add to her question. So disputes in this area, who has the right to sue, and yeah. The other question was in the chat box, not in the Q&A. Why can't I see it? Oh, there's another question. Oh yes, from, I cannot quite get the name. It says TCL, and their question is, how do we register geographical indications at URSB in light of the online system? Is the process manual? Are there any peculiar considerations or domestic standardization requirements for foreign GIs? That's a couple of questions. So basically the question is to do with, is the registration process manual or online? And then are there any peculiar considerations or domestic standardization requirements for foreign GIs? I think you can answer those and then we'll go into the questions from the room.
Yeah, thank you so much for the comments and questions that have come through. I'm happy that in the room there is the commissioner at URSB and assistant commissioner here. They will answer that last part of the registration process, whether manual, they are in the house. One, on the aspect of trademark versus GI, we need to agree from here and make it clear that there is no conflict between the trademark and the GI from the starting point. Secondly, you can have even more than one trademark benefiting from the GI, meaning that you could have your own standards as a community put together, but then your different groups that are under that GI system. So you may have your different trademarks, but marketing your products under that GI. So you have, say, just giving examples, you have Bukonzo, organic. I'm not saying that that should be the trademark, but that is their trademark. But then they're using Mountain of the Moon mark of a GI. Then you have another group that is under the GI system, again having their own trademark, but also marketing their coffee as a GI. But meeting in the same area, meeting the same standards. Now, if there is any other entity that is going to use the GI, the GI mark, or even a trademark that is trying to depict that area, when they are not coming from that area, or even when they are coming from that area, they are not within the GI mapped zone, and they are not meeting the standards, that now becomes an infringement on the GI owners or that community, that entity that would have led the registration of that particular GI. And that the onus would be on that entity to take it up with the registration entities and enforcement entities to see that that infringement is handled. There is indeed, for me, I continue referring to that.
Okay.
An issue where there is misrepresentation of an area and you have it as your trademark. Indeed, like I said, we have examples even in the room. But some of these could have come before the GI was, the GI system was put in place. I imagine if a trademark like this, came before the registrar at a time when the GI system was in place, I am sure they wouldn't have probably registered it as a trademark, because there is some little bit of confusion, but also free riding on an area that you're not representing. Then on the issue of if there is a conflict, who should take it up? Like I said, there are two layers. If the conflict is from within, so the organization or the entity or the membership should have mechanisms of managing conflicts within and how they would manage the conflicts that would have escalated. If it is infringement that is coming from outside an external entity that is misrepresenting itself or falsifying the origin, then you take it up as the owners with the entities that are responsible, like URSB and other enforcement agencies. I thank you.
Okay, thank you very much. Are there any questions in the room?
Okay, thank you. My name is Anthony Kakoza. I just have a few comments, then one question. I think it will mainly go to Joseph. First of all, the comments relating to understanding really what GI protects. There can be a confusion in terms of products out of nature, and probably Joseph will remember we were at a workshop in Cape Town last year where there was heavy criticism as to whether GIs should be protected when they're entirely products coming from nature. Should we grab a fish from the Nile and say this is the Nile perch, it only comes from the river Nile, let's give it GI protection? No, because let's remember that GI is intellectual property, and intellectual property is creativity of the mind. So GI protection goes to the man-made input into a natural product to enhance its quality, so as to say that this is a unique product from a particular area of origin. So anything that is closest to nature, even I was looking up some examples, there's some pork from Italy called Alto Adige pork, but it's because of the unique taste coming from the smoking of this pork and air carrying that gives it GI protection. So even if you go into our Ankole cattle or any of our products here, the protection will come from that extra man-made input to give it GI protection. So that's one comment. The other goes into, should we protect where? I noticed there was a challenge or a risk that came from the slides, one of the last slides that Joseph was talking about, erratic weather patterns due to climate change. Now, if you connect that, for instance, with what Edwin was saying, that part of what makes the Ankole cattle unique is their breeding ground. What if, due to climate change, the weather pattern affects the soil texture? Then the products come out tasting different. That can affect the quality of how we test them. So we need to think about whether this protection can be sustained due to when we have all these challenges of climate change due to soil texture and the like. As Edwin had mentioned, I've been involved with trying to get bar cloth protected in Uganda. First of all, approaching the Buganda administration, getting approval from the Katikiro's office, then going on to the specific clan heads. So the Ota clan or the Ngonge clan has its administrative head, the Katikiro. I approached him with a colleague. We sat down and explained how we would need to work with them to get the bar cloth protected. And that's where the stalemate came in, because they claim that the Ngonge clan is a legal entity. They have not produced any proof to this effect, but they say that they wanted to be the ones having their name on that application document to apply for the GI, not the Buganda Kingdom as an administrative position. That's where the stalemate came in. So that's affecting going forward in terms of getting this GI protected, but we're trying to find a way out of that. Thank you.
Thank you. Edwin, do you have any comments on that?
Yes, definitely.
Maybe I could ask. Okay.
Definitely, ownership is a very,
Please
very
go
big
ahead.
issue. Like on my side, getting the Ankole people together has also been a very big problem. Like I told you, you have Ankole cow, but it's known by the same names in Busongora area, which is Kasese and definitely out of Ankole, and also known by the same name in Nakaseke, Nakasongola, that cattle corridor, even as far as northern Uganda, but it's out of Ankole. So if you want to register it, are you going to leave these people out? For us, we opted for a breeding society where everybody can be a member. We thought an appellation of origin would be possible, but my reading of the Act doesn't give much meaning to the appellation of origin. It seems to be very much a European thing. And then secondly, the communities, turning them into corporate bodies is also very difficult because it's strange. It's alien to any community. Like he has pointed out, the Nkonge clan, indeed, in their culture and custom, they could be operating as a separate entity, and they believe that's a corporate body. But if you put it into legal terms, it doesn't sell, yet that's the best option. So those are some of the challenges we are facing now. Back to you, Stella.
All right. As we see if there's any other question in the room, can the fishing style qualify as extra man-made input? For example, small things, the fact that the cattle keepers, are the ones who determine, so the cows should eat from here and there. Is that sufficient to amount to extra man-made input for qualification for it?
So it's rather interesting, and I think that debate is going to continue until we clear, because the moment you say geographical indication is a form of intellectual property, and time immemorial we've known that intellectual property is creation of human mind. And when you're describing GI, there is little or nothing that is coming close to creation of mind, then contradictions start. But if we continue towing the line of the economy and say we are talking about the economic value, this value that is in the product is influencing the market. And the market is in one way or the other facing probably unfair competition of sorts. So consumers and the producers need to be protected. That becomes now a good line to tow. Though, now the question will be, so why can't you do a trademark and you go full blast on the market and promote your product as a good product, not necessarily tying it to the origin. But again, for me, I keep saying that that discussion should not be coming from our side in Uganda or in Africa, from Africa, because we should be the biggest beneficiaries of this system. So we need to just tap into it and utilize it because it is more into our favor. But that indeed, drawing distinctions, because if you also asked me now for my own honest opinion as an IP personnel, I will say that we should be targeting the derivative products instead of targeting the primary product that is benefiting from nature. Because the derived product is the one that has some level of intellectual contribution. A shabwe, the form in way of making it can qualify probably because there is some intellectual contribution in that. The way the shabwe has now come out as a product, or the ruombo, or the products of shea and the likes, but not the cow itself, not the potato itself, and but like I've said, that shouldn't be coming from us. Let's use it use it the way it is because it benefits us. Now, lastly, on the issue of erratic conditions, it's true, environment is changing. It's very true that even products are changing. But now what we need to look at in characterization of these products, we need to emphasize on dominant unique characteristics, not the micro characteristics that can easily change. So we focus on the dominant characteristics that are exhibited in that product, not the micro ones that can be influenced by slight changes in soil formation, slight changes in temperature, slight changes in the rain patterns, and then the product entirely changes. Yeah, thank you.
Thank you very much. I'm tempted to carry that discussion on a little bit, but for purposes of time, I'll leave it at that. Is there another question in the room?
Yes, there is. Good afternoon.
There is, eh?
Yes, there is.
Okay.
Good afternoon once again. Thank you so much, Joseph and Edwin. Your presentation was very insightful. My name is Jamina Apio. I am a managing partner at Jade Advocates, and I'm very interested in intellectual property. Regarding your discussion and your presentation on geographical indications, I have just a couple of questions that I would like some clarification on. I'll start with ownership. In your experience, have you faced a situation where you have had challenges with identifying the proper collective teams or groups that would take on ownership of the GI? Let me give an example to shed some more light on that. You mentioned earlier, obviously, that GIs are collectively owned, and the norm right now is mainly to have associations or some type of society or community groups to come together to own the GIs. However, have you faced disputes where there is no harmony between the collective groups that for all intents and purposes should be able to own and utilize the GI that you are intending to register? Say, for example, the Ankole cattle that you're talking about right now, you've mentioned that it has its breeding area, which extends far to Kasese as well as other parts of the western region of Uganda. But how do you find yourself making sure that every single person or stakeholder, producer, or farmer, cattle farmer, is able to participate and take on ownership? If, let's say, you have two different associations, who then will be the one to apply to get ownership of the GI? And if there's a situation of dispute or oppositions between the two, how can you come together to make sure that they can collectively agree and benefit jointly from the ownership of the GI? My second question goes down to, I think I'll touch on
Thank you,
one.
Jamina.
Yes, I do have two other questions, if I can just finish all of them, and then maybe they can handle all of them at the same time.
Please make them brief.
Sure thing.
Kindly.
The second question, I want to touch on what Dr. Kakoza had spoken about regarding creations of the mind when it comes to geographical indications. In your presentation, it seems as though most of the GIs are looking at geographical indications with respect to agricultural products per se. Let's say things that come from the soil that none of us have actually we have not produced them. Things that come from the sea, like, let's say, fish, and of course the cattle, which none of us are producing cattle anyway. But if you're looking at creations of the mind and you're looking at GIs being an IP, then at what point are those characteristics supposed to be meshed together to actually identify something as a GI or not? Very quickly, I'll just try to give an example. I know that in Japan, there is the Wagyu beef. And the main characteristic of the Wagyu beef is usually about the marbling of the meat, how it renders fat a lot easier, making it extremely moist. What would be the characteristic we're looking at, specifically with regard to the Ankole cattle that you're talking about, Edwin? And in that regard, my colleague Norman had raised an interesting question saying, in Uganda, you have the Ankole cattle, but it's not the only one that has the longhorns in Uganda. It's all over the country. You can find it in Karamoja, very many other places in the north. So how do you draw the line to say that this is Ankole cattle versus Karamoja? And how do you make sure that you do not find yourself in a pickle when another group of people in another area have the exact same kind of cattle that you're claiming ownership for?
Excuse me. Maybe to just add something to what Jamina has said, maybe I will leave it to Doctor. This is a reaction to Doctor's comments. We're talking about GIs and some addition in terms of creativity, because that's what IP anyway is, that we have to create. And I think that has been the confusion. Maybe you'll take us further now that at a technical level so that we can advise, because I was looking at Norman Zandi's here, which, by the way, I'm not going to return because we already passed the lunch hour. But I was looking at the Ndizi and so many other things. Of course, I know there is indication of source, the made in Uganda, which is also part of the GI category. But when you look at this, the organics and where it's coming from, I really, because I was looking at bananas in particular, so I want to market them to the European Union, but we say that they come from a certain region, they are non-acidic, and then they are also organic, they grow by themselves, by the weather, and so on and so forth. So in that category of plants, I'm just wondering where the creativity would come, so that maybe this can qualify for a GI, or if then we do not add anything to nature's own manufacturing of this product, then does it fall below what might require for a GI? Thank you.
Okay. Another question? Of course, we're way past lunchtime, but I'll be very brief. Ownership. Jamina and Novat. We have discussed this very extensively, I think. It's been hard getting people together. You'll try with other communities, it's definitely going to be hard. But like Professor has said, the guys from Nkonge clan are saying, no, we can't have this. But I have read the law and we can clearly see that the purpose of bringing back these traditional kingdoms was to protect culture. And the Kabaka of Uganda is a corporate body. There's actually even a good judgment, you can read it. Someone sued Kabaka of Toro, Justice Patema declared and ruled that the Kabaka or the traditional cultural institution that is created is a corporate body. There's also the famous case of Justice Katusi with Best Kemgisa over administration of estates. You must distinguish between the king as a corporate body and the personal estate of the person who holds the office. So that is a legal argument. Now, explaining this to people who have had customs and traditions, I don't see them buying it. On our side, we have been able to go around it because the lead agency we're using is NAGRIC. Its role is to conserve and protect genetic resources, animal genetic resources, so fish, cattle, goat, chicken, and not fish. Fish is the work of NAFLI, and then what else? Chicken, goat, cows, livestock generally. Under that very same act, they provide for breeding societies. Now, breeding society for purposes of conservation. And they've been working with those communities. They have a ranch two ranches in Ankole. They have a ranch in northern Uganda, because it's not limited to Ankole cow. There are also other indigenous animals in various places. So I earlier told you that they have the ex situ and the in situ. Ex situ is within communities. Now those communities know, and that is traditional knowledge on how a genetic resource is reproduced. And if you went to those communities, they will tell you that this particular family, this clan has this kind of what? Breed. So they are trying to do it within the laboratory and reproduce. However, like I told you, without research and development, those attributes are difficult. However, I can tell you, for example, one of the products we're looking at is the horn. The moment it leaves that area, it turns brown. Do we have research on why it does so? No. Like you said, the issue is characterization. When you speak to a scientist, they talk about genetic characterization. So in their interaction with communities, they have seen this, but they just need the research to put it into scientific terms. If you went there, it's just a very small place somewhere in Tebe. There is a laboratory. Yeah, all they need is to go and say this chromosome, this. If you remember your biology very well, can reproduce this. So, for example, I think the most famous farm is that of the president. He got it from his father, and the father got it from the other father. You know the background. But if you go to his herd, it's very different from someone in Kiruhura. So, if you want to reproduce that, you now have to go to the laboratory and preserve it for generations. As it is now, it is just there. If his children do not reproduce it the way he does, and that people are losing that custom, you won't get the right one. And it's definitely different from the one in Nakaseke, because they are the same people. I think because of land, they have moved in different places. Secondly, like I told you, the ecological conditions, if you look at the act, it actually talks about attributes, characteristics as a result of the ecological conditions. The ecological conditions of Ankole are very different from, say, northern Uganda or east or wherever. And I think the defining factor is the two rainfall seasons. But like Professor has said, and I've seen this in coffee, I think the world, the Rwenzori area is heated up by one degree, right? So it is changing indeed. If even the snow that we studied about, and for those of you who have gone up to the Rwenzori area, has reduced by, I think, 1 centimeter. So yes, the ecological conditions are the ones that determine, but this is strictly scientific. It's not like, say, a trademark which is out of creativity and you describe it. It's more like patents. One peculiar patent I'll tell you that I found very interesting. We register patents and have the abstract. It's called the Janzi. Yes, I see Mr. Charles Batambuze here. The Janzi is owned by James Wachiyanga. He's an artist with the Janzi band. So when he came to us, he had what he called the Janzi with 22 strings. Because he plays the Adungo local instruments, his problem was that you'd have to put it on a mic to amplify. So he came up with an innovation where you'd actually direct it through a speaker, and he had to change the strings so that it can amplify. And if you see, you try and Google everywhere. When we applied to USB, they sent it to Zimbabwe for examination. While there, the report we got, fortunately, this gentleman was there, the former examiner is now in Ginger. I forget his name, Chige. And they found it very interesting. There were only 2 instruments from Egypt and Tunisia. So they got engineers, sound engineers, to test it. And they looked at the abstract. And it turned out that indeed it was novel. So they gave us a utility model. Understand? So these things are very scientific. You just need to work with the community and the scientists. That's why I was talking about budgets for us to do it. So again, just to conclude, sorry I got into it, the peculiar attributes, we must be able to work with government, we must work with universities for that R&D. Without R&D, I don't think we'll have this. Maybe just to mention one thing, yes, geographic indications are not limited to agricultural products. It just so happens that's what we are working on for the moment, but handicrafts indeed are available. That's why we're having this kind of thing so that people can look at the different, but they must have peculiar attributes, just like you have cashmere rug, and then there's also baskets in Kenya, Tangeta, sorry? Okay. Tighter. Yeah, the tighter baskets. Yeah, so these things are available. And the beauty with the GI, why for me I love it, is that this is IP for Africa. Almost 80 to 90% of our IP is foreign. But here, this is something that you generate from here and you can actually register in other countries. Yeah. So back to you.
Okay, thank you very much for that elaborate explanation. There were questions that were left unanswered, but for this one, I'll just go with a yes or no so that we wrap it up and people go for lunch. So the first one is, are there peculiar considerations or domestic standardization requirements for NGOs? Is there a difference in the standardization? I really just need a yes or no. And then the other one is the registration process, manual or online? Just a yes or no. Further detail can.
To the first one, I would say it's a no. All standards should be the same and should apply. The choice of protecting a GI of Kenya in Uganda would be based on the market. In the house.
Okay, I wasn't here for GIs, but I can answer that. Yes, it is manual. You fill in your Form 20 and then you submit it to the registry.
Okay, looks like the moderator is.
Has gone for lunch.
Okay, colleagues, we can have a lunch break. Sorry, we're really overshot in our time. Can we restrict this to 45 minutes lunch and then come back? And we will continue for the last session after our 45-minute break. Thank you.
Okay, I don't know whether we are set to resume. So we can use some time. We shall not go beyond 5. Online participants, can we connect with them now and find out if they are there? Thank you. ULS, we are ready to start our session. Is that fine? How can we know whether the online, we have some people online there? Okay, so I think that's good enough. All right, welcome back to this afternoon session of our today event. This is the first day, and we are having our last session, which is, which is a review of the Copyright and Neighboring Rights Bill 2025. Maybe just to give you a background about this bill, the process of amending this bill started about 2 years ago. We had the Copyright and Neighboring Rights Act 2006, and obviously, and actually it was a law of 2006. And by 2023, it was felt that this act had lived its time, and there was need for reform. And therefore, so many things had happened in the market, and it was felt that Uganda was out of the market scope. You remember that also ARIPO gave us a model law, one that we should go by. So there were certain aspects of copyright that were introduced in that law. We also have about 3 treaties of WIPO that were made post 2006. So there was also need to incorporate those treaties. And therefore, the state agents, including the private member, decided that we should have an amendment and have a new copyright act, or an act that is actually improving what was existing. So that's this amendment. It's and currently it's amending the Copyright and Neighboring Rights Act Cap 222. Okay. My name is Kalibala Nyanja Philip, and I'm the moderator. We are going to have our discussion is going to be held as such. Mr. Mbabazi Norman from Mbabazi Chiboneka Company Advocates is going to take us through this paper and give us an overview of the salient features of the amendment. And then we shall have Mr. Charles Batambuze from NCF, and also the CEO of Uganda Reproductions Rights Organization. He's also with us on the panel. And we shall have, we are honored to have with us the Commissioner Copyright, Mrs. Nabatanzi Miriam. She will also, she has also graced our panel. She will take on some questions which are coming from the side of the regulator. And then this one I will take leave of ULS to say that we shall introduce, in our presence we have the heavyweight, that is Dr. Anthony Kakoza, and his doctorate is not just in any other subject; it's a PhD in copyright. So, and Dr. Kakoza is a consultant for WIPO. So we thought that since Honorable Chiaga is not with us here, ULS can allow us really to have him. We can't go without having his word and comment on this bill. That would be unfortunate. We are really honored to have him here, so that we can also take his comments. All right, without wasting much time, let me allow Norman to take us through the salient features of this bill, and then thereafter we shall ask our members of the panel to give some comments on what was made. Thank you, Norman. You have the floor.
Good afternoon. We are back late. We had a longer lunch than we should have. So my role is to have a review of the Copyright and Neighboring Rights Bill 2025. But briefly, normally when there's an amendment, the most important bit is what is the amendment intending to cure, what mischief or what societal problem exists that needs to be managed. Before the 2023, before the bill came up, there were a couple of concerns from the film stakeholders, among other people, specifically the businessmen, the publishers, and I think one of the other issues was, could have been the Kaseu Kira issue about the very many contracts that he had from the Kadongo Kamu guys, and he held on to them. He was no longer producing or improving the music as it had been, but then he held them. They had been sold all the rights in perpetuity, so they couldn't utilize them. At the same time, though the songs were being performed on radio and television, he himself, by the way, he was not receiving the royalties, unfortunately. So those were part of the issues that led to. We also had a situation of the ringtone, the callback ringtone, where the artists felt. I think there was one who made $1 billion shillings and only received 200 million. One song from Ankole. So all those things, existed, but also the musicians felt that they needed to start. They had thought of a way to develop the music industry or the creative industry, and that was through the way they thought they would raise funds through the private copying levy. So among those agitated the state, together with Mr. Chiaga, who introduced a private members bill, and then eventually the state took it up and they made the first the draft. Also important to note is that the 2006 Act is more musical leaning, because the people who pushed for the reform from the other Copyright Act previously of 1964 were basically they were musicians, the likes of Mr. James Wasula, among others. This act took 16 years to come to light. And of course, after the death of Kafumbe Mukasa, it stalled a bit, but anyhow, in 2006, the act came up, but like I would say, it was more musical leaning. And to date, we are trying to dilute the musical aspects in the Copyright Act as it is today. Even when you look at, you'll observe some features which are still more onto the musical side, but we are hoping through amendments, maybe this one and another will fairly achieve a creative sector act which is not leaning on one side or another. So among the highlights, we will observe there are provisions for accessibility of works for the visually impaired. That is after we domesticate the Marrakesh Treaty. And of course, I say this in hindsight, is that there's looming pressure across the world to have the inclusion of persons with disabilities to access books, works, and all these other things that help them in their education and reading, among other things. So among the things that will appear in fair use, you will find that online schooling for people who are visually impaired, this will form part of it. Then we have the call ringback tone. There is now a specific law discussing how the percentage sharing will occur, how much does the owner of the song get, the aggregator, and the telecom, who we believe is the arranger of this business. Of course, there is also technology protection measures, whereby they are putting penalties and trying to curb people who are using technology to circumvent infringement. For example, I think you've heard there's been a lot of works being done by DSTV, whereby so many people have been having some sort specific small things, gadgets, whatsoever, to circumvent how they get football, movies, among other things. So this particular amendment is supposed to take care of that. It brings the penalty, it also brings imprisonment and also compensation of the entity which has been making losses. There is also introduction of the orphaned works. These are works without owners, so if you intend to exploit such works, the minister has power to make licensing available to you and how you will be able to license utilize that work. Originally, in the proposal as was done by Mr. Chiaga Hillary, he had intended that copyright extension be moved from 50 to 70, much as it didn't come through. But I captured it because it formed part of the original draft, whereas it doesn't appear in this current one. I just wanted you to know there were some issues which the artist had opted for, but they didn't make it to life. But we still maintain our 50 years. The Act introduces the equitable remuneration of works for every use. The amendment, rather. So in the previous Act, we had a single equitable remuneration. But now, the artists are saying, someone gives you some small money, but whenever there is an opportunity, for example, if I took over the song of Fire Bongole Lutaya, the one Alone and Frightened, every year when there is an HIV campaign, I will use it. But remember, I gave him one off. So, and also the people in the art industry, the guys in the drawings. So the works are being reused over time. So it's called the visual arts, not, but there's that. Yeah, there's the resale right. Yes. So they are now bringing back this, but also it creates two parties whom ought to be remunerated equitably. That is the performer and the producer. So it goes on to create those two variations for every use. For every use. It also intends to introduce the quasi-judicial powers of a registrar of copyright in terms of settling disputes and matters relating to copyright. It also, the amendment intends to increase the currency points of infringement to 2,500. Yes. Yeah. This right here, it's in section 12 of the Act. But now they're expanding it further and broader. Yes, the currency points are being increased to 2,500, and the imprisonment, formerly I think it was 2 years, now it's going to be 10 years, 7 and 10 years for infringement of copyright. It also creates a new regime of how collecting societies will be registered. It is doing away with the requirement of 30 people having a company, then the NGO certificate. All those are coming to an end if the amendment passes. Then it also introduces a blanket license for collecting societies. They can collect on your behalf even if you are not a member. So, because previously in enforcement of copyright, we used to have issues because IP or intellectual property is a private right. So if you don't complain, no one else should complain because you are the owner of the work. Now, the amendment intends to introduce something that even if you don't complain, but your work is being infringed upon, the society and the registrar can commence infringement cases on your behalf. Now, this particular section is supposed to solve works that are found in Uganda which infringe copyright, but it's not easy to get the owners to come here and make a complaint. We've experienced that in the film industry, for example. A couple of movies, and so many movies are on TV, but we don't know whether they have the copyright agreements to broadcast. And these very many pirated movies are eating on the space of the local content, yet we cannot fight them at the same time. So this particular amendment targets to solve that problem, among others. We also see the extension, the extension of reciprocal protection, but also domesticating further international treaties like the Marrakesh, the Beijing, the Bern, which were not in the Act previously. There is also restriction of reproduction of reprographic rights up to 5%. So if you are reproducing a book or literary works, you're only capped to 5% of that particular work. So the education institutions won't rely on fair use anymore if they are doing that sort of reproduction, especially at the printers and all that. So it's restricted to 5%. We also see the ringtone share has been done, and you're good? Okay. The amendment also intends to carry the disputes from the registrar from commercial to high court. Previously, all intellectual property or copyright matters were directed to go to the commercial court, but now that has been opened and they can go to the high court generally, not only the commercial court. The amendment also intends to create another, which I think forms part of the technology circumvention, but also to create takedown notices, and the registrar has powers to take down copyright infringing material, and in certain circumstances where you have lodged a complaint and you'd want that material to be taken off the internet or wherever it is, probably at the broadcast house, as long as you can prove ownership. Of course, it also stipulates that contracts have to be in writing. Contracts to deal with copyright have to be in writing. It was formally in the old Act, but now the amendment creates a situation: if you don't do the registration within 60 days, then the contract is voidable. It also creates the reversionary right, that most of these assignments and publishing contracts that the creatives give to the other people to make business will only last 20 years. 20 years, and thereafter, 20 years, they will revert back to the author or the copyright owner. And also, the amendment caters for costs that the copyright inspector used when some material was taken away from a suspected, because the amendment introduces suspected copyright infringing material. If the inspector suspects, then he will come and inspect and seize. But all the costs involved in that kind of arrangement will be borne by the person upon conviction. It says convicted. Yeah, so those are the key salient features in the amendment, which we didn't have, but if they happen in this bill, they would have created a different order in the copyright regime and the creative sector. I also saw something to do with folklore. I had chosen not to speak about it because I think it shouldn't be in the Copyright Act. I think it should be, there's the Ministry of Gender, Culture, and the youth have these policies somewhere about traditional knowledge, folklore, among other things. I thought folklore belongs there. I didn't think it creates copyright. Whereas they talk about those that arise from the folklore, which I think fall either in music, film, dance, they fall somewhere. So by having folklore identical, or rather individually in the Copyright Act, I didn't think it was right. Though I also make some of my, should I give my contradictions now or later?
You would have the floor to give your opinion now, but allow me to maybe, because you're going to remain on my panel, yes. Even if you are the presenter of the overview, you will still, you will still make some responses. And then I hope that in those responses, then you'll have a right to give your opinion. So we need to make a separation of the salient features and then what you're going to, your views on
the views are on the salient features. I wanted to make a distinction because some are already still in the Act. There are some sections in the Act, but then there's an amendment.
All right.
So I wanted to...
It is fine. We shall get to that. Okay. Let me just thank you for being quite right on point. Your presentation has been, it has been precise. It has been quite precise, and it has identified the areas that are coming in, the new areas that are coming in to create a new order in the creative sector landscape. We know that we need this regulation because our country is a young country. Largely, creativity is still in the informal sector. So we need to be very supportive and welcome of the interventions that are being done by the state to see that we also benefit from art. Because we are told that we are sitting on a multi-million-dollar industry or sector or activities, and that one I think Doctor can testify. So we think that these interventions will help us realize some of those fruits. So we need to support the efforts. But let me, I think, start with Norman. Allow me, I'm excited to have my panel here. Quite a heavy panel, very informed people. You had me introducing them at the beginning. So, and I can tell you, our people, that copyright is quite interesting, unlike any other IP. Although it has it has its own approach, but it's quite interesting. Norman, let me start with you. This one, the question I'm putting to you, which is actually the starting point of our discussion here, is apart from what you've presented. It's not really so much in line with what you presented. It has nothing so much to do with the amendment, but it's a general question that will help us out. Copyright is known to be one of the most complex intellectual properties, and actually the broadest and probably the most technical. Why? Because it's almost everywhere. Everything can be copyright, and so you almost cannot create one line pursuing it because it's really scattered. It all has different things have different characters. We've been facing, from the ULS point of view and our cluster, we've been looking at the way society has approached copyright or IP. We've been reading the judgments, and sometimes we feel like maybe the judgments have fallen short of this subject because of its technicalities. There are some of our colleagues here online. We can see that we are at 51. We have dropped from 71. They are there following us, and which is a good thing. Maybe can you tell us how lawyers can pick interest in particularly copyright? So if someone is a lawyer and they are going to engage a client on this subject of copyright, what should the lawyer look out for? How should the lawyer be relevant to a client
without a lawyer really feeling that this subject is out of field, you know, I'm being bothered because my client has come, how do lawyers develop interest in copyright practice?
Well, for me, I think the most important aspect when you are a lawyer and you're dealing with the creative sector, because basically the copyright is more embedded within the creative sector, is to consider whoever it is that is before you as business. It doesn't. Why we have we have challenges in the creative sector, mainly film, music, art, and drama, is that the approach is that these guys are comedians, or these guys are entertainers, these guys are simply there to make you happy. But this is business. Once you understand that in the drama guy before you is business, then you pick interest in how to approach a copyright issue. Either way, it has to make money, and the only way it makes money is to understand how you, because it's a threefold. There will be innovation, which is the creative. Then there will be the protection, which is the law. Then there will be the commercialization, which is me, the lawyer now, and the artist. So once you understand the threefold of creativity, that someone has to create, someone has to protect, and then I have to make money from the two. I combine the two, then copyright definitely will become business to you. So for every musician you see on TV, think about him or her as business. For any comedian, for anything that's even happening on TikTok, anything happening on Instagram, whatever you see as content can either make or take away your money in one way or another, because that's the only way you can understand copyright.
Okay, thank you, Norman. And I hope our colleagues on the other side virtually, you've picked up some points there. Because the practitioners of copyright and the experts, we are really frustrated that the lawyers are not picking up the subjects of IP. We need a critical mass of lawyers in order to make the system move. So just develop interest. It's quite complex. Yes, you need to be trained, but I think working with the ULS, we can interest you. We can interest you. Thank you for that response, Norman. Maybe let me go straight to Doctor. There was something that you mentioned while you are discussing these new entries, and certain aspects of the bill seem to be introducing things which are also tinkering on the principle of things. Okay, the way things should be done. So the bill seems to be making some radical shifts. I hope not, and maybe as a society we need to also to be ready for that new eventuality, how we are going to change. One of the things that the bill has talked about, I think in one of the clauses, 43, it was talking about amending section 80, 8 of Cap 22, of 222, saying that the treaties of WIPO shall be law, where they can be enforced, they will have the force of law, the treaties of WIPO. Now, reading into this and my understanding from a legal point of view, I get the feeling that what they are saying is, I can look at the treaty, read something from the treaty, and then eventually get a cause of action from the treaty without necessarily going into the Copyright Act, and then I just go to court and I argue that out. That's my understanding, but I want to put that to Doctor. He's well versed in that. That is your field. He will tell us whether that is what the law means, and whether if that's what the law means, that's a good approach, or we would have an alternative of approaching this, Doctor. Thank you. It's to you.
Okay, thank you, Philip. Yes, this specific provision, the proposed section 80A, which says international treaties to have force of law in Uganda, appears to imply that the law as it is, say the Berne Convention or the WIPO internet treaties, will be automatically applied in Uganda. Why that is problematic is that Uganda follows what they call a dualism international law system, in the sense that when we sign and ratify an international treaty, we have to take it through the stages of domesticating it, placing specific provisions into Ugandan legislation, go through the whole parliamentary process of different readings, and then it becomes law. But this here seems to overstep that and follow what they call monism system, which is direct application of the international law. That's something that Kenya does, but Uganda does not do. So it's not really in line with the Judicature Act, which talks about laws applied in Uganda, and we would have to find a way of harmonizing this to avoid this inconsistency.
Thank you, Dr. Koza, with that. And especially also, my observation is that the way these treaties are structured, they are structured to kind of guide the member states to adopt some provisions of the treaty so that they can put in their domestic law. And that's why I'm finding, I want to find how actually the practice of it, how the courts are going to receive when it finally becomes law, that I can go and sue on the Marrakesh directly as Ugandan, as principal municipality law here. And then I see how it would, it would work out. All right. Thank you, Doctor, for that. And our next question is going to go to Madam Commissioner. Madam Commissioner, by the way, we thank you. We thank you for taking up that office, and we also, in the same aspect, we thank URSB. I think having a fully fledged copyright office is something that Uncle Bata and Carlos should clap about, because now the officer who is regulating you is next to you directly. You don't have to go through corners, and which is a good thing. And I think it's an achievement. It's an achievement to the fraternity of copyright. Madam Commissioner, the bill is introducing quasi-judicial powers of the registrar. The quasi-judicial powers of the registrar. And URSB has, because URSB is the regulator in charge of copyright, it has retained this, it has expanded on this function of a kind of dispute resolution and adjudication from the company registry. We have that, and then of course in the IP with trademarks, which I think have been handled well. I think if that is jurisprudence, even if it's administrative, it has been handled well. The judgments, the rulings are good, and we've been discussing them on our ULS, and we think that they have a level of satisfaction, they are quality judgments. So, Madam Commissioner, it's to you. You are also being given that power, and it seems that the scope is quite wide. You are going to do contracts, you are going to do disputes, disputes as per ownership, for ownership, and then you are also going to do issues, I think, to do with registration, whether Bata had the right to register that or no. Just tell us briefly, really, how you are set for this function, and generally whether this is actually a better approach than the direct route going to the court, whether at a technical level this will be helpful to the creatives. Thank you.
Thank you very much, Philip. Good afternoon to our physical and online audience. I bring you greetings from the Registrar of Copyright. So back to your question, as URSB, we are fully prepared to handle the quasi-judicial function that will be vested in us by virtue of the amendment. The spirit for having the quasi-judicial function really was to try and decongest the courts, but also to offer a cost-effective solution for many of our clients. Litigation can be lengthy and it can be very costly, but more importantly, the people who are handling the copyright function are specialists. That's all they do, copyright registration and advisory services. So with the experience, we believe they are better placed to handle those disputes. And then you can still go to the High Court on appeal. In terms of staffing, it's now a fully fledged department. It was carved out of the Intellectual Property Department. In terms of manpower, there's 23 persons. So we do have the capacity to handle the function. Now, some of the disputes we are going to be handling, that's not to say that in the previous law or in the current law, CAP 222, we have not been performing that role. If you look at the process of objecting to applications for registration of copyrights and neighboring rights, parties have been filing their objections with URSB. You state your grounds for contesting a registration, and then you have an officer who's going to determine that matter based on the evidence you adduce. Like you've rightly said, some of the disputes, the bill is broadening the scope. We are now going to be looking at contracts, the exploitation in the contracts, the clauses in particular, because there's been a feeling that some parties are taken advantage of. So where someone comes forward and they feel the terms in there are unfavorable, we should be able to preside over those disputes. Previously also in CAP 222, you would find that simple matters that required arbitration, particularly the disputes between CMOs, members and their CMO, they all have to be referred to the arbitrator under the Arbitration and Conciliation Act. That is also not a cheap process, because by default you end up going on trial and then it's diverted for arbitration, and you still need to incur some costs, and it's lengthy. So as a bureau, we are prepared to shorten the process because we are more staffed in number, but we are also better skilled to be able to take on the function. There are also other things that come with that function, like Norman rightly put it, we also have the enforcement arm. So even the directives that are going to be given by URSB, we are also in position to enforce them. He mentioned the technological protection measures that have been put in place. When you look at the bill, the registrar has been empowered to issue notices to service providers. These are the guys who bring us the works using online platforms. So you can write to the service provider and ask them to take down or to block certain content on their web, on their platform. And if they are defiant, or for one reason or the other they do not comply, then it becomes criminal in nature. And URSB, currently we are performing a delegated prosecutorial function on behalf of the DPP, meaning we have a legal team that has been given power to prosecute some of the copyright piracy cases. But when you look at the bill, URSB has been authorized to enforce the law, which means we can actually come after the people who have been defiant. I know you told me not to take a long time, but yeah, I'll also go on to say that the spirit really was, because the copyright disputes, many of them are not complex in nature. Yeah, so instead of having all these matters sit in court, we feel it is better that they be diverted to URSB for efficient and effective dispute resolution. Thank you.
Thank you for that elaborate one, but you would have gone ahead. It's your floor. I think you are the Mugole of the day. We are all looking at you. But you've mentioned certain things that I want you again to comment about before you switch off that microphone. The first one is I did not see an appeal process after in the quasi-judicial provisions. I don't know, I looked through, maybe I wasn't critical, because that is, I think, a gap that we need to address, other than leaving it to the practitioners to just assume that you will maybe, is it the intention that it will stop at that once the registrar or the commissioner settles the dispute, so the parties then can go and effect such a ruling? That is one issue. The other one is what you talked about, the online enforcement. So there are people who have been reading this bill. They have been reading this bill, the experts there in copyright, and they were saying that when they read through the bill, it's as if the impression that is created there is that unless you've registered your IP, you are not entitled to that enforcement online
if you actually read that provision. It's saying that unless you've registered your IP with the registrar, you might not get the advantages of takedown and then the disruptions and things like those. Now, maybe this one to you, Madam Commissioner, and also to Professor, that how does this balance then? Does it go around? Is it a turnaround now to tell people that you need to go and register your IP, being copyright, in the consideration that formalities are not required for the subject? I'll start with you, Madam Commissioner, maybe to address us on those two issues.
Thank you very much, Philip. To answer the first question, appeals from the registrar lie with the High Court. That is clause 13.4. So if, is it 12? Yes, sorry, 12.4.
Right.
So if you're aggrieved by a decision of the registrar, you still have redress in the High Court. Then the other issue on takedown notices, yes, it is true. To benefit from that enforcement mechanism, you need to avail us with a certificate of registration, because we need to satisfy ourselves that indeed you, as the complainant, you actually own the copyright in the content that you would want us to take down, because we also don't want to be countersued for bringing down content which later turns out not to belong to you. Yes, thank you.
I think actually that response is quite good rationale. It's quite good rationale, but I'm going to give it to the academics of Doctor and also the expert in the principles of copyright to advise whether we shall get away, whether Uganda as a jurisdiction will get away with in a way making rights holders register their copyright. Doctor, over to you.
Thank you, Philip. Just for emphasis, this does not remove the fact that copyright is still something given informally. The whole informal process that you get copyright by fixation of your work in a medium, that is still the principle. We picked that from the Berne Convention, we still have it in the law. But we're going further to appreciate the fact that with takedown situations, these are very technical and they're very cagey, that when we were discussing these provisions and proposing to put them in the bill, we studied some cases, mainly the US, then we think of very few from the UK and other places where people have been suing YouTube because YouTube was very quick to take down when someone was complaining that, hey, that's my song playing or that's my work, without really verifying ownership from the person who was making the complaint. So it's really vital that whoever makes this complaint has to bring in the proof that here's proof that I have the certificate. But just to jump the gun a little bit, tomorrow when I'll be talking about the Bruno K case, it's exactly the same situation. Bruno Chigundu sued Black Market Records because they used to go to YouTube and say, take down this Basson song, it's our music or it's our copyright, when it wasn't really the case. But if they had followed what we are talking about here, for YouTube to say, okay, before you tell me to take down this music, can you prove that it's actually yours? Then that would have been a proper system to follow. So that's the ill that is being addressed here.
I love the way you two experts have argued it. I really love the way you've argued it purposefully. It's for a purpose. And I hope our judicial system, not to prejudice anything from the bench, have picked up that from these experts, because we are saying that it's true, you can argue the principle that with copyright you require no formalities. That is something that we will recite all the time in presenting papers. But I think what these two experts are saying, that the circumstances are calling on us to look at it differently, because proof of ownership now is being critical, especially with online consumption. So maybe that might require the doing something in the ban. Yes, doing something in the ban so that the union states can adopt that. But I think from what you've given, that is quite a good rationale. Okay, thank you so much for that. I think now we are well informed why registration should be done. This one is going to Uncle Butter, called Uncle Butter, Mr. Batamze Charles, Vice President NCF and CEO Euro. Euro is a collecting management organization.
And Mr. Batamze is so passionate and has been involved in his, what you could say, copyright or IP activism. And he's not going to stop. From the last time I was with him, I saw that the figure is still high. We thank you for that. Mr. Batamze, there is, you're going to take a couple of questions in one because you've been silent for long. We have they call them the collar ring back tones. They can call them all kinds of names, coloring back tones, this and that, but they are defined well in the Act, and I will not go into the definition. Now, there is a coloring back tones. There are percentages, the issue of percentages, and there is PCL. I know PCL was not necessarily brought in the bill, but it is really related so much to this. Maybe you will start just briefly by telling us why PCL does not appear here. Yes, we are not bringing things, we are not importing things in the bill, and we are not informing Parliament, but it is somehow associated with this. You tell us why PCL never, why did you fail to make an argument before the policymakers that PCL should go? And then you should tell us about the issue of percentages for the ringback tones. The percentages were given. I think the creatives have 60, but some experts in markets and economics have been saying that, look here, why are you interfering with market play? Why are you saying that? Because everything will depend so much on the investor. Is that playing to the advantage of the creatives, or actually the creatives are being disadvantaged by the percentages? To you, Uncle Bata.
Thank you so much, and thank you, Law Society, for inviting me. Very interesting about the coloring back tune debate, or CRBTs, as we call them. And very interesting what you have said, that the investors, in other words, you are thinking about the telecoms, forgetting that the musician is also an investor.
Thank you for that correction, sir.
Yes, the musician invests in creating the music that eventually becomes a caller tune. And there is no caller tune that is not a popular song. So by the time a song becomes a caller tune, it's already popular. The musician has invested in creating it, in making it popular. And it's unfair, the current system, where the musician reaps peanuts at the end of it all. Because the current system, according to our research, the government takes 50% of the 700 shillings in taxes and whatever. That's okay. But the thing that hurts us is the fact that people keep on saying musicians are asking for money and they don't contribute to taxes. You see, in 2019, government the CRBT's collections were about 68 billion. Half of that is what government took. And if that is not contribution to the tax base, then what is it? But anyway, that aside, so the artist has been taking 1.8% of the 700 shillings, which is about 12 shillings. And that is grossly unfair for somebody who invested in creating and somebody who invested in promoting the work until it becomes a coloring back tune. The process of CRBTs within Uganda, it is so opaque. Actually, it is difficult to know how much your song has made because the platforms, the telecoms, and all the other people involved in that whole value chain are not willing to disclose the money that is being made. I know we actually went to Parliament last year, I think, to talk about this issue of coloring back tunes. And the telecoms were invited to also come. They didn't come. They are so powerful that they can even defy the big organs of government that we know of in our country. The second arm of government. Now, people with such power, imagine a poor artist from Mitiana sitting on the same table to negotiate a contract with such a powerful person who cannot even come after they have been summoned to come to Parliament. So what has been happening is these contracts are, there are templates already there. So when you go, they'll give you and you sign. There's no space for negotiation. Eh? So in our advocacy, we said that it is important that the law protects the weak. And in this case, the weak is the artist. Eh? These artists, many of them cannot afford lawyers, and there are no lawyers doing pro bono contracts for artists. Eh? Maybe that would be a good way of really empowering the industry. So we asked that the law should protect the weak by defining the revenue share from CRBTs. Eh? That's why in that provision, and we're so happy that the government listened, that this was important. Eh? So in that that clause, the share in favor of the artists is 60%. Then the rest take the rest of the percentages. To me, I believe this is a very empowering provision for the artists, and we are likely to see more innovation because we understand that copyright is an incentive for creativity. And if people have been struggling to find money to reinvest back into their businesses, through the CRBTs, they'll be able to gain more and therefore be able to feel better about their investment. Maybe in the future, I keep on saying that in the future, lawyers and whatever that parents will be happy to encourage their children to become musicians because there is money. Then on the issue of private copy levy, by the way, we have now changed it to private copy remuneration. because whenever you talk about a levy, you attract negativity only. Yes, but this is it, that the way we create, consume, and disseminate content has changed. In the past, you would go to a video library to buy a VHS tape, attend or buy or hire, rent for 10,000 shillings. Nowadays, if you want a movie and you go downtown Kampala, you can get a movie at 200 shillings. And this is a movie that cost 50 million to make. You can see the extremes, 50 million to make, but you are selling at 200 shillings to each user. So to make 1 million shillings, you need to sell how many times? So many. So this is all because it has become so easy with the availability of gadgets within the market. Now for music, for example, downtown Kampala, lawyers I know don't pass there, but for us, we pass there. And this is what we hear. They will say, flash ya mutwalo, music wa werere. So you can see the devaluing of creative content to the extent that now music is for free, but a flash disk is 10,000. So who is gaining from all these transactions? It's not the creatives. It is the people that supply the gadgets. Whereas the creative industry is going down, the gadgets are going up. And we know that trade in gadgets cannot thrive if we don't have the content. Or what will happen is eventually when all of us give up on the trade of creating music, films, TikTok, drama, and books, and so on, then the country will depend on foreign productions. So then our cultures will be, we will have a problem of foreign cultures within our country. So given that background, but also let me say this, that recently when Johnny Kazora passed on, this is what happened. All of a sudden, his book became famous, and it was distributed on almost every smartphone, free of charge, full text. And so in Uganda, according to data, there are about 20 million smartphones. And on the day that the book was moving around the country, those that were online, probably 15 million smartphones received Kazora's book for free. Now, Kazora's estate did not benefit from that transaction, but somebody gained, and that is the telecom, because the telecom sold data for uploading, for sharing, for opening the content. So the telecom becomes the biggest taxpayer and is appreciated For us, the artists and the writers, when we say, we're also contributing to economic growth and so on, they said, no, we don't see you. So we have been telling government that actually we are the drivers of change in these other industries. For instance, the telecoms. The telecoms sell data. And what do we use that data for? Part of it is for streaming, part of it is for downloading things and so on, creative content generally. So because of the fact that the way, the patterns we consume content has changed, it's important that people benefit, the creatives benefit from these private uses of created content via gadgets, that the people sharing our music, our movies, our books on WhatsApp contribute something, that gadget, actually the issue is about the gadget, and we're looking at the capacity to store and also the capacity to share. We're not looking at the habit of the person using the gadget, because some people have argued, but for me, I'll buy my phone, and I'll never use it for those things. No, but your phone has capacity to store, and it has capacity to. So we have been agitating that in addition to the CRBT revenue share, the other empowering clause in this bill would be private copy remuneration or private copy levy, a percentage of money that would be collected on each and every gadget on importation into the country, or if it is manufactured within Uganda at the factory. And that money would be collected, say, by the Uganda Revenue Authority. It will be managed by the commissioner here in her office, and then she would distribute part of it to the collecting societies so that we can distribute to the creative industry. And this is the math, that in 2019, the value of trade in gadgets was up to 78 billion Uganda shillings. I believe at this time, in 2025, it is even much higher. And you can see the impact of what 78 billion would do to the creative industry. This whole cry, there is no money, we don't have money and whatever, this whole cry about capital for the creative industry would all be solved just by one reform. And we would like to appeal, because the fight is still on. We are still hoping that we'll go to Parliament and make a case for inclusion of a private copy levy in the bill.
Thank you, Uncle Bata. Passionate as usual. But at least one thing that we pick up from that, that the PCL army is not sleeping. It has refused to sleep, so it has reinvented the name. So you call it PCR? Hopefully that this time that will go through reinventing. That's quite creative. So we say that the PCL is still on, and we thank you, and we also thank you for that elaborate for you as an industry player. You are the one, the person in the field on the ground, as opposed to these lawyers. They might look at it differently, but you are the one in the field. The question that is coming on, I want it to go to Roman. Norman. I think, Norman, you've rested enough, but it's both yours. It's both yours and Doctor. Maybe both of you are going to give us your view on this, and the practitioners there can hear this, to know that this is where we are going. The property character of copyright. So the bill is introducing reversionary character to copyright. Now, someone might make a case and say, now, if we look at what we call copyright now, are we doing away with assignment, and maybe now the issue would be licensing, because we might not use the word assignment with the word with limitation in time. Assignment, you give me the property is mine, and in as far as copyright is concerned, I can exploit the economic interest in this property until I also pass it on. I also use it for collateral, everything, and then I pass it on as part of my estate. But now we have reversion. Maybe from Norman, starting with you, where is this coming from? And where is reversion? Well, and also the other thing is that, are we in tandem with global practices in as far as copyright property is concerned?
The principle of reversion is as old as 1678. It's not new. It's either it's either statutory or contractual. The people who've used it justify the redundancy of rights, specifically in works, that you may not be able to exploit a work for example, in America it is 35 years. Within 35 years, that work shall be or is outdated. And there's new work. If you're looking at Uganda, you may find that every other day there's a new song that pops up. Has its time shelf line, then it goes away and another one comes in. So the reversionary aspect is that after 20 years, the work automatically reverts back to the owner. I had a conversation with the commissioner out there, and she said for her, her interpretation is subject to the assignment. Of course, I don't think license should have been there because license is specified. It has time, assignment and transfer. It should not exceed, should not exceed 20 years. In her opinion, she thought, unless it has not been specified, then the reversionary law takes place. I don't agree, but that is our interpretation. So the same way you'd look at it in terms of land, because IP is a personal right. How I choose to deal with my land or my music is best known to me. If I choose to sell off, then how does it revert back? That's another issue. It's a good concept. The concept is good. Because in America, I think they have reversion and termination. One of the two takes, but I think they usually use the termination. After 35 years, work goes back the other side. There's been lots of litigation. I think in South Africa, they presented the same, and the president refused to sign it because the businessmen refused. It has two things. You have to be sure what you're dealing with. Either you're going to protect the artist, or you're going to have some shortfalls in business, because some investors may not necessarily want to come and invest where they are going to hold work, not in perpetuity. They want to have catalogs for family. They build businesses for family. They want to have, because as of now, whoever has Michael Jackson's catalog is thinking about very soon the reversionary right may kick in. Those who have the Teddy pedigrees and the guys who are singing in the 1980s, whose music many of us grew up listening to.
Dan Mugula.
Yeah, all those guys. So that creates a situation of you want to protect the industry, absolutely right. But is it good for business? That's the other thing to think about. Similarly, if you look at one of the amendments they are bringing in, is that if you do not register the assignment or transfer within 60 days, the contract is voidable. But when I buy, I obtain equitable interest. So are you saying a technical aspect of registration extinguishes my equitable interest? Doesn't that affect the constitutional right to own property in one way or another? Similarly, it also offends another section, I think 46, which says a holder of an assignment may register the assignment deed, or in part, I think in section 2, they go on to talk about the right. You may choose to register the right. I understand the importance of having a copyright register. I understand there shall be a lot of fraud in terms of selling one song unknown to the other buys and all those kinds of things. But there's freedom of contract. And there's something to do with rights. I have bought this thing. I own it. If I buy, if for example, I buy 100 movies, each at $1 million shillings, which is 100 million, and then registration requires maybe 50,000 to do the registration, which I don't have at the time. 60 days later, do I lose my right in those movies? And is it fair anyway? So those two things, you have to find a balance between protecting the industry, but also making it valuable for business. Like I told you, copyright is business. Entertainment is business, you know? So if you don't protect the businessman, they may not invest. Or if they invest, they are cagey, 1 foot in, 1 foot out. Then they don't do good work. So, and if you want the industry to develop, you have to balance both rights to make sure those investing and those in the creative are able to benefit. I thought they would be more geared towards protecting against infringement than the collaboration between the user and the purchaser, or the creator and the purchaser. Because our biggest problem coming now as a practitioner and a beneficiary in the creative sector, our biggest problem, by the way, may not necessarily be infringement, but is paying for work. The public performance licenses in the matatus, in the taxis, in the hotels, clubs, and all these other events are not paying. Why? There is the law is there, but the way you have done maybe for ringtone, you should have come up with a very strict way to manage hotels. Sorry, fairway, I'm here, but I'm just saying. To manage hotels, to manage radios, TV stations, and all these other guys who are communicating this work to the public. In fact, if I were Mr. Batambuze, instead of going for flash disks, I would go for cars. I would go for buses, because those are the guys who actually communicate to the public. And they should be the ones giving you enough money, because their licenses are broader in terms of seating capacity, how much people sit in your vehicle. Those are the guys who should be able to develop the industry. Similarly, when an event is supposed to happen, for example, a performance, and there is work to be communicated to the public, that's where the target should be. Because, like you said, the art is the driver of almost all this economy. If you calculated how much beer is consumed at a show, if you calculated how many clothes are bought when there is a show happening, women can attest every event is a new outfit. All right? Every event, new outfit. Then you have all these liquors being sold. Then you have all these other guys who have friends and girlfriends and everybody to call Ubers and everything. They are functional on a day when there's an event. So I think the amendment should focus more on where the money is going to come from, because that's what the artists want. No artist wants to make work and it's not viewed or it's not performed, but can they get money from the performance? That should be the question.
Thank you, Norman. Doctor, I'm going to give you, of course it's coming back to you, but I'm going to twist the question, the same subject. Maybe I'm going to call on you, LS, to inform us if we have some people online, because I will calculate our time. We shall be strictly within the finishing time, but I need to know. You'll need to inform me whether we have some hands online and they want to make comments here, but also the in-house attendees. There are questions? Okay, so at least I'll put you in mind. I'm going to spare you some time. Yes, I'll also spare some time. So I'm going to keep you in mind, but let me take it to Doctor. The same question, Norman seems to be thinking that it's going to affect especially people who will buy property. And I will agree with him unless, of course, a contrary view comes up, because we need to remember that IP is a commercial system. It's a model for economics. And even when we are creative, when we don't creativity is not an end in itself. We need to use it, and we need to attract capital to invest in the creativity and also do whatever it is with it, and so on and so forth. So for him, he feels that maybe reverting works is a bit limited. Maybe someone has not recouped their investment and so on and so forth. Doctor, what do you think? Where is the rationale coming from to actually, and maybe you will inform us whether it's peculiar to Uganda, the reformists decided to bring that, or they are getting it from somewhere. Thank you.
Thank you very much for this opportunity. Okay, so I want to look at it from two different scenarios, not scenarios. These are actual events that happened. One is in South Africa. I take you back to the 1950s, a young man by the name of Solomon Linda. Solomon Linda was a member of the Zulu community in South Africa, and he used to look after cows, cattle. And he would hum this song to himself all the time, a song called Mumbe, which is basically The Lion Sleeps. And his part-time was cleaning as a janitor in a music studio. Were somehow interested, the owners of this music studio, and they pick interest in this song, and they allow him and his colleagues to, record this song in studio. So it's a folklore from the Zulu community, which later on went to studio and produced a song called Mumbe. Mumbe became quite popular during apartheid South Africa in the 50s, and somehow finds its way in Europe, specifically in Sweden. It goes on to so many other places. Long story short, hundreds of versions of this song are made, but because in Europe they could not pronounce the word Mumbe, it's I can't even remember the spelling, they started saying Wimowe, and eventually it was saying Wimowe or Wimowe. It goes on to finally Walt Disney Corporation, and they use The Lion Sleeps Tonight as a soundtrack to the Lion King movie. And when the Lion King movie came out, I think around 1991, between 1991 and 1994, Solomon Linda was long dead. He died a very poor man with probably just about $5 to his pocket. But his family were there and were still living in poverty. So Lion King is soon to be released. It's in Walt Disney Corporation, have an office in South Africa. They're also going to release the movie there. And Solomon Linda's family go to a lawyer called Dean, Dr. Dean, and say, we need to stop this misappropriation of our late father's song. They were not looking at the folklore version owned by the Zulu community, but they were looking at the studio version of Mumbe, which their father had taken to studio. And Dr. Dean looked into a specific clause that had hardly been used in South African copyright law on reversion of rights, and said, let's use that. That since Linda had passed on copyright in his poverty mentality and without any understanding of copyright law, but his family are really entitled to the benefits of this song that was done by him. So that's what happened. They filed an injunction to stop this movie from being released and use that as pressure to negotiate down the Walt Disney Corporation in South Africa to agree on a royalty payment to the Linda family. So to this day, between $6,000 and $10,000 are paid, which in South Africa is quite a lot of money to this family as royalty every year out of The Lion Sleeps Tonight. Now, that's one situation where reversionary rights have kind of worked out very well that we can use by having this insertion of Section 13A. The other is here in Uganda, a story that was shared by Judith Bavire. I think she's now somewhere in Canada. Talked about a time when she was negotiating one of her songs with a certain corporation here in Uganda. And because she was really in need of the money, they gave her 5 million shillings for her song and went on to renegotiate that song with MTN, and MTN made hundreds of millions for her song through coloring back tunes and the rest. So that's the crux of this situation, that you have someone who comes with a number of factors, lack of awareness of copyright situations or a desperate or vulnerable situation, and you end up negotiating a contract just because you want some bread to take home at the end of the day. But years later, you're better informed, you're in a better position, and you feel that I wish I could take back what I sold for a cup of soup. And there you have the reversion. So we put it at a timeline which in many other jurisdictions, South Africa has it, US, of course, as you heard from Norman, has it, and a number of other jurisdictions, that you can have a reversion after a 20-year period, which is fair enough, because if we're saying copyright for an individual runs from the life plus 50 years after, then 20 years of reversion is really sufficient. Now, I also want to speak into the second thing that Norman talked about, and we had this conversation with him at the side about a contract or assignment or license having to be registered with the registrar within 60 days, otherwise it's considered voidable. That specific clause is not on the reversion bit. It's specifically looking at having to register an assignment or a license with the registrar. And the basis behind this is you're looking at situations where the licensor has given or the person has assigned his copyright to an entity, and the entity is not going further to, articulate it or to implement it. And then other bidders are coming in and you're wondering, what are they doing? So this is kind of like to push them to show commitment. Let's go ahead now, we've entered this deal, let's register it with the registrar. That's one point. The other is, me, the licensor or the assigner, I may give you MTN this deal, and then go behind your back, as people do either when we land matters, and find another one and enter the same deal with them. So whoever has gone to register and has already gotten this contract registered has title in a way that protects them legally against such fraudulent or unethical practices. So those are the things I needed to give clarity to.
Interesting. Madam Commissioner, you want to make a comment on that? Now, this is the way I'm going to do it. Since I want to open up to the gallery, and actually I was coming to you because you seem to be so comfortable, and enjoying the show of these practitioners responding. But the next question is coming. So we are going to make a comment on the reversion, but also there is a question, there is something that was given to your office. There was, the registrar was given powers and the CMO at the same time. Both the registrar and the CMO were given powers. There is an aspect of prosecuting. So I'm not going to put myself out of that picture. I'm going to be very much part of it because we've been trying copyright enforcement and prosecution, and we were never in tandem with the DPP. The ODPP says that unless Schwarzenegger comes here to testify, you cannot. You are not the right parties to be here. Okay. So Mr. Batamze and his inspectors go out there. They grab someone using Donald Trump's "How to Be a Millionaire" or whoever is out there, and they say, "Okay, we are going to prosecute you for copyright infringement." Okay. But the ODPP is saying, where is Trump? Where is Trump here? Because he's supposed to come and give testimony here since it's his works that are being infringed. That one was in district, okay, with all due respect to the office of the ODPP, we thought it was in disregard to section 80 or 79 of Cap 220, which say that since we are members of some conventions, where also these authors are members, so we had the right to anyway clean the market. Sorry, in as far as copyright infringement is concerned. The DPP wanted precision. What authority do you have to prosecute on behalf of Schwarzenegger? So, the wording of the bill has changed. It's saying, regardless of whether the aggrieved party is there or not, still the CMO and URSB or the registrar has a right to prosecute. Now, Madam Commissioner, you were formerly in enforcement. Tell us whether this adds advantage to the whole enforcement aspect of copyright, whether really this is now going to convince the ODPP in saying that you will have a right to prosecute on behalf of Schwarzenegger or Donald Trump.
Thank you, Philip. Before I delve into that question, I just wanted to clarify on the issue of
get close to the mic.
Registration. Registration that had been mentioned by Norman. You find that there is no contradiction between the Act and the bill. The registration referred to in Cap 222, it's talking about registration of the right. That's voluntary. And we are in tandem with the Berne Convention. The registration that we are referring to in the bill is the registration of the document that may be creating the right. So there is no contradiction whatsoever. The registration here is optional. Here you have a choice to register it within 60 days. Otherwise, the contract is going to be avoided or rescinded by one of the parties. That's all we are saying. Okay, so to get back to your
Thank you for the clarity.
Okay. To get back to your question on prosecution, yes, we've encountered challenges trying to prosecute cases of foreign rights holders because we all know that the best witness for that case is going to be the complainant themselves, the rights holder, because they know their content better. If on my own volition I decided to prosecute, I don't have a witness. So what this means, and for one reason or the other, maybe they may not want to descend onto the Ugandan market. They find the market too small and all that. But it has a trickle-down effect because you'll find that our Ugandan artists are not put on the same leveled ground with the foreign artists. What am I saying? You'll find a lot of foreign works being dumped on the market, and you find our local content being shelved because it turns out to be more expensive. For them, they want to gain from their creativity, but there's someone else whose work we are consuming, but they are not interested in enforcing their rights, so you end up undercutting the Ugandan on price. That's not the spirit of copyright, but we are saying we should all enforce these rights, provided the works belong to members of contracting states of the treaties. Now, in practical terms, the bill is allowing the registrar on her own volition to institute a case without a complainant. Okay? It doesn't take away the mandate of the DPP to sanction the charges, but they are only saying the registrar can prosecute the matter without having someone to come to Uganda and say, look here, I'm Schwarzenegger, I've seen my Terminator being played in the video libraries. If I know it's infringing, how will I know it's infringing? I will ask you to avail me with your authorization, or I will call the CMO that manages the rights of those foreign artists, be they musicians, be they film actors, performers, producers, name it. So we will approach them, and then they'll say, you know what, I gave a blanket license to a certain library to broadcast the works of my members or the foreign societies I represent. So if we come to you, the burden of proving that you have permission to play lies with you, the user. And that's all I need. If you do not adduce evidence that you have been authorized to broadcast those works in your spaces, then I can be able to take you on for infringement. So that is what the bill is trying to usher in. And the good thing, the cost of that enforcement, if you're convicted, Norman has already said it, the cost is going to be transferred to the convicted party. So the money that we have been expending to investigate, to seize, to destroy all these items, and it's not cheap, by the way, that cost is going to be transferred to the convict. So for us, it is a strong provision that we feel will deter people from playing works without authorization. And then I also wanted to emphasize something on the penalties. He mentioned the enforcement in taxis and all that. We believe the penalties that have been proposed are kind of deterrent in nature because we are making it risky business to do it, for you to engage in piracy. I want to believe that you'll think twice before you plagiarize someone's book, before you air someone's movie, play someone's song without authorization, because the cost of doing that vis-a-vis paying 50 million or going to jail for 10 years, you'll think twice. The current situation today, the punishments are not commensurate to the financial benefit you have derived. I think the maximum term of imprisonment has been 4 years. I've not seen someone go to jail for piracy. And in the alternative, you are fined 2 million. 2 million, Charles, right?
Yes.
Yes, 2 million. And someone has made commercial sales of millions of shillings, let's say 100 million. you'll find that we have repeat offenders, because when you ask them to pay 2 million, they will actually say, wait here, let me go and do the payment, and then I secure freedom. Yes, it's even on mobile money. Then they move to another location. So 50 million vis-a-vis pirating, the flashes he's talking about, I think we should be able to build some respect for copyright once the amendment passes.
Thank you, Madam Commissioner. I have exactly 7 minutes. I think Doctor will allow you to do that, but okay, since you've already...
This provision about prosecuting or enforcing on behalf of an owner even when they haven't asked you to. Ghana does that. The Kenya Copyright Board does that. The Nigeria Copyright Commission does that. So, and they have huge success stories. So with Commissioner Miriam's office, if they do the same thing, we'll have huge success over enforcement of copyright here.
By matter of fact, from the beginning, we thought that's the way it was supposed to be. We thought it was self-evident that actually we were members of the ban, and these were union states, and we had a right. And I think also in our criminal practice, people, interested parties can go to court, even if they are really not the afflicted people. I think we thought that was the case until we found that DPP looked at it very differently, and the law had to be tweaked. But it's a very good principle, because generally no one is supposed to infringe copyright. But
I wanted to give the perspective of the collecting societies, respect to that.
Okay.
You know, we're supposed to license on behalf of our members. The current law, that's what it says. We're supposed to license on behalf of our members. However, the users of works use works of our members as well as from other people that are not our members. And normally when we go to negotiate, for instance, if I'm negotiating with a university, they would want to look at my authorizations. So that register of members to see, do you have even bilaterals with the UK? Because we are using most of the books from the UK. Do you have bilaterals with and who in the UK, which authors are part of that society there? So what this amendment, I like it very much because it is empowering us as the CMOs, because we now represent the works in the market. And for the user, for instance, a university, when they pick a license from Europe, they'll be confident that this license covers them adequately. There will not be any other person coming to claim the university is infringing their copyright. If anybody comes, they'll just say, for us, we paid euro, go to euro. And to me, that is good. Then the second bit about enforcement, we have a problem of, say, pirated Oxford dictionaries in the market. Some of them come from the UK. Most of them nowadays come from China. And I remember when I wrote to URSB to say, can we tackle this issue? Then they said, who represents those people here? Who can stand in court? And there was nobody, because most of the people are just agents, but agents who have now been overpowered. No wonder, because of that, some of the prominent bookshops, for instance, have closed because they cannot compete with the people that are bringing in cheaper versions of the same books. So again, for me, in terms of protecting the industry, protecting the jobs for Ugandans, protecting revenues and income, this is a very, very good proposal.
Thank you, Uncle Bata. I wish the officer from URA stayed with us here, because you discussed something to do with customs and pirated products coming in. I think the books are all over our market, and that's what we were discussing in the morning. But you can see the passion. That is what IP does, and that's what copyright does. But I'm not going to deny the gallery the right to ask a question or two, and then you'll allow us to exceed slightly beyond 5, because their questions have to be heard. So I'm going to ask that the microphone can move. We're going to ask the questions once, and then identify who is going to respond, and then I will leave them to respond. Okay, it will come. I'll ask ULS to allow us for you to ask. Anyone else?
There's a question over there.
Okay, there is a question online. Let's first hear these ones, and then we shall go online.
Thank you very much. The panelists, thank you. Madam Commissioner, it's a pleasure to make your acquaintance. Mine is directed to Dr. Kakoza. I just, on the backdrop of the conversation we had in the morning, I just wanted to know if you're satisfied with the digital regulation, the regulation in the digital space in respect to this bill. And on the same note, emerging technologies. Are you satisfied that this bill takes us 10 years, 15 years into the next, or we are going to have to amend 2 weeks after after passing this new law, we're going to have to amend, or have we made the necessary progress in the digital regulation and emerging technologies space?
Yes, Jamina. You'll wait the panel. We are going to combine all the questions and then you'll go.
Thank you. Good afternoon, everyone. And thank you so much to the panelists. It's been extremely amazing. I just want to ask 3 questions very quickly because of time constraints.
They are going to?
The first question is in respect to the issuance of notices that the registrar has been given powers to provide for in the bill. And it specifically requires for the registration of ownership of the copyright. I would like to hear the views of the panelists in respect to the practicality of this particularly, because if we're looking at our stance being parties to the Berne Convention, where a copyright does not necessarily need to be registered, and yet you're saying for you to get support from a registrar to have a takedown, you must present a certificate of registration. Do you think that's practical? Is there another way this can be done? Can't copyright owners find other ways to prove ownership rather than just having certificates of registration issued? That's the first question. Then the second question is on the issue regarding representation of non-members to CMOs by the CMOs or by the registrar. In an event that you are allowed to prosecute or let's say file a civil case on behalf of an infringement, in respect to an infringement, in the case that damages are granted in a civil court, who takes them? Is that provided for in the bill? Who takes that money? Because at the end of the day, it is the actual owner of the copyright who is supposed to benefit from that particular type of claim. And then my final question is on the issue regarding the reversionary discussion we've been having. I did not hear whether or not, from a business perspective, as Norman had put it, whether or not there's an opportunity for an extension of a contract after a reversionary period has lapsed.
Okay, Council, still I had asked you who you directed those questions to, but you never got to me, so let me leave them. They will pick up. I think they have written something. We have those 4 questions, and then we have a 5th one. This one directly, I think, will go to Madam Commissioner, that in case of fraudulent registration, so someone is, and that is very likely in copyright, maybe wrong registration, someone thinks that they are the owner of the works, because maybe they made they added to the vocals, yet actually the works belong to Carlos and something like that. So in those situations, how is that going to be addressed when you are taking down works in case registration in case of fraud? Maybe ULS will allow us one last comment from a person from the sector, from the creative sector, to just to add to our debate. Carlos, you want to make a comment just to the lawyers? And then we wind up, we leave it to the...
Thank you. Thank you, ULS. Thank you, Kalibala. My name is Emma Carlos. I'm a talent manager and an arts administrator. I've been in the business of music management for the last 20 years. You can Google me. Well, my comment is about PCR and then what Uncle Norman said. Uncle Norman, you're right about the cars, the taxis, and all other people who consume our products. However, when it comes to PCR vis-a-vis those people, it's about the months, the cost of collecting from them, and then the amount you're collecting. So it's very easier, it's cost effective for PCR, and the amounts we get from PCR. So we need them, but we're giving this priority. Then two, about PCR, why government, we got information why cabinet didn't warm up to PCR. First of all, there are three issues. One, the first one was that, is it being practiced elsewhere? Or are these creative guys creating something new for Uganda? So it's everywhere, at least around East Africa and Southern Africa. And then the other issue was about being in contravention with the other government program of telecom, handset penetration within the industry. For us, our argument is people buy phones. People buy phones like, let me say, from iPhone 14 to 15 to one, enhance production of their content and then also consume content. So they don't buy phones to get agricultural apps to buy pesticides, for farmers. So that's our argument. And then last, on a very hopeful note, recently during the coffee marathon, I happened to meet, this is to give open to the creatives there watching this workshop, that I personally met the speaker, and we had a chit chat, deputy speaker, and it was like, government actually misunderstood the concept of PCR. Let the sector do a well-researched document. He will make sure that he chairs the second reading or the debate of the corporate and amendment bill. So that gives us hope. So Parliament, when they are from recess, we are well prepared with our documents and statistics, and we shall move our case. Thank you very much. I think I just wanted to make those notes. Thank you.
Thank you, Carlos, from the creative sector. I will be the last person to speak, but I'm going to do the round, starting with Council Norman, through to Uncle Butter, then Madam Commissioner, then Doctor. Everyone is going to take just a minute, so we shall take 4 minutes. We make responses and then final remarks, and then we can do. Maybe, Norman, you can also give your opinions in that closing remark of yours. Thank you.
For me, wholesomely looking at the amendment, these other issues can be discussed and harmonized, specifically the contracting, the reversionary. But what comes key for me is the blanket licensing, because having worked with the collective society and also had some experience with people out there, specifically those in the entertainment industry. So I had a chat with someone from the movie sector, MPAA, it's the biggest in the United States. So I asked them, we have a lot of your work here, and you should come and help us patrol it. It's being stolen, lots of movies are being watched. So the guy looked at me and he said that I assumed like I was talking, he was nodding. Then eventually told me, you are aware we have a culture attaché in Uganda? I said, yes. What do you think is the role of the culture attaché? I said, well, to help spread the culture of your country, to fund some activities which help in promoting the culture and all those other things. And he said, now, it said categorically, said, some foolish Ugandans steal our work and give it to the country. The country watches it. They copy our culture. And then, without us spending a penny, they spend their airtime, they download, they watch, they adapt. Naturally, they kill their culture by copying our culture at no cost. In fact, very soon we'll recall the culture attaché, because that person has no job anymore. The Ugandans should actually be our culture attachés. So whereas the Copyright Act is not entirely about managing culture, among other things, but the collective protection of work will help us somehow, one, create market for our local content, because then we will be able to remove the pirated work, but most importantly, preserve our culture. All these things you see, these Gen Zs and I don't know what they call the other people, there's a name for slayers. The things you see them doing, they watch movies, see different clothing styles and all these other things freely without paying a penny. So it is us eroding our own culture. We've tried Media Council. Media Council has not helped in this particular issue because it has failed to prevail over the broadcasters who have these movies being done. And I can understand they are not they don't have the capacity, but we hope this particular provision of the Act will help us manage our cultural protection in that sense. That's why you say copyright is very broad. It captures a lot of things unimaginable, whereas so many people may not understand. But lastly, I pray the ringtone, the callback tone section does not become redundant, like the landlord-tenant Act, where people are increasing rent at 50%, 100%. Money Lenders Act is in existence. People are still lending at 10% per month. So my prayer is, whereas this is coming up, there should be very, very serious regulatory consequences to the telco to observe what would have come in this law. Other than that, it is going to be redundant, like those other sections in the different acts that we have.
Okay, Uncle Bata, you remember the questions that were asked by the gallery? I think you addressed those. You picked them up.
Okay. There was the question of representation of non-members and who benefits from court money awarded by court in terms of damages. For instance, if Euro was the benefit in case Euro was the one, if Euro was the one prosecuting, I think in terms of our representation agreements with the authors, because we represent authors, or we work on the basis of the reciprocal agreements. And if it's a work, say, by Emma Carlos, our member, and we are the ones supporting the court processes and whatever, and money is one, definitely in line with the representation agreement or reciprocal agreements that we have with different parties, that money would have to go to them. Because for us as a society, it should be on my neck. If I'm awarded 1 billion and we spend it at Euro without it benefiting the rights holder, but at least now I'm leaving the burden to her to prove that the regulator, because for us, she will say that money should go to the rights holder. And because of her oversight, we cannot do otherwise. But maybe in terms of the law being specific, but I think maybe that's something that we need to think through and see whether that provision we can add elements such as those. But also don't forget that as a CMO, for instance, we also actually prosecute on behalf of our members. For instance, if a university is refusing to get licensed, we'll go to court over that. And because we are acting on behalf of the members, when we succeed, they also succeed financially.
All right, Madam Commissioner. Thank you, Uncle Bata.
Thank you. So the first question was what happens when someone fraudulently registers another person's IP? I'll restrict myself to copyright during the takedown. If you look at the bill in its current form, we are saying that the minister will make regulations that will prescribe the procedure for blocking or taking down the infringing content. And in there, we can make proposals, maybe as a complaint is being looked at for bringing down infringing content, you can have some injunction of sorts that no further registrations can take place until the matter has been resolved. So those are options that we can look into when the time comes for us to prepare the regulations. There was the issue of the certificate before enforcement. Like we've said, really, we need to strengthen the ownership proof requirements. But coming to the registrar, does not preclude you from seeking redress in the courts of law. If the standard is too high, as provided for here, if providing the certificate is a problem, you will still be open to exercising your options of going to court. But we are saying if you want this particular remedy from URSB, then you're going to have to prove to us that indeed you are the rights holder in that content that you want us to bring down. Because at the end of the day, there will be repercussions if we make an erroneous decision. There was an issue on civil, I think it was compensation, right? Compensation. Yes, compensation, you can get that when you pursue a civil remedy. And they do give compensation where the parties' rights have been infringed upon. I think the challenge with copyright has been proving you need to account for the profits of the accused person, and many a times I think the bookkeeping is not well done and all that, so there are issues of proving how much loss has been occasioned to you as the rights holder. But on the side of prosecution, for us, we are looking at getting the convict punished. So we may not be able to pursue redress as far as compensation is concerned, because the bill is providing for only 2 punishments. You would either have to go to jail or you would have to pay a fine, and that fine is not going to come to you as the rights holder. It's going to end up in the consolidated fund. Yes. Yeah, thank you.
Thank you. Doctor?
Thank you. So yes, interesting question about whether I'm satisfied with the digital regulations in light of merging technologies. I've looked at the ones that I'm really satisfied with to an extent. Technological protection measures is something new here. We've seen it in the Nigerian Copyright Act of 2022, I believe. Kenya has the same, and this is in line with the WIPO treaties of 1996. It's further strengthened by the Beijing Treaty of 2012. So it's really something that we're happy with. People can use TPMs to protect their copyright. Same thing with takedowns. Yes, there may be a few sketchy issues on how to prove ownership. Regulations may take care of that, as Madam Commissioner has said. On the issue of collar ring back tunes, so to the extent that that has a technological aspect to it, I'm not too happy with the straight jacket provision of saying 60% to the authors, 35% to the others. That's really a straight jacket position. The law should have a freedom to contract. And when we were working on this, we were talking about let there be a provision on equitable remuneration, so that in the contractual understanding, the parties then decide how to split this. But then the ones who are opposed to this, mainly from the music industry, were saying we've been bullied far too long. Whenever we tried equitable remuneration, it wasn't working for us, because the big Goliaths, the telecom companies, would be the ones calling the shots. So that's a difficult one to take, but that's where it is. Beyond that, we can't really say the law is sufficient on technology. I mean, we can't predict what the future of technology would be, so it's definitely going to be something that we'll need to revise as and when more technologies come up that are not covered here.
Okay, thank you so much. I think you are witnesses to the passion. Like Shaka Sali always said, time is not our ally, but there is a lot to say. You can see that we are not really yet tired, but time is saying that enough is enough. And with the coming into force of the EPS, maybe they will make it capable of catching latecomers, those who leave the office late, and we pay 800K tickets. Okay. So with that, thank you so much. Madam Commissioner, you surrounded by these gentlemen who have very high capacity. I'm proud of you, gentlemen, who are representing our copyright sector and people in the creative sector. And I want to thank you, LS, for giving us this opportunity, and also for the IP cluster that has organized this. I hope, Brian, you are still online. Thank you so much for making this possible. So we've closed the first day of our engagement. Thank you.